Okay friends, now we'll move to the next section, section 236, acquisition of shares by majority shareholders of minority shareholders. See, please understand, I'll tell you one thing. There is a company X Limited, fine, and then there is another company Y Limited. Even X Limited's majority shareholders, X Limited has acquired Y Limited's majority shares. Again, I'm repeating, X Limited has acquired Y Limited's majority stake. Now, let's say X Limited has 90% or more shares of Y Limited. So, don't you think now X Limited is nothing but 90% shareholder of Y Limited only? And now this 90% shareholders want to acquire shares of remaining minority, that is remaining 10% minority. Can they acquire this? So, answer is yes. But here the language you have to be very careful. Here it is not that X Limited want to acquire shares of Y Limited. What they are saying, 90% or more shareholder want to acquire remaining 10% or less, whatever remaining shareholder shares are there. So, they want to acquire those shares. So, that means, can I say, when 90% or more majority shareholders, sir, why majority? Because now in Y Limited, majority shares are held by X Limited. So, 90% or more majority shareholders may acquire shares of minority shareholder. So, now how you can read it? Y Limited's 90% shareholder, 90% or more shareholder want to acquire the second category, that is less than 10% shareholders. They want to acquire these shares, minority shares. Then at what price they can acquire? So, for that they are saying the price will be determined by, tell me first, the price will be determined by registered valuer. But if it is a listed company, then as you know, listed company is governed by the SEBI regulation. So, it will be governed by SEBI regulation. If it is listed company, for other company they are saying it will be determined by registered valuer. Then what they are saying, that this 90% shareholders, how they will make the payment to this less than 10% shareholders? So, this is majority shareholder would transfer such payment in a separate bank account from which the payment will be made to the minority shares, and this separate bank account shall be maintained for the period of 1 year. See how it happens in real life. Let me explain you. See, this Y Limited will be there. This 90% or more majority shareholder will transfer the money, and this money Y Limited will maintain it in a separate bank account. Fine. Y Limited will maintain this money in a separate bank account, and whenever this less than 10% dissenting shareholder will come, they will make payment, Y Limited will make payment to this less than 10% shareholders from this separate bank account. Now, within how much days they should take the money? So, this is that ideally they should take within 60 days. But if there is a delay, then in maximum 1 year they should take the money. So, if you will see, the normal time limit, it is this thing, 60 days. In 60 days they should take the money. But let's say if what is they saying, they could not take this dissenting, the less than 10% shareholder, if they could not take within 60 days, then they can take money even after 60 days in maximum 1 year. So, the separate bank account shall be maintained for the period of 1 year, and the payment shall be disbursed to the entitled shareholders within 60 days. When following payments are not made within 60 days, then it can be disbursed within 1 year. So, 60 days time limit is just a discretionary nature. This is that the shareholder, if they could not take money within 60 days, then there is no problem. You can still take the money and you can pay it up to 1 year, no problem. Then this is that who will going to work like a transfer agent? Company whose shares are being acquired. So, in my example, Y Limited. If Y Limited will work like a transfer agent. Why they are using the language transfer agent? Because see, this money, 90% or more shareholder have transferred their money to Y Limited, and they have managed this money in separate bank account, and the shares of this less than 10% shareholder, can say, will be transferred by Y Limited to this 90% or more shareholder. So, can you say Y Limited is acting here like a transfer agent, working like a, tell me fast, transfer agent. Now, what if there is a transmission? In case of transmission by way of assignee, a transmission means, let's say, in this less than 10% shareholder, let's say Mr. X is there, he, let's say he die, after his death, can I say his shares will be controlled by his legal heir and money will be given to the legal heir, or if he became insolvent, then assignee will come in the picture. So can I say this is called transmission. In this case, can I say Y Limited will give money to this legal heir, to this assignee, and they can claim it from the Y Limited. But don't you think now this is a situation where legal process will be more, so they may take more time to complete all the procedure, and that's why normally this less than 10% shareholder, at the max they can claim money within 1 year. But if the matter is of transmission, that is by operation of law, that is assignee is there, legal heir is there, so they can claim the money even after 1 year. They can claim up to 3 years. Tell me first what they are saying. They can claim up to 3 years. I hope it is crystal clear to everybody. Now, so this is what they are saying. In case of a transmission by way of assignee, legal heir, administrator, payment can be made within, tell me fast, payment can be made within what? 3 years. I hope it is clear. Let's revise section 236 fast. What they are saying, can I say transfer agent, I mean this company whose shares are being acquired, that is in my example Y Limited, can say they the 90% or more shareholder will acquire the remaining 10% shareholders shares at a price determined by the registered valuer. If it is a listed company, then as per SEBI regulation, then this is the money will be transferred to a separate account by the majority shareholders, and it will be maintained by the company whose shares are being acquired. In my example Y Limited, and the minority shareholder can claim money within 60 days or anytime up to 1 year. So it will be maintained for a year. But if the case is of transmission, then in that case, and the company whose shares are being acquired, that is Y Limited, will act like a transfer agent. And can I say if the case is of transmission, in that case instead of 1 year, money can be claimed up within 3 years as well. So this is a provision. Section 237, amalgamation by central government. Now please understand, till the date, you have whatever you have done, what you have done. Can I say all the amalgamation, section 232 you have studied, that was an amalgamation. Company is doing voluntarily with their wish. Only thing is that NCLT was controlling, because the procedure in 232 is given under section 230. Then 233 was that only, but only thing is that it was a fast track merger controlled by central government. 234, can I say it was when one party is a foreign company, but the procedure what you follow is of 232, that is 230 procedure. Fine. Then in 235 you have studied takeover, means one company is trying to make other company as their subsidiary. Yeah, but don't you think these all are voluntarily? Means company is doing with their wish. Company is doing with their wish. But 237 is a different game. Under 237, central government is making the order and telling the companies that you please amalgamate. Now you will say, sir, why central government will tell to the companies that you amalgamate? How does it will affect to central government? I'll tell you. See, sometimes central government do this in public interest. Please understand one thing. Now let's say there are two companies, X Limited, or let's say I'll give you some real life example. Let's say in Mumbai there is a Adani Electricity, fine, and then there is a Tata Electricity, Adani Power, Tata Power. They are into the production of electricity. Now please understand one thing. This Adani Power, Tata Power, they are working separately. Now I am creating a hypothetical situation. Now let's say there is a problem in Mumbai for power generation of electricity, and there some resources are unutilized and there some resources are unutilized. And if they will come together, there will be more and economical power generation. If this is the situation, now central government will order Adani and Tata to get amalgamate. Now you will say, sir, means central government is forcing them? Yes, central government is forcing them. Sir, what if they don't want to do it? So practically you have no choice. If central government will tell you, you have to. Now it is a forceful, yes, it's like a marriage, forceful arranged marriage. You have to do it whether you like it or not. Are you understanding? So they are saying that central government, if want 2 or more companies to amalgamate, a central government may order this, and in that case those company has to get amalgamated. But why the central government will give this order? In public interest, for the general welfare of the public. Now you please understand, this is what it is given, that if it is in public interest, central government may order 2 or more companies to amalgamate. Please understand, if it is in public interest, central government may order 2 or more companies to amalgamate. Then what will happen? Now let's say there were 2 companies, Adani and Tata, and they formed, let's say, new company ABC or some other name I will take. Adani and Tata Limited got merged and they formed new company Tadani. Sir, what the nonsense? They formed new company Tadani Power, and now they are saying all the rights of the shareholder in Adani Power and all the rights of the shareholder in Tata Power will remain same in the Tadani Power. Means it shall not affect the shareholders' right. Sir, what if it is affecting the shareholders' right? Means the rights of the, see what is written, all the rights of members, creditors, means all the creditors of Adani and Tata, all the shareholders of Adani and Tata shall have same rights in Tadani Power. So the shareholders' right and creditors' right shall not vary. But now somebody will say, sir, what if it varies then? Then what will happen? So this is that if varies means if there is some loss, let's say his right got varied, yeah, or his right got varied, and because of that they are at a they are incurring loss, then obviously they have to give compensation. So if the rights are same, fair enough. If the rights are not same, if the shareholders' right and creditors' right in the old company was more and in the new company it is less, means the shareholder or creditors are at loss. So they are supposed to receive compensation for that. So Tadani Power need to give them compensation. So they are saying that right of all the members and creditors in the new company, that is Tadani, should be same as that of old company. It shall be same. What if it varies? However, in case of vary of rights, if their rights vary, so this is that if varies, then of any members or creditors, then CG may declare compensation. Then CG may order compensation, and when they are not satisfied, with the compensation, then they may file appeal to NCLT. Just now I told you that Tadani Power, let's say shareholders and creditors of Adani Power have less rights in Tadani Power. So now what will happen? Tadani Power will give them compensation for this loss. Now, if they are not happy with this compensation, they can file the appeal to NCLT. Are you understanding? So they can go to NCLT and they can say that, see, our rights have been reduced to so and so extent. According to us, I should get compensation of 50 lakhs, but they have given compensation of 30 lakhs only. So can you please tell them to give me the proper compensation? So like that, appeal can be filed to NCLT. Now this is very important. What is the point they are saying in this? That the order of amalgamation can be passed only after giving opportunity of objection to the amalgamating company for at least 2 years. Means what? You see here what they are saying. Adani Power and Tata Power, these are 2 independent companies. Now central government has given them order to get amalgamated. Now there is a very much possibility that Adani Power and Tata Power are not happy with this. So can they object this? So they are saying that yes, they can object it, and for this they will give objection. They will give time for objection of at least 2 months. To put it in simple language, can I say central government has to give Adani and Tata at least 2 months time to object this amalgamation. Now you will say, sir, what if they object? Whether central government will not going to order amalgamation? Now let me tell you, it is like arranged marriage, whether you object or not. If the parents want you to get married, they will make sure that you get married. So can you say central government want them to get amalgamate? They will get amalgamate. Now you are saying, sir, but in the law it is written that they shall give at least 2 months time to company to make the objection for the amalgamation. Yes, the time is given, and if they will make some objection, central government will try to modify some scheme or something like that. But central government will not say, okay, you are not happy, we will not amalgamate. If central government have thought so, they will definitely get amalgamate. But this objection will help the central government to modify the scheme and to make you comfortable as much as possible. So can I say, order of amalgamation can be passed only after giving opportunity of objection to the amalgamated company. And how much time will be given to object? So this is that at least 2 months time should be given to object. Fine. After amalgamation, order by CG, it should be placed in both houses of parliament. I told you, central government has ordered the amalgamation. So whatever central government will do, don't you think now they will put it in house of parliament? So it will be laid in house of parliament, Lok Sabha and Rajya Sabha. And now, can I say lot of cases must be going against Adani or against Tata? Will it abate? Will it cancel? So answer is no. Any cases which is already going against Adani, any cases which is going against Tata shall continue in the name of Tadani. So cases against the old company shall continue in the name of new company. So section 237 got completed. Mark it important, many times they have asked this in exam. Section 238, registration of offer of scheme involving transfer of shares. I taught you section 235. When I was teaching you section 235, what I told you, that the transferee company will give offer to the shareholders of transferor company, and that offer will be open for 4 months, and within that 4 months period the shareholders of the transferor company will sell their shares to the transferee company. And now don't you think, when shareholder of the transferor company want to sell the shares to the transferee company, shareholders shall know entire details regarding this scheme and everything. So when the shareholder will be having more faith, when the details will be given by the directors of the transferee company or directors of the transferor company. So obviously directors of the transferor company. For example, let's say there is two company, Rakesh Limited and Katrina Limited, or A Limited and B Limited. Look here, A Limited and B Limited. Now please understand, A Limited and B Limited, there are two companies. Now, can I say this is transferee company, this is transferor company. Transferor company has given the offer to the shareholders of B Limited, and the shareholders of B Limited will sell the shares to transferee company. But for this offer, can I say, you have to give details also, details of entire scheme and everything. Now don't you think these details, if it is given by the directors of A Limited, it will not be that faithful for the shareholders of B Limited. But if it is given by the directors of B Limited only, now don't you think shareholders will have more faith in that? So that is why they are saying that any offer or scheme involving transfer of shares in section 235, that scheme is require registration of circular with ROC. See what they are saying, what is circular? It is a statement which contains the relevant information and recommendation made by directors to shareholders of the transferor company. Means what? It means this scheme, the details is called as circular, and in this all the details, in this what will be there? There will be a relevant information and recommendation by the director to the shareholder of transferor company. Means B Limited's board of director will tell to B Limited shareholder that why they should sell the shares to the A Limited. Are you understanding? So sir, you want to say that it is not a hostile takeover? Obviously not a hostile takeover. So can say BOD will tell shareholders why they should sell their shares to A Limited, and this details will be called as circular. Now there is a risk in that. Sir, what is the risk? Can I say BOD, board of directors of B Limited, might take money from the A Limited and may provide them wrong information to the shareholder. So these risk should not be there, and that's why this is a disinformation which the BOD of the transferor company is providing to the shareholders of the transferor company. That is a circular. It shall be registered to the ROC. ROC will see whether all legal compliances have been complied or not. So any offer or scheme which involve transfer of shares under section 235 require registration of circular with ROC and before transfer of shares. Then when you are going to ROC for registration, now it is the choice of ROC whether ROC want to register the company or not. So ROC may reject the registration. ROC may reject the registration, which should be and if they are rejecting the registration, in that case they will communicate this within 30 days. So ROC will tell that we have rejected your registration of circular, we are not finding it appropriate. Sir, in that case, can they appeal? Yes. In that case, company can file appeal against this rejection to NCLT. So I hope it is clear. Shall we proceed? Next. preservation of books of accounts. After amalgamation, this is amalgamating company and this is amalgamated company. So whatever the books of accounts of amalgamating company is there during amalgamation, should it be maintained? Yes, and it will be maintained by amalgamated company. For how much period? They have not given any period. That means it shall be maintained by amalgamated company for lifetime. For lifetime. What if amalgamated company want to destroy these books of accounts? They can do it, but only with the approval of central government, and central government can allow only after investigation of the books of accounts. Only after inspection, not technically investigation, after inspection of books of accounts. Now don't you think it is better not to destroy? Because if you must have done if you would have done any fraud, and if you want to destroy, CG will first do the investigation, inspection of books, and then only they will allow you this. So don't you think it is even more risky? So this is what they are saying. Books and papers of amalgamating company shall be maintained by amalgamated company. For how much period? Lifetime. However, it can be disposed with prior approval of CG. CG can make such order only after investigation of such books and papers. And the last section for compromise and arrangement is section 240. There is a possibility that before amalgamation, some fraud might have done by directors, and those frauds came in the knowledge of the company after amalgamation. So what is the problem? Old company we have closed, now it is a new company. So the director who have done anything wrong before amalgamation, there was a question whether they will be liable for such offense even after amalgamation. Are you understanding? Means something wrong you have done before amalgamation. Now the question is whether you will be liable for such offences even after amalgamation. Obviously, can I say whatever wrong you have already done, you have done. Now it doesn't matter whether company is in existence or not. If you have done anything wrong, and even later on, if government will come to know, if authority will come to know about this fraud, they will punish you. So that is what written in 240. Liability of officer in respect of offences committed prior to merger amalgamation shall be continued even after amalgamation. I hope it is crystal clear to everybody. So finally we have completed amalgamation chapter. I am trying to put it as exhaustive as possible, but as much relevant also, and I am trying to keep good pace, so that you know once it is done, तो तुम्हारा एक बार अच्छे से you will be able to complete it. Fine. So now let us move to the next topic: inspection, inquiry, and investigation. Please understand what they are saying. Inspection, inquiry, and investigation. Now what is this? Please understand. Inspection, inquiry, and investigation. First of all, this inspection and inquiry will be done by registrar and inspector. So it will be done by registrar and inspector. So the basic inspection inquiry information is given in 206, 207. Whatever inspection inquiry you have done, the report will be made in section 208. During inspection inquiry, if you want to do search and seizure, that will be done in 209. Now, next is, you want to do investigation. So central government may appoint inspector, but only when this investigation order is made by NCLT. So there is a two possibilities. CG want to do it suo motu or on the order of NCLT. So if NCLT is giving order to the central government for investigation, so NCLT will give order under section 213 to whom? To central government. Then central government will do what? So then the central government, there are two possibilities. Can I say central government may assign this to SFIO, or central government may appoint inspector to do investigation. There are certain big offences, those will be investigated by SFIO, Serious Fraud Investigation Office. Otherwise all offences will be investigated by the inspector, and the power of inspector is given in section 217. SFIO establishment is given in 211, and the functions of SFIO is given in 212. Now after that, once inspector got appointed, they have just clarified that see, inspector should be the natural person. Firm or body corporate should not be inspector. That is given in 215. Sir, why? Because obviously inspector is exercising lot of power, lot of activity. For that you need to be the natural person to do the lot of activity which is normally done by inspector. So they have just put one section that firm or body corporate cannot become inspector. Then after that, there are three things. Number one, First, the investigation can be of affairs of the company. Then you can do investigation of the ownership of the company, and then you can do investigation of the related company. So affairs of the company, that you will study in 210. Ownership of the company you will study in 216, and related companies you will study in 219. And their report will be prepared in, the investigation report will be prepared in 223. Now you will say, sir, but you said 208, that is an inspection report. Investigation report will be prepared in 223. On that basis, what action CG can take is given in 224, and who will bear the expenses of the investigation is given in 225. So these are some glimpses of the section which we will going to study. So now let us start. Now let us study section 206. What they are saying, 206, please understand, they are saying registrar documents. First of all, section 206, a registrar may have some document with them. On the basis of the document, they may call what? They may call information explanation. And from whom they will going to call information explanation? From company. So then what is the duty of company? Company is bound to provide information explanation. So first, registrar has some document. On that basis, they are of the opinion that they need information or some explanation. So they will send notice to the company, and it is the duty, and they may ask company to provide information and explanation. Now it is the duty of the company to provide the information. So there are two possibilities. Possibility number one, that company has provided information or explanation. This is the possibility number one. Possibility number two, company has not provided information, no information is provided, or incomplete information is provided, or inaccurate information is provided. If they have provided, fair enough, but if they have not provided, if the company has not provided information to the registrar, then again by written notice, they will again demand the information. Now again there is a possibility that registrar has provided the information, or again there is another possibility that they have not provided the information, or incomplete, inaccurate information is provided. So they are saying even after second notice, if incomplete, inaccurate information is provided, then they will be levied fine up to 1 lakh and ₹500 per day. But if they have provided information explanation, then what? So they are saying in that case, registrar may form three opinions, that if there is a fraud, then obviously there will be punishment for fraud. You will be studying in section 447. Second opinion, they are not very sure that fraud has happened or not, but they are of the opinion that inquiry need to be conducted on the basis of information, or they are of the opinion that there is a possibility of fraudulent thing, or there is a possibility that investor grievance not redressed. In that case, they will refer this to central government, and central government may authorize the registrar inspector to conduct inquiry. Now you can see they have added the word inspector. Why? Because now, can I say, this entire investigation, this will be done by whom? Will be done by inspector. So they will conduct inquiry, not investigation. Inquiry came into the picture, and that's why inspector will also come into the picture. So inspector will be appointed who will do inquiry, whose power is given in 207. What if they are of the opinion that everything is diligent, then no further action will be taken. So now let us revise once. See what I am telling you. Registrar has some document. On the basis of that information, they are of the opinion that they need some information. So they may call information or explanation from the company. Now company is bound to provide the information. So if the company has provided information explanation, fair enough, but not provided, or incomplete provided, or inaccurate information provided, then again demand notice will be sent by the registrar to the company. And even after the second notice, if the information is not provided, then there will be penalty. But if it is provided, and registrar is of the three opinion that fraud has been conducted, so in that case 447 penalty. If they are of the opinion that everything is diligent, means nothing wrong has happened, then no action will be taken. Or if they are of the opinion that inquiry can need to be conducted on the basis of information filed, fraudulent, that business has been conducted for fraudulent purpose, this is an opinion but which need inquiry, or investor grievance not redressed, in that case they can refer it to the central government, and central government may appoint inspector, registrar inspector for the inquiry, whose power is given in section 207. Now, what is the power of registrar inspector given during inquiry? So please understand, all powers and duties are corresponding to each other. So it is very easy to remember. Again, the power of registrar inspector will not, can I say, will be nothing but corresponding to the duty of officer or employee of the company which is under inquiry. So can I say how you can remember? What is the power of registrar? They can do discovery and production of books and books of accounts. They can do what? Tell me first. Discovery and production of books of accounts. They can ask for books of accounts. And once they will get the books of accounts, they can place identification mark. If something wrong has they have found in the book, they can put the identification marks which can be used as evidence subsequently. And they can make copies of the books of accounts. Means they will not take original book, they will just do the photocopy and they will take the books original, they will keep the original books with the company and they will take the photocopy along with them. And then they can inspect books of accounts, they can summon. Now see how you can remember. It is the power of registrar inspector for the discovery and production of books of accounts, placing identification mark. So don't you think what is the duty of officer employee? If when they will ask for books of accounts, it is their duty to provide the all documents and books of accounts. When it is their duty to place identification mark, make copies. So for that they have to provide what? For that they have to provide all documents and books of accounts, corresponding duty. They can inspect books of accounts. For that it is their duty to provide information, explanation. Summon means asking someone to come in person. See, normally when some authority asks you, you can send your advocate, but when they will summon you, you have to go yourself. You can take the advocate along with you, but you have to go yourself. That is summon. So if they will summon you, it is your duty to render all assistance. And if you are failing to do it, there will be imprisonment up to 1 year and fine 25,000 to 1 lakh, and director is also liable to vacate. So how you can remember? Corresponding power. What is the power of registrar inspector? They can say for discovery of books of accounts, means they will tell where to officer employee of the company which is under inquiry that wherever the book is, you please bring to us. Once book they got, they can make identification mark, they can make copies, and they can then if there is any query in that, they can ask for information. So they can, means they can conduct inquiry and they can also summon. So what is the duty of officer employee of the company? They will provide the books of accounts, documents, they will provide the information, and they will render all assistance. Fine. Now can say registrar inspector have conducted inquiry. After conducting inquiry, they will make a written report, and this report they will give it to central government. You know, inquiry is not in detail analysis. It is not fact finding activity. It is just a basic inquiry. So after written report, if the registrar or inspector is of the opinion that there are certain things which is possibly maybe a very big fraud, but for which we need to conduct investigation. So in the report only they can write the recommendation to the central government, and they can recommend central government that this company require further investigation. So they, in the written report they can refer that this company require further investigation. During inquiry, if registrar or inspector is of the opinion that some books or something, some evidence is available at some place, then can they conduct search and seizure? Yes, during inquiry they can conduct search and seizure, and that power is given in 209. What they are saying, that if the registrar or inspector has reasons to believe, see when the language they are using, reasons to believe, not just opinion, that means they have some prima facie evidence. So can I say, if the registrar and inspector has reasons to believe that books and papers of number 1 company, director, KMP, auditor, CS in practice. How you can remember? From near to far. For company, who is the most close? Company itself, then director, then KMP, auditor is outsider, CS is even more outsider. So they can, if registrar inspector has reasons to believe, then books and papers of company, tell me, company, director, KMP, auditor, CS in practice, they are of the opinion that their books and papers are likely, means it is not yet done, but there are chances that it will be done. So it is likely to be destroyed. They are of the opinion that it will be destroyed, or it will be mutilated, or it will be altered, changed. Destroyed means you may destroy it, or mutilated. Are you understanding? You may just store the pages or something like that. Alter, can I say you may make some changes. Falsified means, can I say you may remove that book and you may put some other book in that place. Secreted, you may hide the book. So there are, if these are the possibilities, fine. Destroyed, mutilated, altered, falsified, secreted. You can remember DMAFS. Then after obtaining order from the special court, it can exercise three power: enter, search, seize. So what I am telling you, after obtaining order from whom? After obtaining order from special court, they can exercise three power. Which three power they can exercise? Enter, search, seize. But this power they can exercise only after taking approval from the special court. They can enter with such assistance as may be required. Means if they feel that they are not safe to go alone, they can take police protection. Search such place as may be required. If they are of the opinion that in the bedroom of managing director some books are there and they can be used as evidence, so they can search the bedroom of the MD, that is house of the MD. Seize books of accounts. Sir, that we have already studied. No, there you have taken copies, not the original book. Here you can take the original book only. So seize the books of accounts. But then in this situation you will allow company to take the copies. Earlier you had taken the copy and the original book was with the company only. Now you want to take original book, so you will allow company to take the copies, and it can be seized for 180 days, and further extension of 180 days can be taken. So it can be taken for 180 days plus another 180 days. So what they are saying, if the registrar has reasons to believe that books and papers of the company director KMP auditor CS in practice is likely to be DMAFS, destroyed, mutilated, altered, falsified, secreted, then with the approval of special court they can do three things: enter, search, seize. Enter with such place as may be required, search such place as, enter with such assistance as may be required, search such place as may be required, seize books of accounts. And books of accounts can be seized for 180 days plus 180 days. Next, section 210, investigation by CG. Now we are entering into the investigation part. See, till now we have studied inquiry. Now we will be discussing investigation by central government. See, there are two possibilities. One is CG may order investigation, and number two, CG shall order investigation. If when they use the language CG shall order investigation, means in this situation it is mandatory obligation from the end of CG, they have to order investigation. When, sir? When the order is made by NCLT and when the order is made by court. Are you understanding? Sir, why? Obviously NCLT and court, if they are telling any order, they are the judiciary and CG is executory, so they have to listen what court and NCLT is saying. So when the order is given by NCLT and court, CG have to order, mandatory it is, shall order investigation. But when CG may order investigation, when it is optional, so this is when recommendation is made by registrar. So when the registrar is making the recommendation, then it is optional. In section 208 we studied now that the registrar has given recommendation to central government. Then obviously in that situation you cannot mandate CG. Registrar is a smaller authority. So if they are giving recommendation, it is optional from the central government that whether they want to order for investigation or not. SR passed by the shareholder or public interest, means CG is feeling suo moto. In these three situations CG may order, they have the option. SR passed by the shareholder, suo moto. SR passed by the shareholder, then also it is optional. It is the wish of the central government whether they want to order investigation or not. Fine. Now, please understand, I told you order of NCLT. When order is given by the NCLT to CG for conducting investigation, then it is mandatory for CG to order investigation. But when the NCLT will give order, so please understand one thing, this is provision given in section 213. If when members are filing application to NCLT, on that basis NCLT will order central government for investigation. So NCLT being a quasi-judicial court will not go suo moto to CG and will say that please conduct investigation. No. When NCLT will order investigation to central government, when members will file application to NCLT, and how many members can file application, that is what we will going to learn in section 213. So how many members can file an application to NCLT? This is, sir, if the company does not have share capital, then 1/5 of total number of members. So let's say if there is 1000 members, then 1/5 will be 200. If the company has share capital, so if the company is having share capital, in that case 100 members or 1/10 of, please notice, total voting power, they are not using the word share capital, total voting power will make the application. Sir, I have a doubt. if this many members are making the application, then is it obligation for NCLT to refer this to CG and order the CG for investigation? So answer is no. Can say if these many members is there, then only they can make an application to NCLT, and then NCLT will think whether to give order of investigation to CG or not. If members are less than this, then they shall not go to NCLT at all. Are you understanding? Sir, whether other person can also file the application. So they think any concerned member other than member can also file the application. So what I am telling you, any concerned person other than what? Other than members may also file the application. On which ground? On these 3 grounds. So any concerned person can, other than members, also can make the application when the business are carried for fraudulent purpose, director are engaged in fraud, business is conduct, and inaccurate information provided to members. So even other than members can make the application on these grounds to NCLT. So I hope it is crystal clear, everybody. Shall we proceed? Next, I have already told you, if when you appoint inspector has to be a natural person, because the activity which inspector has to perform, artificial person would not be able to do that. So they are saying firm or body corporate cannot become inspector. Firm or body corporate cannot become inspector. Then investigation of the ownership of the company. What is the reason behind doing the investigation of the ownership of the company? Please understand, let's say I am a very rich person, I am a politician, rich, sir, you are rich. So I am a politician, are you understanding? I am a politician, I have 1000 crore rupees, but all this is black money. So what I have done, I have formed one company and I have made my driver as the MD of this company and shareholder also. My driver, maid, etc. Now the question is, tomorrow if government want to punish, they will punish this person only. He will not be punished. And that's why they are saying that, boss, sometimes we have to find who is the true owner to decide that to whom we need to punish. So this is nothing but investigation of ownership of the company. CG may order investigation of ownership to determine who is true owner on the basis of material interest in the company. For example, in this company, this driver or maid does not have material interest. This politician has material interest. Material influence on the policies. If this company's policies, this driver shareholder will not decide. This person will decide. Or beneficial interest in these shares. Technically, he is the legal owner, but the real benefit is given to this politician. So, can I say these are the 3 factors by which you can investigate who is the true owner. What? Can I say material interest in the company, material influence on the policy, and beneficial interest in the shares. And for that, they can conduct what? They can conduct investigation. Protection of employee during investigation. Now, I will tell you one thing, lot of information during investigation is provided by the employee to the inspector. For example, let's say I am the inspector, I went in the company and I want some fraud, I want some books of accounts in which some fraud information is there. So I was searching for this. So there was one innocent, employee came to me, he said, sir, the book has been kept over there. I have seen it. And now I will find that book. But being that employee is a very small employee, so can I say now once I will go out of the company will going to punish this small employee. So they are saying that for this purpose, employee need to be protected. So this is that no employee can be removed or deranked during investigation without approval. So you want to remove, you can remove, but then you need approval of NCLT. Sorry, you need approval, yeah. Now you will say, sir, why they can remove? What if after providing information that employee started misbehaving because he think that nobody can remove me? So now let's abuse everybody in this company. So it is not that you cannot remove, but for removal you need whose approval? NCLT. So can say they will apply to NCLT for this, fine, and NCLT has to reply within 30 days. If no response is given by NCLT within 30 days, in that case that employee can be removed. So if the company want to remove that employee, they have to apply to NCLT and NCLT has to reply within 30 days. If NCLT has not replied within 30 days, then company will deem it as NCLT is okay with this and they can remove the employee. If NCLT has passed an order for removal, then obviously he can be removed, everybody. But then employee can be removed or deranked. For derank also you have to give this information. Why? Because employee is a cashier and he has provided the information. Now you are saying now you will not be cashier, you will be peon in this company. So can I say, even if you want to derank that person, you have to take NCLT's approval. But what if NCLT reject the application? Means you have said that we want to derank this employee, we want to remove this employee. NCLT will say no, I don't think so, he has done anything wrong. So in that case, if you are not happy with the order of NCLT, you can file appeal against NCLT to NCLAT, National Company Law Appellate Tribunal, within 30 days. I hope it is clear. Shall we proceed? Investigation into affairs of the company. Now this is very important. Please understand. Till now, you are doing the investigation of that company. But now you want to do the investigation of related companies. Sometimes what happens now, there are some evidential circumstances and due to which you need to investigate some other companies also to gather the information. So can you investigate some other companies also? So now they are saying, since you are touching other companies, you need CG approval. So inspector cannot do investigation without CG approval in other company. Now which other company you can investigate? So any body corporate which is subsidiary or holding or fellow subsidiary. Now holding subsidiary, you are holding more than 50% shares. So the company which is under investigation, that company is a subsidiary, that company is holding and that company is fellow subsidiary. Subsidiary means you are holding more than 50%, or the company which is holding your company is more than 50%. Fellow subsidiary means what? Again, say there is a holding company and you are the subsidiary. So another subsidiary of that holding company will be fellow subsidiary for you. Are you understanding? So you can investigate all these three, and that can be present or past. Please understand, present or past means if some company is your subsidiary holding and fellow subsidiary today, you can investigate. But some company is not the holding subsidiary or fellow subsidiary of your company today, but it was in past. Sir, can we still investigate? Yes, you can still investigate. Or if any body corporate in which having a common MD or manager, means can I say there is a company in which my company's MD or my company's manager is the MD or manager in that company. So I can investigate that company also. Now you will say, sir, why? Because if my MD or manager has done fraud in my company, there is a possibility they must have done some fraud or something like that in that company also. So you can investigate that company also. What if my MD or manager, today he is a MD in my company and in that company he is not today MD, but he was a MD earlier, he was a manager earlier. So can I say, if it is in present or past still, it can be investigated. Or any body corporate whose BOD are accustomed to act as per the directions of directors of the company. Now there is some body corporate and that body corporate board of directors is working as per the instructions of the directors of your company. And now if your directors are doing fraud here, now don't you think there will be very high chances that there is another company whose board of directors is working as per the directions of your directors. So your directors must have given them some order, and because of that some fraud must have done in that body corporate also. So you can investigate that body corporate also. So if there is another body corporate whose board of directors, if they are working as per the instructions of the directors of your company which is under investigation, then you can investigate that particular body corporate also. But this is only present. Means if in the past that body corporate they were working as per accustomed to act, that BOD, then you cannot do the investigation. But if today in present they are doing it, then you can do the investigation. I hope it is clear. So here only it is present. Then MD, manager, employee of the company, whether you are today MD, manager, employee, or you were MD, manager, employee earlier, today you are not MD, manager, employee, but still you can be investigated. So these people can be investigated. I hope it is clear. Now, seizure of the documents by the inspector, investigation. This is nothing. Just now you have studied, there was a seizure you have studied in section 209. Now this is 220. Here also we are reading seizure. That seizure, those seizure was for inquiry, 209. Here it is 220, it is for investigation. Same like 209. All procedure except they are used to take special court approval. Here special court approval is not required. Why? Because you are doing it for related companies. So here you need CG approval. Fine. Books and papers will be of related company. This is what we have studied. and they are used to cease for 180 days plus 180 days, here till latest conclusion of investigation. Till the period investigation does not get completed, you can seize the books of accounts. So this is the difference. Otherwise all the procedure whatever we have just now studied in 209 will be same over here as well. Next section, freezing of assets of company on inquiry and investigation. When you have done inquiry and investigation, can you freeze the asset? What is the meaning of freezing the asset? Freezing means you cannot transfer the asset. So please understand, when the application is made by central government or members under section 244, means operation and mismanagement, creditors having value 1 lakh or more, and any concerned person. Are you understanding? You can remember COCA, central government, operation mismanagement, creditor and any concerned person. COCA can make the application to NCLT, but when you can make application, when they have reasons to believe. Reasons to believe means you have some proof, evidence, and that is given to NCLT, and NCLT is having now reasons to believe with that proof that asset will be transferred. There is high chances that asset will be transferred, and if it is transferred, it will be harmful to the interest of company, shareholder, creditor, public, from near to far. For companies at the most primary place, so it is harmful to the interest of the company, then shareholder, then creditor, then public. Then they may order to freeze the asset. They can freeze the asset for maximum 3 years. Means in that situation, asset will not be transferred for 3 years. And if still you are transferring, then this punishment will be there. So now tell me, who will file the application? Central government, operation mismanagement, creditor, any concerned person. Creditor having value 1 lakh rupees or more, any concerned person. They will make an application to NCLT, and if NCLT has reasons to believe that asset will be transferred which will be prejudicial to the interest of the company, shareholder, public, then in that case they may freeze the asset for maximum 3 years. I hope it is clear. Okay, now let's move to next section. Section 223, inspector report on investigation. In section 208 we have studied that the report will be prepared and ROC will furnish the report to central government, but that was for inquiry. This is for investigation. Inspector will give written report to central government. Obviously the report has to be in the written form. During investigation also they can report, they can give report, and on conclusion of investigation also they can give report. During investigation, the report which is given is called interim report. During investigation, any report given is called interim report, and after the investigation get completed, the report which are given is called final report. So this report will be authenticated by the company or officer having the custody. So what they are saying? They are saying that you can give report during investigation also, and after the conclusion of investigation also. During investigation, the report which you are giving is called interim report, and after the investigation get completed, the report which you are giving is called the final report. And this report will be authenticated by the company or officer having custody. Who will give this report? Inspector will give this report. And to whom it will be given? It will be given to central government. And now who can obtain this report? So this is who can obtain this report. Number 1, creditor can obtain this report. Number 2, member can obtain this report. Any person who is concerned, like anyone who is getting affected because of this investigation, can obtain this report. So very simple section. Shall we proceed? Section 224, action to be taken on the basis of inspector report. What action can be taken on the basis of inspector report? Number 1, they can do the recovery of any loss or damage due to fraud, that is indemnification. Means, please understand, if any fraud has happened, so the person who has done any fraud, so anyone who is suffering loss because of that, that loss need to be compensated by the person who has committed the fraud. So this is called indemnification. Number 1 is indemnification, recovery of property which is wrongfully applied. If you have given the property fraudulently to someone, so that will be recovered. And if the crime is very big, if the fraud is very big, even the winding up order can be past. So number 1, indemnification. Number 2, recovery of property. Number 3, winding up. These 3 orders can be taken by the, orders can be made by the central government, or action can be taken by the central government on the basis of inspector report. I hope it is clear. Security deposit for an application. There is always, that is given in section 214. There is always a risk of fake application. See, you have some grudges against the company, and that's why you made the application for investigation. So they are saying that anyone who is making application for investigation, they have to pay security deposit. CG may ask to pay security deposit, and that can be up to 25,000 rupees. The amount is less, I understand, but something is better than nothing. And if investigation result in prosecution, means the person who has made the application has to pay 25,000 rupees. Now, after that application, there are 2 possibilities. Can I say the person who has made the application, after that investigation has been conducted and the person against whom the investigation has been conducted has been proven guilty. Now, that means the application was the genuine one. So in that case, it will be refunded. So security deposit will be refunded if the investigation results in prosecution, means the person has been declared guilty. What if that person does not get declared guilty, means that the application which you have done was not genuine. So in that case, the security deposit will be forfeited. I hope it is clear. Who will going to bear the expenses? Sir, security deposit from expenses will be incurred from security deposit. Please understand, security deposit is very less amount. It is hardly 25,000, and investigation expenses are very high. So it cannot be borne from the security deposit. Who will bear the expenses of investigation? So it will be borne by CG, and subsequently if somebody declared as guilty, it will be recovered from that person. It will be recovered from the person who is prosecuted. What if it is not prosecuted? So it will end up borne by the CG only. Now, continuation of investigation. Once the investigation will start, will it going to affect the application of operation mismanagement, or any winding up application made by shareholder, or any winding up order made by NCLT? So they are saying no. Even if investigation started, it will not going to stop operation mismanagement or winding up by shareholder or winding up by NCLT. It is other way around also, means if any application of operation has been filed, or application for winding up by shareholder has been filed, or winding up by NCLT has been filed, even in that situation it will not affect the investigation. So in a simple language, I can say that both will go together. Investigation will not get affected, even the investigation will continue. So this is the point. Section 227. Can say legal advisor have lot of information related to company. Bankers have lot of information related to company, and those are very confidential information. So there was a doubt, can they be compelled to share those informations? So see, in India, if you want judiciary to run properly, you have to give legal advisor and bankers proper shield. So they are saying the legal advisor or banker, when they have obtained any information in their ordinary course of business, means they have obtained the information while exercising their rights, like you are an advocate and you got the information when you are representing your client. So can I say you have obtained this in an ordinary course of business? Then nobody can compel them to share that information to NCLT, CG or registrar or inspector, except the name of client. Name of client is not a confidential information. Apart from that, nothing CG, NCLT, registrar, inspector can force legal advisor or banker that you have to share the information which have been given by client to you. No, they can keep it confidential, and NCLT or CG or registrar, inspector cannot force them to share these informations. Provision of this chapter is applicable mutatis mutandis to the foreign company, means whatever investigation procedures you have studied, or inquiry, investigation, everything in this chapter is also applicable to foreign company. But wait, now when I say it is applicable to foreign company, means will you go and do the search of Tesla? No. So foreign company, as if it is applicable to Indian company, but only for Indian business. So if the foreign company has some businesses outside India, you cannot go and investigate that way directly there. But yes, to a foreign company, they have an Indian business, you can investigate that in the same manner as if you are investigating some Indian company. That is called mutatis mutandis. Section 229. What they are saying? While investigation inquiry, if you have given any false statement, or if you have destroyed any document, you have mutilated any document, you have made changes in the document, then it will be liable for 447. 447 is for punishment for fraud. Punishment for fraud. I hope it is clear. Next is section 212. What they are saying? Investigation into affairs of company by SFIO. Please understand what they are saying. Investigation in the affairs of company by SFIO. What is the full form of SFIO? Serious Fraud Investigation Office. What is SFIO? Tell me. Serious Fraud Investigation Office. Now, see, there are, I'll tell you, whenever you file an application to central government take a call that is it a very big offense or relatively less. If it is a normal offenses, normally they will send this to inspector, and inspector will do the investigation. But then there are some very serious and grave offenses. In that situation, instead of sending it to inspector, they may send it to SFIO. So what they are saying, registrar, when registrar is filing application under 208, SR Public Interest Government Department. If these three were for inspection also, investigation also, only one thing has been added, that is Government Department. So if these four will make an application to CG, CG may refer it to SFIO. Considering the intensity of the offence, they may refer it to SFIO. And then the SFIO director will appoint the inspector, who will have power as per section 217, which we will study in some time. And then they will do the investigation of the company. They have an overriding power in this act. It means if some other authority is already doing some investigation or already undergoing with some verification, and if SFIO started their investigation, that other agency will stop and the entire control will be taken by the SFIO. So any investigation by any agency will abate and shall provide all document to SFIO under this act. So let's say if some other authority is doing any investigation under Companies Act, so what is now their duty? They will stop, and whatever the information related to that company they are having, they will provide this to SFIO. Agency may take information and shall provide information to SFIO. So can I say other agencies, if it is not under Companies Act, in general, if they want any information, they can take it from SFIO and they can provide information to SFIO. So I hope it is clear. Shall we proceed? Now we are learning section 217, power. A power of inspector. Please understand. Power of inspector. What is a power? Please understand. What they are saying, when the investigation is going on, they are saying central government, state government, police, legal authority, they shall provide assistance to inspector, because inspector cannot work standalone. Can I say they need a lot of help? So central government, state government, police, legal authority shall provide assistance to inspector. Then this is, inspector has a civil court power. What is the civil court power? They can summon. Summon means they can ask somebody to come in person. So sir, they can bring advocate, yes, but they also have to come. They cannot just send their advocate. That's called summon. They can summon to whom? To officer, director, employee of the company. So they can summon to officer, they can summon to employee or director of the company. They can do it. If they want to summon someone apart from officer, director, employee of the company, now it's a very big thing, because officer, director, employee is directly related to company, you can summon them. But you want to summon someone else, then you have to obtain prior approval of central government. Then they can demand information also, whatever is necessary. They can demand books of accounts also, and they can keep it in the custody of for 180 days. They can examine on oath also. So they can do these things. Then this is when they are asking someone to come in person. They are summoning, they are asking for information, they are asking for books, they are examining on oath, and if the other person is not cooperating, then what will happen? And then the penalty will be levied on director, officer and other person. And not only that, if that person is the director, he is also liable for vacation of office. So director is liable for vacation of office also, penalty also, like that. I hope it is clear. Then second part is about cooperating each other. I hope it is clear. Second part is about cooperating each other. What they are saying? Now lot of fraud you do in India, and then all document you send outside India. So how the government will control? And that's why many countries nowadays are doing reciprocal agreement. For example, I'm in India, fine, I'm in India, and there is another country, Mauritius. Now my person has done fraud and he ran away here, and a Mauritius guy has come to India. So now don't you think India and Mauritius will do the agreement that, see, I will going to help you for the investigation, and against that you have to help me for the investigation, and this is called reciprocal arrangement. What we call it? Reciprocal arrangement. So what they are saying, that if the central government and foreign government can sign reciprocal agreement for exchange of information records necessary for information, how it will work? If the foreign government will exchange information records to government of India, means what? Again, the foreign Mauritius government is giving information to India, means here Indian government is taking help from Mauritius government. So how it will work? This is, first of all, Indian inspector will make application to Indian court. Indian inspector must be doing some investigation, and they came to know, and they are of the opinion that we need help, so they can make an application to Indian court. Indian court will give letter of request to court competent authority outside India. Indian court will send the notice or details to outside India, and that what authority, Indian court will give letter of request to court outside India, competent authority outside India, and what help they will ask? They will tell that, see, my person has gone outside India, can you please examine that person on my behalf? Can you record his statement? He is having lot of book outside India which is related to the investigation which we are doing in India. So can you provide such books of accounts, records to us? So these requests Indian court can make to the competent authority outside India. Then the court outside India, what they will do, they will provide these documents, records, etc. to the court in India, and then the Indian court will provide this document to the inspector, who will use it as a evidence in his investigation. So this is when the Indian government or Indian court is asking help, Indian government or Indian court is asking help to foreign government. It can be other way around. Foreign government will ask the help to Indian government. So how it will work? Government of India will exchange the information with foreign government. Means here Mauritius is asking help, and the government of India will give the help to Mauritius government. So government of India will exchange information with foreign government. Foreign government will provide letter of request to Indian government. So foreign government will give it to Indian government. Now the Indian government is central government. Central government will direct the competent Indian court to proceed with the matter. Indian court will authorize the inspector and will tell them that please investigate the matter and provide a report within 30 days. So foreign government has given this letter of request to Indian government. Indian government sent it to competent authority, competent court in India, and then that competent court will order the inspector to provide the report within 30 days or any extended time. And then the Indian court, whenever they will get the information from the inspector, they will forward this information to foreign court. So this is the entire procedure. I hope it is clear. So finally we have completed with the chapter inspection and investigation. Next chapter we are doing the discussion is company incorporated outside India. In this, the first definition which we will discuss is foreign company as per section 2 clause 42. This is what is the foreign company. This is that any company incorporated outside India and has a place of India and have doing business activity in India, If 3 conditions are satisfied, then that company will be called as foreign company. Number 1, it shall be registered outside India. Number 2, it shall have a place of business in India. Number 3, it shall doing the business activity in India. So these conditions are cumulative, obviously cumulative, and is written. Now place of business can be directly or it can be indirectly, it can be physical, or you can have a electronic presence also. So it can be like that. But you are having a business activity in India. If all these 3 conditions are satisfied, then the company will be called as foreign company. So this is what we have discussed. Then this is section 379. If any foreign company is there, fine, and if that foreign company is at least 50% shares, whether equity or preference, held by either Indian citizen or Indian company or Indian body corporate, or cumulatively together at least 50% shares are held by, whether equity or preference, are held by Indian citizen, Indian company, Indian body corporate, or together. So that foreign company's Indian business will be deemed as Indian company. That foreign company's Indian business will be deemed as Indian company. Now they will be deemed as Indian company, means they have to definitely follow the foreign companies chapter. So foreign company chapter 22 they have to follow, but they have to follow such other provision as may be specified by CG. Means CG may tell them to follow some provision which is applicable to Indian company. So basically they have to follow what is given to foreign company, and some provision what is there for Indian company, CG may tell them to follow that as well. So what I told you, that if any foreign company whose 50% equity share capital or preference share capital is held by Indian citizen, Indian company, Indian body corporate, then that foreign company's Indian business will be deemed as Indian company. They have to follow the provisions of foreign company also, and they have to follow the provisions of such other provisions as given by the CG. CG may tell them to follow something which is applicable for Indian company. Are you understand? Next is, so same thing I have given as an example, that if CIOI is there, place of business is not there in India, then it is not a foreign company. CIOI is there, place of business in India and business activities in India. So it's a foreign company, but 50% or more shares not held by this Indian citizen, or then it's just a foreign company. But if everything fulfilled, then its Indian business will be deemed Indian company. Are you understanding? Section 380. Whenever a foreign company start place of business in India, they have to file lot of documents to New Delhi ROC. Always remember New Delhi ROC. They have asked it many times in exam. Now, I'll tell you what is, there was once, the question was there in exam. They have said that they have started in Kolkata. So, you know, the basic opinion is it shall be filed to ROC of West Bengal. Answer is no. If you are a foreign company, even if you start the place of business in Kolkata, still you have to file all documents to the New Delhi ROC. So, what documents? Documents required to be filed with ROC of New Delhi within 30 days. In form FC1. Whenever you have incorporated place of business in India, then from that day, within next 30 days, you have to file in form FC1 what all the documents to ROC of New Delhi. If there is any changes, alteration, then in that case you have to file within 30 days form FC2. So these, see what they are saying, if you have started place of business in India, then these documents, if you have started place of business in India, then these documents you have to file to New Delhi ROC within 30 days. And if there are any changes in these documents, then also you have to file within 30 days to New Delhi ROC in form. But the form number is, when you are coming first time and you are filing these documents, it is form FC1 within 30 days. And if there is any changes, then also you have to file within 30 days to New Delhi ROC, but then the form will be form FC2. Now, what documents you have to file? This is constitution of the company. See, in India we call it memorandum, but since it is a foreign company, in foreign it must be known by a different name. So this is the constitution, that is the charter, that is the statute, that is the memorandum. Technically you have to remember, memorandum you have to file in India. Then, can you say this is a foreign company? So, details of the director, name and details of the secretary, you have to file. If there is any address of the principal office outside India. Sir, why outside India? Obviously, being a foreign company, principal office must be there outside India only. So, that information you have to file. Then, the similar things in India also. For example, when you are filing at principal address outside India, you have to file place of business in India. Then, you are filing name and details of director, secretary, but they are sitting outside India. In India, government wants someone to whom government can frequently communicate. So, name and address of one or more person to whom the notice can be served on behalf of company who is in India. To put it in simple language, can we call it as Indian representative? Yes. So, we can call it Indian representative. Then, whether in past the place of business has been started or closed in India. So, whether in past office or place of business is opened and closed in India before. Why so? Please understand one very important thing. If you have started office before in India and if you have closed office before in India, so what is the problem that I will tell you? See, you have started office or you have closed office in past. So, there is a possibility that you must have done something wrong. So, you know, government has to track that, and that is why whether you have, if you have closed or opened the office, you have to inform that also in past. Then you have to ensure that the director and the Indian representative is not debarred to incorporate company anywhere. Sir, in India, no. Anywhere. Means in India, obviously, they shall not be debarred. in that home country shall not be debarred. They shall not be debarred to incorporate company anywhere in India, so anywhere in the world. So government don't want that risk. They say that your Indian representative director shall not be shabby and any other information. So it is very simple, everybody. The constitution, charter, memorandum outside India, place of business outside India, details of director, secretary, then address, registered office outside India, place of business in India, name and address of the person to whom the notice can be served on behalf of company, that is Indian representative, then whether office or opened or closed in India, then foreign director and Indian representative is not debarred to incorporate company anywhere, and any other information. Then this is section 381, accounts of a foreign company. This is foreign company's account will be prepared as per schedule 3. And if schedule 3 exact you cannot follow, then try to keep it as close as possible to schedule 3. Then this is that document need to be annexed what is given in chapter 9 of the Companies Act. Then latest consolidated financial statement you have to give for the parent foreign company, consolidated. And see, if this is possible that these informations may not be in English. This is possible that these informations may not be in English. So this is that if it is not in English, you have to give this in certified English. So that is there. Then this is related party transaction. If you have done related party transaction, you have to you have to provide certain information, like you have to tell the name of the person who is covered in section 2 clause 46, section 2 clause 76. I taught you this in meeting of board chapter. I told you the relations of related party, then what are the nature of relation is there, what is the nature of transaction, value of transaction, and whether it is at arm's length price or not. So all these things, whatever anyway we have studied in section 188, those informations. Then repatriation of profit. See, please understand, if it is a foreign company, means that the company registered outside India and it has a place of business in India. That means whatever business he will do in India can say a lot of money he may send. In real life, you cannot send too much of fund outside India. It is lot of restrictions are there, but little amount you can send outside India. So that is called repatriation. So when the foreign company has a place of business in India, after doing business in India, if they are sending money outside India, that's called repatriation. So you have to give the details related to repatriation, how much amount you have given, who is the recipient, in what way you have given, details, mode of repatriation, all these things. Then transfer of fund. Now please understand, whenever you are doing transfer of fund, you have to provide entire details, a date, amount, purpose, approval of RBI, everything, and you have to file the above documents to ROC within 6 months from the end of financial year, form FC3. If you are not able to do it within 6 months, you can get extension of 3 months by registrar. Do they have to get their books of accounts audited? So this is yes. Audit required to be conducted by CA having a COP in practice or firm doing practice. And Companies Act chapter 10, audit and auditors, which you have studied, will be applicable for their audit. Fine. And foreign company, can I say they will file FC3 within 6 months from the end of financial year to ROC New Delhi. And along with that, in books of accounts, what they will make sure that, can I say, they for Indian business they will write everything in the way we present in India. Then it will be certified English translated copy. It shall be as per schedule 3. You have to follow AS and Ind AS. Then financial statement and consolidated financial statement. If financial statement you will file only for Indian business, but consolidated financial statement will be filed for worldwide, and whatever attachment is required, that will be filed. Okay, now next point. When you start place of business in India, the foreign company has to display few things. First of all, what they have to display? They have to display the name of the company. They have to display the country in which the company has incorporated. For example, there is a company Jingzhong Corporation. Jingzhong Corporation is incorporated in China. So I will write Jingzhong Corporation. I will write below that it is incorporated in China. And if the company has a limited liability, I have to inform that also. Because see, if the company is outside India and if it is a limited liability, so the people will take cautious. People will be cautious while dealing with that. Why? Because if tomorrow any default has happened, then there is a very limited scope of recovering the money. So these 3 informations you have to provide, and that will be in English and vernacular language. Where it will be at the place of business in India. So wherever you have a place of business in India, on that signboard you will write these 3 things. Conspicuously means what? Visible, legible, you have written in a very chinna font. So that is not allowed. You have to write in a visible font. Are you understanding? So same way in the business letters, letterhead, communication letters, you have to give all these three information: name of company, name of country of incorporation, limited liability, but only in English, obviously. How come vernacular? Vernacular, place of business can be one language in which state it is, but business letter is given across state. You cannot write in 28 languages, no? Only English. And in prospectus, if the company has a limited liability, you have to give this information. Sir, what if the liability is not unlimited? Then we have to tell that liability is unlimited, no. But if the liability is limited, you have to tell that, and nothing written, then it will be deemed it is unlimited. So limited liability, you have to specify that. Whatever the notice you have to give to the foreign company, to whom you will give? You will give to the person whose name has been supplied. So if it is served, it will be deemed as a notice is properly served to the foreign company. So every time you cannot send the notice to the foreign country. So the person will be in India only, and to whom, if to that Indian representative, to that person, if you send the notice, then it will be deemed as if notice is properly served. Next, please understand what they are saying. Can I say financial statement? Indian company filed in AOC 4, you have studied in Inter C, and annual return filed in MGT 7. For foreign company, it is not like that. Foreign company has to file FC 3, financial statement. That took 6 months from the end of financial year, and annual return 60 days from the end of financial year. Here not from AGM, because their AGM when they will conduct, we don't know. So it is from the financial year you have to file. So financial statement will be filed 6 months from the end of financial year, and annual return 60 days from the end of financial year. And now what they are saying, these sections, what are these sections? Section 71 debenture, section 92 annual return, registration of charge, books of accounts, inspection and investigation, CSR. This is, it will be applicable mutandis to the foreign company as if it is applicable to the Indian company. Means these sections are there which is applicable for Indian company. It will be applicable to foreign company in the same way, provided if some exceptions are given by the government, you have to follow that exceptions. But apart from that, whatever exception is given, you follow that exception. But apart from that, everything, whatever is there for Indian company, for these sections need to be complied by the foreign company as well. So this is the thing. Section 385. See, whenever you file any document, so to ROC, when you will file document, obviously can say you cannot just go and file the document. So they are saying whenever you file the document to ROC, you have to give fees. How much? Whatever ROC has prescribed in the rules. So that much you have to pay the fees. Next is section 387, disclosure required in prospectus. This is whatever disclosure, normal disclosure which is there for Indian company, which is given under section 26. You must have studied it, CA inter level, that lot of documents, lot of information need to be given in prospectus. Those are given in section 26. All those informations need to be given by the foreign company anyways. But along with that, it shall also be dated and signed. So the prospectus should be dated. You should have written date in that, and you should sign those prospectus. I hope it is clear. Then apart from that, if any additional disclosure required to be given, so you have to forward that additional disclosure also. What are the additional disclosure you have to give in prospectus? Under which enactment the company is registered? Sir, Companies Act, no. The Companies Act is registered for Indian company. It's a foreign company. So it must have registered in some Ching Jong law, whatever law is applicable in that country. So you have to say the enactment under which it is registered, and name of country and date of incorporation. When that company, what is the name of the company? Jing Jong Corporation, and when it got incorporated in China, and document defining constitution of the company. For example, memorandum in India, like that there must be some document outside India for that foreign company which define their constitution. So you have to say that also. Then where you can, address of registered office, which will be obviously outside India. What is the place of business in India? Where is the place of business in India? That also you have to specify, and where all these documents can be inspected. So you have to say that. So what is that? Tell me. Section 26, whatever they said, dated and signed. Then they says enactment under which it is enacted outside India, name and country of incorporation outside India, registered address outside India, then place of business in India, then where the documents can be inspected in India. These documents. Fine. Okay. Next. Section 388, experts consent. Please understand, whenever you issue prospectus, lot of things, lot of valuations you give of assets in that prospectus. So to prove your claim, you also give the expert's report. So when you use this expert's report or expert statement, they are saying that any statement used in the prospectus which is issued, circulated or distributed by the company incorporated outside India by way of reference report or direct statement, then approval of such statements is required by the written consent. So if you are using any statement of any expert and you are making the claim that these informations are made by those experts, so before making that claim, you have to take the written, not the oral, written consent of that expert, and then only you can make that statement. So that expert should give in writing that okay, we are giving this statement, and according to us this thing is there. So yeah, they have to give the written consent. Now what if expert has withdrawn the statement? Means expert has given the information, then later on expert realized that boss, the information which you have obtained was given due to suppression of fact, means you have hidden some information, and then you went to expert, and then expert have inadvertently given you the consent. So they can withdraw it, but wait, they can withdraw it before registration of prospectus. So if the prospectus is not yet registered and expert want to withdraw this statement, they can withdraw it, and if they have withdrawn the information, then you cannot use the expert statement. But what if the expert has, what if the prospectus is already registered? Then can I say it is already in public domain? Now even if expert will withdraw, there is no withdrawal allowed, and the statement will be deemed to be given, already given. So if after registration of prospectus, if expert come to know that there was something wrong which he has said, he has to bear the consequences. Any losses anyone incurred because of this expert statement, he will sue the expert for that, and he will recover the compensation. Company cannot use such statement if the consent is written by the expert before, if the consent is withdrawn, not written, withdrawn by the expert before registration of the prospectus. I hope it is clear. Okay, let's proceed. Registration of prospectus. You want to raise fund, CIOI, company incorporated outside India, want to raise fund in India. So can they do this? Yes, they can do it. But before that, CIOI want to raise the fund. So obviously to raise the fund in India, they have to issue prospectus. So they cannot directly issue the prospectus. To issue the prospectus, first of all, it should be registered. What I am telling you, to issue the prospectus, it should be registered. What should be registered? Prospectus should be registered, and following conditions need to be satisfied. What? First of all, that prospectus should be signed by 2 directors and a chairperson. So it will be signed by 2 director and chairperson. Number 1. Number 2, the document shall have following details. Number 1, expert consent. Means what? Can I say prospectus need to be signed by 2 director and chairperson? Then in prospectus you must have claimed certain statement which you are saying that it is given by the expert. So that expert's written consent you have to file along with that prospectus. Then as I told you, if director is not signing because for some reason, maybe he is not in India, nowadays you can do electronic signing, but earlier there is to be physical. So assume if director is not signing because of any problem, if agent is signing, then you have to file the copy of attorney, that copy of attorney, power of attorney given by the director for that agent to sign. Then if there is any important contract with MD manager, that has to be filed. If there is any underwriting agreement, even that has to be filed, and any other material contract, you have to file all these things when you are filing, registering the prospectus. Then IDR. What is the IDR? IDR is the way by which CIOI raise fund in India. So any rules related to IDR by the CIOI, any rules for issue of IDR by CIOI, who can make it? CG can make it. Fine. So for listed companies, SEBI makes, and for here CG will make. So they can tell that how you can offer IDR. Then when you issue IDR, obviously CIOI is raising the fund, so they have to issue prospectus. So what disclosure will be there in prospectus? Then IDR, how it is issued in real life. There is a CIOI and there is overseas custodian. It goes like this, that a foreign company is there, CIOI outside India, and they issue shares which is kept with overseas custodian, and against that there is the Indian depository. Fine. For example, NSDL, CDSL, who issue IDR to Indian public. So they are in India. So how the depository will deal with IDR, that NSDL, CDSL in India, how they will deal it, and how the IDR will be transferred and transmitted. Transfer is voluntary transfer, transmission is by operation of law. How it will be done, all these issues, who will make the rules? Central government. Okay. Now section 391, application of section 34 to 36. What they are saying, when Indian company raise fund and issue prospectus, and if they do some mischief in the prospectus, there is a punishment for the Indian company under section 34, 35, 36. 34 is about criminal liability for making misstatement. 34 is about criminal liability for making misstatement. 35 is about civil liability for making misstatement, and 36 is about if you are fraudulently inducing someone to invest in your company. So then there is a punishment for 34, 35, 36. So when CIOI, company incorporated outside India, raise fund through issue of securities in India, and first let me finish this. So there is this punishment in these three sections. This is if CIOI do these mistakes in prospectus, even they will be punishable under 34, 35, 36. To put it in simple language, whatever punishment is there under 34, 35, 36 for wrongful act for raising fund and mischiefs done in prospectus, same punishment is there for foreign company also and CIOI also, company incorporated outside India also. When I say CIOI, please understand, foreign company, wherever it is written, it means registered outside India, having place of business in India and having business activity in India. That is a foreign company. But when I say CIOI, that is very broad interpretation. That includes a company which is having place of business in India, that is foreign company, as well as a company which does not have a place of business in India and they are just registered outside India. That is mere CIOI. So it includes both now. So this is one point which is completed. Second point, what they are saying, that any CIOI is there, who has raised fund from the India, and they have not repaid yet, they have not repaid any money in India and they want to close the place of business in India. Please understand, CIOI is there, they have raised fund from the India. After raising the fund, means CIOI is there, they have a place of business in India, that is they are the foreign company. They have raised fund from the India and they have not yet repaid it, and now they want to close the place of business in India. So it's a very big thing. Why? Because the company is outside India. Now they have raised money from the India and they have not yet repaid it, and now there is a problem. What is the problem? Can I say they have not repaid it? Now the problem is they want to close the place of business. So it's not that they will not pay in future, but don't you think if they will not pay it, it will become very difficult for Indian investors to recover this, and that's why this is for closing this place of business in India. It's a very difficult task. You have to follow section 376. It is not there in your portion, but 376 is the procedure by which a foreign company can close their business, and they have to follow chapter 20. That is how the chapter 20 is like how they can do the winding up. What is the procedure of winding up? So that is you have to follow. I hope it is clear. Now section 392, punishment of contravention. Now please understand this nicely. What is the punishment of contravention? See, if you are doing any violation of any provision of foreign company chapter, so the punishment for the foreign company is minimum 1 lakh, maximum 3 lakhs and 50,000 per day. As far as the person is officer in default, minimum 25,000, maximum 5 lakhs. So this is the punishment. So it's a very big punishment. Along with that, this is 393. Can I say, if a CIOI is there and if they have done any violation, then they cannot sue anyone but can be sued. Means if I am dealing with CIOI and they have done any punishment of this act, then can I say I can file case against that CIOI. But if I have done anything wrong with them, they will not able to file case against me. So don't you think they will be at great disadvantage? Sorry, it is like a partnership firm which is unregistered, same, and he is not eligible for set off. Obviously, if he will not able to file case against me, he is not eligible to set off. Means I am supposed to take 1 lakh from him and I am supposed to give 2 lakhs. So he will not able to do set off. I will say I will not give you your 2 lakhs, but you give my 1 lakh. And that's why if CIOI is there, they take great cautious while doing any violation, because otherwise they will be very unprotected in India. So because of this section. So that's all for CIOI, foreign company. National Company Law Tribunal and National Company Law Appellate Tribunal, NCLT and NCLT, very small chapter. See, central government has established 2 judiciary bodies on 1st June 2016. So central government has established 2 judiciary bodies on 1st June 2016. Number 1, NCLT. Number 2, NICLAT. So whenever a company has a problem, they will go to NCLT and then they can file appeal to NCLT and then it will go to Supreme Court. It goes like this. These sections are not there in your portion. So we'll straight away start, but then few things I have to discuss for the knowledge purpose. Benches of NCLT. Where is the principal bench of NCLT? New Delhi. There are many NCLTs across India and but the main bench is in New Delhi. And then this is every NCLT can have as many benches as they want. What is bench? From judges. The judges give judgment to the set of those judges are called as benches. For example, if there are 3 judges sitting and giving the judgment, it's called multiple member bench. 1 judge is giving the judgment, it's a single member bench. From here there is in your portion. Now let us start. Usually in all situation of the NCLT, 2 member will be sitting, judicial member and technical member. But if it is a special class of cases, means light cases are there, then single member bench will be there. But if he is not comfortable with the interpretation, he may refer this to president of the NCLT and then president may refer it to multiple member bench for the judgment. But if very serious issues are there, means it is related to revival, it is related to rehabilitation, it is related to winding up, then at least 3 members bench should be there, in which majority should be the judicial member. See, there are 2 types of member, technical member and judicial. Judicial member come from the legal background. So majority should be the judicial member. And if there is a deadlock, for example, 4 members are there, 2 are saying yes, 2 are saying no, then president of NCLT will appoint 1 member. And obviously his members vote will be decisive. Why? Because if he'll say yes, there will be majority yes, no, then majority no. It's like that. I hope it is clear. Next point. Please understand. When NCLT is there, NCLT will give the judgment. See, what is the purpose, whole idea of forming NCLT? NCLT can give judgment very quick, because see, in the normal civil court, there is hell lot of cases on every judges, allocated to every judges. So the hearing, once you done hearing today, the next hearing will come in 4 or 5 months. So because of that, it used to take a lot of time. But NCLT look after only company cases. So for every judges, the number of cases are very limited. So hearing is very fast, decision come very fast. So this is that NCLT shall dispose the case within 3 months. If they want, they can get extension of 90 days. Technically 90 days is almost equal to 3 months, but be careful in exam, because it is written, you have to write that way only. So dispose within 3 months and extension can be given of 90 days. If you are not happy with the judgment of NCLT, you can go to NICLAT within 45 days, and due to some reason, maybe health or something, you are not able to file within 45 days. Then on genuine ground, you can get the extension for filing an appeal of another 45 days. Again, NICLAT will give the judgment within 3 months and extension can be given of 90 days. From NICLAT, you have to you can straight away go to Supreme Court. Within 60 days, extension can be given for 60 days. Sir, within how much days Supreme Court will give the judgment? Supreme Court can take as many days as they want. Then section 420, if sometime NCLT has given the order, after giving the order, NCLT realizes that there is some error in the judgment. So can they rectify the mistake? So this is, if they are of the opinion that they have given the judgment, but there are some error in the judgment. So can I say they can rectify the mistakes, but then that can be done within 2 years, provided the mistake is apparent in nature. What is apparent? Can I say this is the order copy? This is the order copy. Apparent means if something is visible on face. So if some mistake is visible on face, which is not debatable, then it can be rectified. Fine. But sometime what happens, NCLT has given the judgment and then you went in appeal and the matter is subjudiced to a higher authority, neglect. Now can you rectify the mistake? Answer is no. Why? Because then in that case you are trying to overpower the higher authority. So that is not allowed. Any matter which is under appeal cannot be rectified. I hope it is clear. Then they say that NCLT is not bound by Code of Civil Procedure. See, so basically NCLT has to give judgment very fast, and can I say, if you will see Civil Procedure Code, there is a lot of nitty-gritties in that, you know, because of that they consume hell lot of time. So that's why this is that NCLT is not bound by Code of Civil Procedure, means can I say they can follow their own procedure, everybody, it's like that, so that judgment, they can give judgment very fast. NCLT and neglect may delegate its power by general or special order subject to conditions. So can I say, if NCLT and neglect want to delegate their power, can they delegate power? Yes, they can delegate power to the subordinates or to some other authority by passing general or special order. Then what they are saying, that president of NCLT, chairperson of neglect and members of NCLT and neglect shall be treated as public servant as per Indian Penal Code. What does it mean? See, what happens now, many a time when they exercise their power due to so much of work they do on a very regular basis, there is some chances that they may end up doing some mistakes, they end up doing some errors. So can I say, can they be punishable for that? So they says that, see, if they will be treated as a public servant in Indian Penal Code, so for them it is a shield that if they do anything wrong, but if they have acted in good faith, you know, in that case they will not be punished. So they are saying that yes, they will be treated as public servant under Indian Penal Code, and any act done by president, chairperson in good faith shall not, then in that case he will not be liable for it. So any act done by president, chairperson in good faith, then they will not be liable for it. It is like that. Then can I say, NCLT give lot of judgments, but can I say execution is very difficult, because can I say police and all are under normally control of technically judges only, but then magistrate look after the daily affairs. So this is that NCLT require to exercise its power, then they can take help of chief metropolitan magistrate to exercising. So they can, whatever execution etc is required, they can take help of CMM, chief metropolitan magistrate, for exercising of that power. Civil court have no jurisdiction on or cases pending before NCLT. So what they are saying, that if any cases are pending before NCLT or neglect, then civil court have no jurisdiction. Means civil, if any cases is pending before NCLT and neglect, and you want to take the stay order, so to take this stay order, you cannot go to civil court. Why? Because otherwise what will happen, just for the delay tactics, what people will do, anything pending before NCLT neglect, they will straight away go to courts, so for the stay order. So this is no, civil court have no jurisdiction on the cases pending before NCLT or neglect. Then see, whenever you do something activity, there are some loopholes, there are some errors, those are bound to happen. So this is any inconsistency in any procedure or invalidity in any appointment will not affect the decision already given. So if there is later on you got to know about some inconsistency or something like that, it will not going to invalidate the entire procedure you have done, entire act you have done. So that's all in NCLT, it is completed. Next chapter is removal of name of companies. See, this is the register. ROC has this register in which name of company is written like this. Now what happened, that the company name is written ABC Corporation. What ROC will say, ROC will strike off the name. So can you see, if the name is stricken, like if the name has been removed, means technically now that company does not exist only. Why? Because the name is not there in ROC. So on a technical ground you can say the company is not in existence. So that's called removal of name of company. Now why it will be removed, how it can be removed, or can it be restored? So all these things we will be revising in this chapter. So what they are saying, in this chapter there are two sections, 248.1 and 248.2. See, please understand, under 248.1 ROC will remove the name suo motu, means ROC will do it suo motu, and in 248.2 company will file to ROC that please remove my name. Now why company will file to ROC, that also will learn, and on which ground ROC suo motu remove the name, that also will learn. So please see what they are saying, removal of name by registrar. This is registrar. So on the four grounds, ROC will remove the name of company. First, if you have not started the business, not commenced the business for 1 year from the date of incorporation, your company has been incorporated, but from the date of incorporation for next 1 year you have not done any business only. Now ROC will say, what is nonsense? Why you have incorporated when you don't want to do the business? So they will strike off your name. Or there is no business activity without obtaining the dormant status for 2 years. Sometimes what happens now, you don't do business activity. You started your business, you incorporated the company, you started the business, and then you go on halt. Why? Because you may be working for some future project or something like that. So you don't do any business activity. But then in that situation, you have to take the dormant status. You are not doing any business activity, nor you have obtained the dormant status, and that you have not done for 2 years. Are you understanding? That you have not done for 2 years continuously. In that case, your name can be removed. Subscription fees, if you have not paid. You have not paid, tell me what? Subscription fees. You have to, when you register the memorandum, you have to pay subscription fees. You have not paid, and you are not paid for 180 days. So government says in that case your name will be removed. When there was a physical verification taken place of your company, there was no business activity was there. Means you said that this is my factory and this is everything. You have given the entire information. Now at random government authority came to check, and then they found that there is nothing over there, no business, nothing, just a vacant room. Means, can I say basically you are trying to make the company for hawala, etc. They say that if there is no business activity on physical verification at your office, means there is no activity taken place, they can remove your name. So in 4 situations, name can be removed. From incorporation, no business for 1 year, no business activity for 2 years without taking dormant status, then no business activity on physical verification, and then this thing, subscription fees not paid for 180 days. In that case, what will happen? Registrar will give you STK1. STK1 is striking off of the company. STK1 to company, and will say that we are planning to remove the name because of these 4 reasons. Do you have to say something? Opportunity of being heard will be given. Then the company has to reply within 30 days. But these companies cannot be, ROC cannot strike off these companies. Which company? Listed company. Delisted company means the company which is going for delisting, and vanishing company. These companies are controlled by SEBI, and that's why ROC cannot delist them, cannot strike them. They let the SEBI control them, because it is under the control of SEBI. Any company whose prosecution is pending, don't strike off, otherwise it will be very difficult to complete the prosecution. Or if the matter is under court for compounding, again court is doing something, if it will strike off, the legal existence will go away. It will become very difficult for court to do the compounding. Section 8 company is NGO. So government want these to be dealt in a different way, because obviously they come for non-profit activity. And if the company has taken a public deposit, don't strike off, because let them repay everything and then strike off, that's okay, but not now, because otherwise it will be difficult for the deposit holder only. So in this situation, ROC cannot strike off the company. Fine. Now section 248.2, what I told you, under 248.2, under 248.1, ROC suo moto removing the name of company. Under 248.2, company is making an application to ROC. Sir, on which ground? Same ground which is given in 248.1. That is, from incorporation, company has not conducted any business for 1 year. Company has discontinued their all business activity for continuously 2 years without taking dormant status, not paid subscription fees within 180 days. Same 4 grounds. On that, even a company can make application for removal of name to ROC under section 248.2. Now you will say, sir, why company will make this application? Because please understand, company know that I have done something wrong. Now ROC will come and they will anyway remove my name. It is very humiliating, plus some punishment also they can leave. It is better I will go and I will tell that, see, these defaults I have done, please remove my name. So on these grounds, company can also make the application to ROC. In the given situation, company can make application for removal of name to ROC. What is the procedure? Company will file ROC what? Form STK 2, 3, 4. What is STK 2? In STK 2 they will give fees of 5,000. STK 3 is indemnity bond and STK 4 is affidavit. So these 3 forms they will file. Then obviously it is not applicable to section 8, different procedure for them it is. Then they will undertake that, see, our company's assets are sufficient to pay liability. You want to strike off by this way. So in that case, obviously the company has to be solvent, because government don't want that your company is insolvent and you have strike, like they have strike off, ROC have strike off, and then you are not repaying to anyone. So it will be difficult for others to recover the money. So this is, the company should be the solvent company. Any liability of company and director will not affect due to removal of company. See, let's say now ROC has strike off the name. Now director will say now company is not there, so I am not liable to anyone, or company will say I am not liable. Are no boss. Even if your name is strike off, even after that, the company, even if legally does not exist, still liable to pay for the liability. Directors are still liable for anything wrong they have done. So like that. Then it will be published in the notice, public notice. Then this is STK 5 and STK 6. What? In that, can I say you will place all these informations on website, official gazette, and 2 newspaper, 1 English and 1 vernacular. So you will do these things. That is in 248 2. I hope it is clear. Next is, if these type of companies, following company cannot file application for striking off. Which companies? These companies cannot file application for striking off if they have done any of the given activity in last 3 years. They cannot go for striking off under 248 2. They have changed the registered address from one state to another state. Can I say technically they have changed the ROC. Now this is possible that they must have done something contravention earlier, and recently they have came to new ROC, which may not come in knowledge of the new ROC. So to avoid such situation, this is that if in last 3 months you have changed the registered office from one state to another state, you cannot go for striking off. Or in last 3 months, if they have disposed assets or liabilities substantially, then this is possible now that they may try to run away after taking the money and without paying to creditors, and that's why if in last 3 months you have done this, you cannot go for striking off. If they have engaged in any activity except what is required to expedite application. This is if you are doing something which is necessary to speed up the application of striking off. In last 3 months you have done that, that is okay, but you are doing other activities. So then you cannot come here, because here it is for dead type of company. If you are doing activities, that means your company is alive. So why you want to strike off? Continue with your business. Or if the application is pending for winding up, if the application is pending for winding up, if the application is pending for compromise arrangement, if both are pending before NCLT. Now don't you think if ROC will strike off, don't you think they are technically trying to override the power of NCLT, and that's why they cannot strike off. So in this situation, if these things are happened, then in that case you cannot strike off the company. Next section. 250, effect of company notified as dissolved. See what they are saying, company shall cease to be valid from the date mentioned in the notice. However, it shall be liable to pay liability even after the date of dissolution. What does it mean? Can I say after the striking off, can I say they will mention in the notice that from this date your company will be ineffective. Now can I say the company will cease to exist? But now the immediately question comes in the mind of the student, sir, what about the liability which is already there, whether they are not liable to pay? I have already told you, even if the company's name has been removed, still they will be liable for the liability which is already standing on the date of removal. Section 251, can I say, they are saying that when application is made to evade the liability, then the applicant is jointly and severally liable. A, B, C, there are 3 major shareholders and they are the directors of the company. And now they have applied for removal of the name of the company fraudulently. The whole purpose is to run away from the liability of the creditors, and later on they got to know after the removal of name. So what will be the liability? This is A, B, C will be severally and jointly liable. It means what? If B, C does not have any money, then entire amount will be taken from A. If they have money, then equally will be taken from them, or in the proportion, whatever the ratio they have. So they are saying that they will be jointly and severally liable. What if your name has been removed? So this is when the registrar has wrongfully removed the name, then they can appeal to file NCLT. When the registrar have wrongfully removed the name, then you can apply to the NCLT that please restore my name. Registrar has removed my name inadvertently by mistake, and I have not actually fallen in any of those 4 grounds. So in that, application can be made within 3 years, and if NCLT satisfy, they can restore the name. If the other situation is any other situation, means there is no mistake from the registrar, but on a humanity ground, you are saying that employees are not getting job, this, that, please forgive me. So in that situation, you can make application even within 20 years. So there is no time limit. So in that case, there will be discretion whether they want to restore or not. So that's all in this chapter. Okay, now we are going to discuss penalties. So section 447, what they are saying? Fraud. If the fraud has been conducted, in that case, what they are saying, if the amount involved is less than 1% of turnover or 10 lakhs, whichever is lower, and no public interest is involved. So number 1, the amount involved is less than how much? The amount involved is less than 1% turnover or 10 lakhs, whichever is lower, and no public interest is involved. Public interest is not involved. In that case, it will be imprisonment up to 5 years or fine up to 50 lakhs. That means if otherwise means if this situation is not there. So if the amount is less than 1% of turnover or 10 lakhs, whichever is lower, and public interest is not involved, in that case, how much it will be? It will be imprisonment up to 5 years or fine up to 50 lakhs. But otherwise means if public interest is involved. What I am telling you, if public interest is involved, then minimum 3 years, maximum 10 years. Minimum how much? 3 years, maximum 10 years, and fine minimum 100% of amount involved and maximum 300% of amount involved. If public interest is not involved, then minimum 6 months, maximum 10 years, and same fine. So how will you remember? See, amount involved is less than 1% of turnover or 10 lakhs, whichever is lower, and public interest is not involved, then imprisonment will be up to 5 years or fine up to 50 lakhs. Then this is otherwise. Otherwise means if public interest is involved, then minimum 3 years, maximum 10 years, and not involved, then minimum 6 months, maximum 10 years, and fine is same for both, minimum 100%, maximum 300% of amount involved. See, I'll tell you one thing. Then say minimum 100% means if fine is 1 lakh, if the fraud is of 1 lakh, minimum 1 lakh, maximum 3 lakhs. It's like that. Fine. Then this is general penalty. What is the general penalty? So this is wherever the penalty is not specified, you will use this. So for company it is 10,000 plus 1,000 per day. And if the offence is of continuing nature, obviously 1,000 per day, but it can go total up to 2 lakhs. So it is not, it is 10,000 plus so and so amount, but total it cannot go more than 2 lakhs. And for officer in default, 10,000 plus 1,000 per day, that is 10,000 plus 1,000 per day, so but total it can go up to 50,000. So it is like that. So it is not 2 lakh plus 10,000, it is 10,000 plus 1,000 per day, which can go up to 2 lakhs. And for officer in default, 10,000 plus 1,000 per day, which can go up to 50,000. What if there is a repeated default? If what is repeated default? So let's say if the same offence you have repeated within 3 years, then this is the fine will be double, but imprisonment will be same. For example, any punishment is risen up to 2 years or fine up to 50,000. So if you repeat that offence again within 3 years, then next time the court can levy up to 2 years imprisonment, but the fine can go double, that is it can go up to 1 lakh. Or if it is 30,000, then it can go up to 60,000, like that. I hope it is clear. So if you repeat the same offence again, imprisonment tenure will be same, obviously, because sometimes the imprisonment is 10 years. You will repeat next time, they will not send you in jail for 20 years now. That will be too much. So this is imprisonment will be same, but the fine will be double, like that. Then while determining the quantum of penalty, a person shall consider what? Whenever you are deciding penalty, what you will consider? The size, nature of the company, damage by the public, nature of default and reputation of default, all these things. Then this is if the default incurred in penalty and imprisonment in this section. 1-person company is there. If small company is there, startup and producer company. For these companies, this is the normal penalty, whatever you have studied now at every places. For these companies, that is for 1-person, small, startup and producer company, this is it. The punishment will be half. And that too, it can go up to maximum 2 lakhs and officer in default maximum 1 lakh. So if the natural punishment is 3 lakh, So for company it will be 1.5 lakh only. If it is 6 lakhs, then half will be 3 lakh. It will not be 3 lakh. It will be maximum up to 2 lakhs. And for officer in default, it will be maximum 1 lakh. So the different penalties you have studied in Act. But if it is one person company, if it is small company, if it is startup company, if it is producer company, then in that situation what will happen? In that situation they are saying that whatever punishment will be there, it will be half of that. Fine. So whatever, it will be half. But if half is coming more than 2 lakhs for company, then it will be up to 2 lakh only. If half is coming less than 2 lakh, then that amount. But more than 2, then 2. And for officer in default, if half is coming more than 1 lakh, you will take 1 lakh. If it is less than 1 lakh, then that amount, whatever like that. So it is like that. So it is completed. So finally, penalty part is also completed. Now we are starting with securities and economic law, in which the first topic which will be beginning is insolvency and bankruptcy code. What is the background of bringing insolvency and bankruptcy code? Earlier there was lot of laws used to be there related to insolvency and related to liquidation. But the problem was, due to multiple laws, they used to consume lot of time. And because there was no clarity of who will be the adjudicating authority and under which law I have to go, and there was no time bound procedure was there. Along with that, there was a real life problem. What was the real life problem? No revival procedure used to be there. There used to be mostly focus on liquidation. So we needed a law where there is a time bound procedure, there is a clarity, and there is also a revival procedure. So that is what given in Insolvency and Bankruptcy Code 2016. So first of all, 2016 means it has been notified on 28th May 2016. Why the name is code? When the law has a vast variety, we use the word code. For example, civil procedure code, criminal procedure code, like that. So why it is called as code? As I told you, there used to be lot of law and there was no clarity. Because of that, huge amount of time used to go in doing all these things. So they brought single law who was looking about individual as well as non-individual or corporate people related to their insolvency and revival procedure. And so how they have brought it? Earlier there used to be a multiple laws of insolvency. They have deleted those laws. Multiple laws they have deleted, and multiple laws they have amended, and their insolvency part they have removed, and they brought all the laws under one roof, that is under IBC, Insolvency Bankruptcy Code, and that is why it is called as code. So which laws they have deleted? So Presidency Town Insolvency Act, Provincial Insolvency Act, and Sikh Industrial Companies Act. These are very old laws. In fact, Presidency Town Insolvency Act, Provincial Insolvency Act is more than 100 years old law. So they have deleted these laws and they have brought all the features, all people under these laws under IBC. Then they have amended Partnership Act, Recovery of Debt Due to Bank and Financial Institutions Act, SARFAESI Act, and Companies Act. So now those laws are deleted? No, those laws are not deleted. These laws are still there. Partnership Act, Recovery of Debt Due to Bank and Financial Institutions Act, SARFAESI Act, Companies Act are still there. But their insolvency portion they have deleted and they have brought under IBC. As far as Companies Act is concerned, under Companies Act still there is a insolvency portion is still there, but the voluntary they have brought under IBC. So now these are not important from exam point of view. I have just given you the reference. Now let us understand what is the meaning of insolvency and bankruptcy. So what is insolvency? Insolvency is a state or position where liabilities are more than assets. So when your liabilities are more than assets, we call it as insolvency. It's a situation. Court has not declared us insolvent. It is only the situation where we know that yes, our liabilities are more than assets, and it is an alarming bell. And if we will not do anything, subsequently we may be declared as insolvent. So it is by the court. So it is a state or position where liabilities are more than assets. And if it is treated means if you make the revival plan to recover the company. So if you will make the revival plan, there is a two possibility, or you don't make any revival plan. So revival plan is called as resolution plan in this topic. So if it is treated, that means you can make the revival plan, or you may not treat it, means you will not take any action. So if it is untreated, then it will lead to liquidation for corporate and bankruptcy for non-corporate. Because non-corporate cannot liquidate. Now I am an individual, I cannot liquidate, so I will become bankrupt. But if it is a company, it will liquidate. If it is non-company, then it will become bankrupt. So now let's conclude. Insolvency. What is insolvency? It's a state or position where liabilities are more than assets. Now there are two possibilities. You may make the revival plan or you may not make the revival plan. If you are making the revival resolution plan, fair enough. If you are not making it, then because of that, it will end up what? It will, if it is untreated, it will lead to liquidation for corporate and bankruptcy for non-corporate. So this is what we have understood, insolvency bankruptcy code. Now before entering into the topic, I will teach you the entire background of IBC very quickly, the entire procedure, not background, entire procedure of IBC, because then when we'll start revision, you will get the quick flow in that. So now understand, under IBC your financial situation is very bad. So first what will happen? First, financial creditor, operational creditor, corporate debtor will come in picture. And what financial creditor, operational creditor and corporate debtor will do? They will make the application to NCLT. Now first question is, sir, who is the financial creditor? The person who has given the loan is the financial creditor. For example, Kingfisher is under under revival. So can I say SBI has given the loan to Kingfisher. So SBI will be the financial creditor. ICICI Bank, say let's say, has given loan. So ICICI Bank will be the financial creditor. So financial creditor will give the loan to NCLT, and along with that they will give the name of insolvency professional. Now who is insolvency professional? That I will tell you in 2 minutes. And also, who can give the application? Operational creditor. Who is operational creditor? Any person who is generated out of business operations. So, for example, let's say as far as company is concerned, can I say, for example, Kingfisher. In Kingfisher, air hostess, who is the employee? Can I say, if their salary is pending, not paid, then that employee will be treated as operational creditor. They must have taken some petroleum, etc., some lease property, so rent is supposed to be paid. So those people are treated as operational creditor. Who is corporate debtor? Kingfisher itself is the corporate debtor. Now you say, sir, why Kingfisher itself will file the application? Because this topic is not just about liquidation. In fact, liquidation is a very smaller part. Here the major part is of revival only. And can I say, corporate debtor may wish for revival, so they will file application for revival itself. So three people can make the application: financial creditor, operational creditor, corporate debtor. While making the application, they will give the name of insolvency professional. Now who is the insolvency professional? They are the people who are expert in doing all the legal procedure and revival of the company. So they are the basically professional. Any CS, CMA after qualification and having a 10 years of experience, they will go and they will write an exam and they will become IP, insolvency professional. So these are the expert people who are who all are primarily CS, CMA, advocate, and who passed their exam conducted by IBBI and become IP. IP is an insolvency professional like a CA only, but a senior one who has a great knowledge of doing these things. So they will give the name of IP to NCLT. Now what NCLT will do? NCLT will appoint this IP as interim resolution professional. What is resolution professional? He is the person who do the revival process. What is the relation between insolvency professional and resolution professional? It's like same CA and auditor. Can I say CA is the qualification, auditor is the designation. You get appointed as a auditor in some company. Same way, can I say IP is a qualification and RP, resolution professional, is a designation. You get appointed as a RP in some company for revival process. So can I say, they will give name of IP and he will get appointed as resolution professional. But you will say, sir, you have not written resolution professional, you have written interim resolution professional. So there is a difference actually. What happens, you know, here the entire control is given in the hands of creditors. So who has the authority to appoint the resolution professional? Committee of creditors has the authority to appoint the resolution professional. But the problem is, for that you have to constitute committee of creditor, and for that you have to call the committee of creditor. So what happens? IP will come in picture. They will what NCLT will do? NCLT will appoint IP as an interim resolution professional, and then they will call the creditors, and then the creditors will appoint resolution professional. Sir, can they appoint this IRP as RP? Yes. Sir, they can appoint, can they appoint some other person as RP? Yes, both are allowed. So for that, can I say, for timing, that's why it is called as interim, because yet this is not yet, he is not yet finalized by COC. So now NCLT is appointed, NCLT has appointed IP as IRP. Now this IRP will do the public announcement, and in that public announcement what they will say, And why they will do the public announcement? Because obviously now you have to do revival. So you will call creditors, you will take their claim, you will form the committee of creditor, you will do entire revival process. So can I say, they will do the public announcement in which they will give the name of company, name of interim resolution professional, by what date you can make the claim. That is very important, because otherwise anyone will come at any time. So by what date, last date up to which you can make the claim, and then you have to write the deterrent, that what will be the penalty for false claim. Otherwise anyone will come and will make any random claim even if he is not creditor. So what will be the penalty of claim, and by what date the resolution process will get over. Let me tell you, 180 days is the time normally by which your resolution process shall get over. So but then you have to mention that last date up to which the resolution process, that is the revival process, will get over. That entire thing you will put in public announcement, and after that the creditor will come to know, okay, this company is undergoing under revival process and I am the creditor of this company. So the creditor will come and he will submit his claim to interim resolution professional. Now what interim resolution professional will do? Interim resolution professional will verify the claim. Interim resolution professional will verify the claim given by the creditors, and after verifying the claim, they will form committee of creditor. So once they have constituted committee of creditor, what COC will do? Committee of creditor has been formed. Now what committee of creditor will do? Can I say they will appoint RP, resolution professional. Sir, can they appoint IRP as RP? Answer is yes. Sir, can they appoint some other insolvency professional as RP? Answer is still yes. But for doing anything, they have to pass 66%, at least 66% in value resolution. And then they can either appoint IRP as RP, or they may appoint some other person as RP. Both are, some other IP as RP. Both are allowed. Then after once RP formed, now what RP will do? RP will prepare information memorandum. Now here the most important thing, please understand, for revival of any company, what is the most important thing? So for revival of any company, the most important thing is money. So there has to be someone who will give you the money. The people who come and give the money is called resolution applicant. Sir, why they will give the money? Because they will take control over your company. Sir, why they will take control over your company? Because they have believed that your company is good enough and it will grow in future. For example, Bhushan Steel was under resolution process. So Tata Steel came, they gave money to Bhushan Steel and they have taken control over Bhushan Steel under IBC process. So here the person who give money and take control over your company is called resolution applicant. For example, in case of a Bhushan Steel, was under IBC, so Tata Steel was the resolution applicant. But the problem is that resolution applicant will give you money after, means will give you money. Why? Because they have a belief that your company can grow and they will earn well in future. So now don't you think they have some ideas also? And that's why resolution applicant, that is in case of Bhushan Steel, I am talking about Tata Steel, will prepare the resolution plan. What they will prepare? Tell me fast. They will prepare the resolution plan. Now this is nothing but the revival plan. But to make revival plan, don't you think they need a lot of financial information of the company? So what RP will do? He will prepare information memorandum. This resolution professional, like CA kind of person, you can visualize whenever I say RP, resolution professional. So he will prepare the information memorandum, which will contain the financial information as well as the information required by the applicant. Applicant means resolution applicant, and they will provide this information. And resolution applicant, that is Tata Steel, if the Bhushan Steel is under revival process, they will prepare resolution plan, that is revival plan. But the problem is, they will be knowing the plan, but they will not be having the entire knowledge of law, and it might possible in that plan there is some violation of the act. So what will happen? Again this revival plan, resolution applicant will give to RP, resolution professional, and now the resolution professional will verify whether all acts have been complied or not, whether IBBA guidelines have been complied or not in resolution plan. And after that, this plan will be submitted to committee of creditor, and committee of creditor after that will approve it by 66% in value, and then this will go to NCLT. This plan will go to NCLT. Now there are two possibilities. NCLT may approve this and then resolution process will start, and may reject it. If they will reject it, then liquidation process will start. So the entire procedure is like that. I went very quickly because anyways all this procedure will come in detail in topic. Now let us start. These features and these are extra things. Straight away come to regulatory mechanism. Now Regulatory mechanism. Please understand, insolvency bankruptcy code. And now there are two structure in this. First is regulatory, second is adjudicating authority. See, any act is there now, whenever any act formed. So there are always two authorities. One who control the mechanism, and one who give the judgment. So here the controlling authority is IBBI, Insolvency Bankruptcy Board of India. Like in case of banks, it's RBI, like this. In IBC, it is IBBI. They have a three function: legislative, executive and quasi-judicial function. And they will exercise all these three functions on IP, IPA and IU. Now what is IP, IPA and IU? IP is an insolvency professional. They are like, as I have already told you, when CA, CS, CMA, after qualification, when they have a 10 years of experience, they can go and write an exam of IP, insolvency professional. And if they pass that exam, they will be qualified to be called as IP. And then they can work as a revival person, resolution professional under this act. So this is IP. What is IPA? Insolvency Professional Agency. It is same like relation between CA and ICAI. So if you will take it IP as a CA, then IPA, Insolvency Professional, as a ICAI. Understood? And IU is what? Information utility. Basically, it is nothing but you can say it's a data bank where all informations are stored properly. So that is called what? That is called IU, Information Utility. Now please understand. So obviously, can I say IBBI will going to control these three people, these three person, IP, and IU. And please understand, IPA, why IPA has been formed? Can I say IPA control? I mean ICI control CA. Same way IPA will control IP. And IPA will exercise legislative, executive and quasi-judicial function. What is the legislative function? So they will draft code of conduct. What is the executive function? They will monitor the wrongful act of IP. And what is quasi-judicial function? So they will address the grievances against the IP. So can I say all these functions, anything same way, can I say ICI make code of ethics for CA. So the IPA will draft the code of conduct for IP. Same way, whether CA is working properly or not, they are not doing anything wrong. So those things are, who check this? ICI. Same way IPA will check it for IP. And quasi-judicial means if you have anything grievances against CA, you go to ICI. Same way, if you have any grievances against IP, you will go to IPI. So can I say technically IP is controlled by two persons? One is IBBI and one is IP, like this. Now next is who is the adjudicating authority? Who is the adjudicating authority? So can I say they are like a court. So if any corporate person has any problem, they will go to NCLT. From NCLT, they can appeal against NCLT to neglect, and then they can go to Supreme Court. As far as non-corporate is concerned, they will go to DRT, and if that is that recovery tribunal. And if they have anything against that, they can go to DRAT, and then they can go to Supreme Court. It's like that. These are just for understanding. Now, what is the structure of this code? There are total 255 sections are there, 12 schedules is there, and 5 parts are there. What is 5 part? Part 1 is preliminary. Part 2 is insolvency resolution and liquidation of corporate person. Insolvency resolution means revival from insolvency. But if revival from insolvency is not possible, if it is failed, then it will lead to liquidation. And liquidation means it will be of whom? Corporate person. Part 3 is insolvency resolution and bankruptcy of non-corporate person. Now can I say, please understand, if you will do revival of insolvency, and if revival of insolvency fails, then it will lead to bankruptcy. And for bankruptcy, whose bankruptcy take place? Non-corporate person, for example individual. So that is there in part 3. Then there is another part also, PPIRP, and then there is a part 4, IP, IPAIU, Insolvency Professional Agency and Information Utility. Again, all the information related to these three persons is covered in part 4. And part 5, they are talking about miscellaneous provisions. So these are 5 parts which is divided. Then now there is nothing like Jammu Kashmir applicability. So now all part is applicable across India, including Jammu Kashmir. To whom this law is applicable? This says that it is applicable to individual. It is also applicable to personal guarantor. Who is the personal guarantor? For example, loan has been taken by Kingfisher. So Vijay Mallya has given the guarantee. So Vijay Mallya will be the personal guarantor. So it is applicable to personal guarantor also. To proprietorship firm. technically proprietor is not different than an individual, but under IBC they have been categorized as a different person also. So even to them it is applicable. Then to a partnership firm, LLP, company, special act, for example ICI, even they will, but they will never become insolvent, but like that. And body corporate. Now I have arranged it in a manner that you can simply remember. Can I say from a smaller entity to a bigger entity, individual, personal guarantor, bigger proprietorship firm, bigger than that partnership firm, then LLP, then company, then special act. Body corporate includes everyone, so like that. So it is applicable to individual, personal guarantor, proprietorship firm, partnership firm, LLP, company, special act, body corporate. It is not applicable to whom? So it is not applicable to these 7%. Number 1, it is not applicable to bank, financial institute, asset reconstruction company. So please understand, it is not applicable to number 1, bank, number 2, financial institute, number 3, asset reconstruction company. Why it is not applicable to these 3 people? Please understand. Can I say they have a separate authority, RBI, they control them. So it will not be controlled by this one. Then asset reconstruction company means, you know, hope you know, they purchase loss making NPAs and then they try to recover it. Then it is not applicable to mutual fund and collective investment scheme because they are the intermediary, they are controlled by SEBI. And it is not applicable to insurance company and pension fund because they are controlled by IRDA. So like that. Now one by one we will learn. We will start with the topic now. So can I say, I told you who will going to make the application under this act. So application can be made by financial debtor, application can be made by operational debtor, application can be made by corporate debtor. So application can be made by these 3 persons. So first, when the financial debtor is making an application. Now please understand one thing. When I say you financial debtor means what? The person who has given the loan. So that means in case of a Kingfisher, who has given the loan? SBI. So SBI will be financial debtor for the Kingfisher. So when financial debtor will make the application, first of all application will be made to whom? So can I say it's a company, it's a corporate person, so it will be made to NCLT and he can make it himself or as well as jointly. Means what? 2 financial debtor can go together and can make application, or independently even single financial debtor can go and make the application. If when they will make the application to NCLT, they have to provide 3 information. Number 1, records of default. Can I say this I told you all the details of everything is there in IU, information utility. So what they will go, they will take this information from IU and this information they will give it to NCLT. Along with that, they have to give the name of insolvency professional like CA, etc. The person who has qualified to become IP, they will give the name of IP and then other information as required, and the application will be made in form number 1. After the application is filed to NCLT, NCLT has to confirm within 14 days. So NCLT will decide whether they want to accept the application or reject the application. If when the application will be rejected by NCLT, if the application is incomplete, you have not given the proper information, or the name of IP which you have given against that person, disciplinary proceeding is pending. So you have given the name of IP and against that IP, the disciplinary proceeding is pending. Or if default has not occurred only, so means then why he has filed the application unnecessarily? There is no default. He is feeling that the default may occur, but there is no default at all. So in this situation, they will reject your application, and then this is that FC, and then they will communicate with you. Then this is that FC can rectify the defect within 7 days from the date of receipt of notice. Whenever the financial debtor will receive the notice, from there within 7 days they can rectify the defect. But the problem is, now you will say, sir, when he will rectify the defect? You can say if a default has not occurred, then there is nothing that you can rectify. But imagine if application is incomplete and because of that application is rejected, then FC can rectify the defect, they can complete the application and they can resubmit it. But that has to be done within 7 days from the date FC has received that notice from NCLT. Now the next point, when application can be accepted. So if application is complete, no disciplinary proceeding is pending against IP, if default has occurred, then if all 3 situations have been fulfilled, then they will accept the application, they will communicate it within 7 days to financial debtor and corporate debtor. Sir, why corporate debtor? Because you are carrying the proceeding against whom? You are carrying the proceeding against corporate debtor. So the corporate debtor shall have the knowledge that a proceeding is going against them. So you will communicate this to financial debtor and corporate debtor. Now next point, sir, can the application be made by operational creditor? So answer is yes. Application can be made by operational creditor. When operational creditor will make an application, this is that operational creditor can make the application himself. Means no 2, 3, 4 operational creditor will go and they will make the application. They have to make it independently. If when they will make application, here very important point. If you will see financial creditor, they can straight away make the application. They can straight away make the application to financial creditor. But for operational creditor is concerned, they cannot make the application straight away. Why? Because technically operational creditor are normally smaller. As I gave you an example of employee, etc. The claim is not normally very big, and that's why this is that first you have to ask the money to corporate debtor. Don't waste the time of NCLT straight away. Ask the money to corporate debtor. So can I say they have to send demand notice or invoice in form 3 and form 4 to corporate debtor, and corporate debtor has to reply within 10 days. Now within 10 days either corporate debtor will tell them that see we have already paid you. They may send the copy of attested checks and all details, or they will say, boss, the thing which you are telling me, I have already disputed this. See, this dispute is pending. Now, not necessary that it is pending before court, but there has to be a genuine dispute. So they will say, see, this is already disputed. Why you are claiming this amount? So it can be either paid or it can be proved that it is already disputed. So corporate debtor will say, see, this is paid. Or corporate debtor will see this is already disputed between us. Dispute can be related to quality, payment or warranty. So if it is paid or if it is disputed, then in that case no application can be filed to NCLT. But what if it is not paid and it is undisputed? Again I am repeating, what if it is not paid and undisputed? So this is that if it is not paid or if it is undisputed, in that case you can make the application to NCLT. So what I am telling you, if it is not paid and if it is undisputed, then you can file the application to NCLT. Now when you will file the application to NCLT, 4 things you will file. Number 1, you will give invoice to prove that your debt is genuine. You will give the affidavit that dispute is not pending. See, please understand how NCLT will come to know that there is no dispute, and if it is disputed you cannot file now. So you have to give the dispute that you have to give the affidavit that dispute is not pending. Then you have to give the certificate that the payment is not received. For example, if I am working in XYZ organization since 6 years and I say that I have not received the payment, so I will give my bank statement to prove that I have not received the payment XYZ amount. So certificate that I have not received the payment. But if it is available, means if you are a non-resident and you don't have that bank certificate in India, then you will not file it. So you will give certificate if it is available and other information. Again, when NCLT got this, NCLT has to confirm within 14 days. Now within 14 days, they can reject the application for the same reason. If the application is incomplete, if the disciplinary proceeding is pending against IP. Now see, here giving the name of IP is not compulsory. So if the name is not given, then there is no problem. But if the name is given and if the name, the disciplinary proceeding is pending against IP, then also it can be rejected. Or if the default itself has not occurred, then in that case they will communicate. If they will reject, then they will communicate to OC, then this is that OC can rectify the defect within the period of 7 days from the date of receipt of notice. Same procedure. If application is accepted, means application is complete, disciplinary proceeding is not pending against IP if the name of IP has been given and default has occurred, then they will communicate within 7 days to OC and CD. I hope it is clear. Now next is when corporate debtor can make an application. See, in the law they have written corporate applicant. Why? Because when I say corporate debtor, actually 4 people can make the application. One, corporate debtor himself can make the application, or any person who has been authorized to make the application. Fine. For example, partner or company's managing director is authorized to make the application. So even they can make the application, or any person who is having the control over the corporate debtor. For example, promoter, they can also make the application. So they have used the word corporate applicant. So corporate, but for a general layman understanding, we will write corporate debtor. So corporate debtor can make the application to NCLT. Now you will say, sir, why he will make the application? Because let's say he want to revive the company. So corporate debtor himself can make the application, but such application can be made only on commission of default. Obviously, if there is no default, then why he will make the application? So on commission of default, they can make the application to NCLT within 14 days. And while making the application, they will give books of accounts information, not the entire books of accounts, that will be huge. So books of accounts information they will give the name of IP. They have to pass special resolution of the shareholder if it is a company. If it is LLP, then 3/4 of partners approval, that will be filed and other information. So once you have filed this, within 14 days NCLT will confirm, either they will accept the application or they will reject the application. Now, can I say again, when they will reject the application, if the application is incomplete or disciplinary proceeding pending, they will reject and then they will communicate. Now this thing, corporate data, not OC, corporate data can rectify the defect within 7 days from the date of receipt of notice. If they may accept the application, if application is completed and this thing, disciplinary proceeding is not pending against IP, and then it will be communicated within 7 days to corporate data. So this is what we have already studied. Now, there are 4 situations when application cannot be filed. There are 4 situations when application cannot be filed. Which are the 4 situations when application cannot be filed? This is if company is already under resolution process, application cannot be filed. Means, can I say the company is already under resolution process and now financial creditor is going, they are saying that we want to file application for CIRP, corporate insolvency resolution process. They will say, but it is already under CIRP, but still we want to file. Get lost. Can I say, if it is already under CIRP, we will anyway get money along with others, why you want to file the application again? Or if the resolution process completed in last 12 months. See what happens now, after resolution process get completed, it takes some time to get settled down, and that's why government has kept the cooling period of 12 months. This is that, yeah, if your resolution process is completed in last 12 months, you cannot make just immediately again application. So you have to wait for another 12 months, then only afterward you can make the application for resolution process. If FC and CD has violated the resolution plan in last 12 months, one said, yeah, you are a regular offender, you have violated, so much of effort has been taken to prepare resolution plan and you have violated the resolution plan. So in that case, you cannot make the application. What if 12 months has elapsed? So government feel that after the passage of time, people improve. So they says, okay, if 12 months has already elapsed, now you can make the application. But in last 12 months, within last 12 months, if you have violated any resolution plan, then you cannot make the application. If the company is already under liquidation, and now see, we are talking about revival plan. Revival plan is for someone who is alive. If the company is under liquidation, means company is dead. Now you have to do the Antim Sanskar. You have to go for the funeral. You cannot revive the company. So it's like that. I hope it is clear. In 4 situations, you cannot make the application. When the resolution process will deemed to be commenced. So this is when the NCLT has accepted the application. It will be deemed to be commenced. Now you must be thinking, sir, why it is given? I told you IBC should be completed ideally within 180 days. So that 180 days will start from when? So can you say from the date NCLT has accepted the application, because the date that date will be treated as if resolution process has been commenced. So can you say that day will be the day 1, and from there you have to count another 180 days. I hope it is clear. Next concept we are going to discuss is moratorium. Now what is the moratorium? Please understand. What they are saying, please understand what they are saying, that what happens, see in the real life, when NCLT accept your application, fine, your NCLT has accepted the application. After that, can say revival process will start, but during that process, if you will keep on disturbing the company, then don't you think then the company will not able to get properly revived? And that's why there are certain activity which is possibly may disturb the company for revival will be kept on hold for certain period during CIRP, and that's called moratorium. So certain activities in moratorium will be on abeyance, not absence, abeyance, that is on hold, and that moratorium is usually for 180 days. Then this is that what will be on abeyance, cases against the corporate debtor. So any cases which is pending against corporate debtor, that will be on hold. So the cases will be cancelled, no, it will again start, but during moratorium there will be no hearing, it will be on hold. Then dealing in assets, Can say if the CRP is going on, then during that period company cannot deal in assets. Sir, why sir? Yeah, otherwise what will happen during this thing CRP process? They will sell all the assets and they will run away from the company, because if they know that they will not going to revive, they may sell the assets. They will take the money, they will run away from the country. Vijay Mallya, Nirav Modi. So this situation should not come. So this is, they cannot deal in assets. Enforcement of security interest by ARC. Now this topic is not there in your syllabus in paper 4. So you may not understand this properly. But just to tell you this, I will tell you like this. See, let's say your company has taken loan from some bank and your company has kept some asset on mortgage. Now if your company has made some default and they have not repaid, then what that bank will do? A bank will either try to recover, or second choice is bank will sell this your NPA, because the bank has given you the loan. For you it is liability, for bank it is asset, but for bank it is a non-performing asset. So bank will sell this non-performing asset to asset reconstruction company, and now the asset reconstruction company will come and they will try to recover money from you. And now this is that if the company is in CIRP, ARC cannot come and recover money by enforcing the asset, means taking out the mortgaged asset. Why? Because government says that boss, anyway they are doing the revival process. If it is revived, then anyway the ARC will get the money. Sir, what if it is not revived? Then after that you can anyway take that asset, but during moratorium, during CIRP process, please don't take this asset. Then recovery of asset which is in possession of corporate debtor. Means what? You can say corporate debtor has taken some property on lease, and now the company is under CIRP and you have the corporate debtor has not paid the rent. So the lessor will come and take that asset which is in possession of corporate debtor. So this is wait. See, you have not got the rent, we understand, and that's why you are angry. This is that wait, let the CIRP get over. If the company get revived, anyway you will get the money. If not, then you can take the assets afterward. So it is like that. So these 4 assets will be on hold. But certain activity will not be on hold. Which activity will continue during moratorium? Supply of goods and services which is essential. For example, 3 are given in rules: electricity, water supply, telecommunication. Because 3 are lifeline. Again, electricity, water supply, telecommunication. These 3 are lifeline. Now don't you think if you will stop these 3 activities, it will very heavily damage the company and company may not able to revive. So these 3 activity will continue. Any activity which central government feels it is necessary, then they will consult with financial sector regulator, that is SEBI and RBI. SEBI, they will consult with them and they can tell that this will continue. The moratorium is on the company and not guarantor. For example, during moratorium, I cannot take action against Kingfisher, but I can always take action against Vijay Mallya, because Vijay Mallya was the guarantor. This law has brought because of these people only, because what used to happen, you know, during CRP process, we used to keep moratorium on company, and then the guarantor, they know that the company will not pay, then they will catch me. So they used to run away within that period. So they says that boss, during moratorium also we can take action against guarantor. Then there are some amendment. This is that during moratorium, I have written it on the last page, that during the moratorium, no license will be suspended, and it is obvious. See, if you will suspend the license during moratorium, the company will not be able to do the business only. Then how they will revive? So this is that licenses will not be suspended during moratorium, and anything, any activity which IRP or RP feels critical, they feels that it is very important to continue. So even with the even IRP and RP can continue those critical service which they feel to be critical during moratorium. So this is like that. Now the next point, how you will going to appoint IRP? How you will going to appoint, tell me, IRP? This is financial creditor and corporate debtor. Again I am repeating what they are saying. Financial creditor and corporate debtor, they will give name of IP to NCLT. So financial creditor and corporate debtor will give what? Name of insolvency professional to NCLT. For them it is mandatory na. NCLT will appoint that IP as IRP. Only condition is that no disciplinary proceeding should be pending against that IP. So NCLT will appoint that IP as IRP. As far as operational creditor is concerned, there are 2 ways. See, operational creditor, for operational creditor it is option. If they wish to, they can give the name of IP. If they not wish to, they may not give the name of IP. So now let's assume that they are giving the name of IP. Then NCLT can appoint that IP as IRP provided no disciplinary proceeding is pending against that IP. But what if the name is not given by the operational creator? Then in that case what will happen? NCLT will refer this to IBBI. They will say give us some name of IP. IBBI will give the name of IP to NCLT, and then NCLT will appoint that IP as IRP. So it is like that. Next, what are the powers of IRP? So the code is C Mary power. That means what? C stands for compliance of act. M stands for, so all the compliances of the law, which was the earlier responsibility of board of director. Can say once the IRP will come into the picture, IRP has to do all these legal compliances. So all the annual return filing, all statutory will be done by the IRP. When I say will be done by IRP, means IRP will have the ultimate control, but obviously he will get the things done from the other employees of the company, but he will be having the ultimate control. So it is the responsibility of the IRP to do the all compliances. Then management of affairs, all the control earlier of the management was with BOD, now it will be with IRP. Then exercise the power of BOD partner. So obviously if it is company, then power of BOD will vest with IRP, and if it is LLP, then powers of partner will now vest with IRP. Then earlier reporting of officer manager, earlier officer manager used to report to BOD and partner if it is LLP, but now this officer or manager will report to IRP. And can say instructions to financial institute. Now what is the meaning of that? Can say Kingfisher. Kingfisher has the account in ICICI Bank. Now can I say it is a current account for Kingfisher and it is an asset for the Kingfisher. Kingfisher will use this bank account to make the payments. So for Kingfisher it is an asset. Now who will give instructions for check signing and everything? Earlier it used to be done by board of director of the Kingfisher, but now all the instructions to that ICICI Bank for related to payments and everything will be given by whom? Will be given by IRP. I hope it is clear. Now what is the tenure of IRP? So they says that IRP will continue till the appointment of RP. So till the period IRP does not come, IRP will continue. Fine. Now appointment of RP, how RP will be appointed? So there are two possibilities in this. Number one, you can say you may appoint IP as RP as well as you may appoint IRP as RP. You want to appoint IRP as RP, then in that case 66% in value of COC along with the written consent of IRP will be taken, and once it is done, appointment of RP is effective. So what they have said, that you want to appoint IRP as RP, so what you will do, 66% in value of voting share of COC will be passed, and you will take written consent of IRP, because obviously you have to ensure that IRP whether you want to continue as RP or not. So you will take his written consent and plus 66% in value voting share. If it is passed, then IRP will become RP. But assume you don't want to appoint that you don't want to appoint that IRP as RP. You want to appoint some other IP as RP. Then can you do this? So this is yes. Even another IP can be appointed as RP, but then what will be the procedure? This is, in that case, COC will take out the name of IP. For taking the name of IP, they will pass 66% in value, and they will take written consent of the IP whom they are proposing to appoint as RP, and after passing that 66% in value, taking written consent, taking the name of IP, they will send it to NCLT. NCLT will give it to IBBI, and IBBI will tell within 10 days that whether any disciplinary proceeding pending, whether any disciplinary proceeding is pending against that IP or not. Now till the period, if it is not pending, then NCLT will appoint that person, that IP as RP. But till the period that IRP get appointed, who will going to continue in the company? The old IRP will going to continue in the company. So it is like that. Now, what are the powers and duties of resolution professional? So I have given you the code C Ali Ram. C Ali Ram. Fine. So what are the powers and duties of RP? So this is, they will take the custody of asset. See, if RP came in the company earlier, if the IRP is different and RP is different, then the custody of the asset must be with IRP. So now who will take this custody? RP will take. Then act on behalf of corporate debtor. Earlier whatever act need to be done by the corporate debtor, it used to be done by BOD or partner. Now it will be done by RP. Then list of claim, they will prepare list of claim. Now someone will say, sir, but it must have already prepared by the IRP. But don't you think IRP must have raised some extra funds, etc.? So again it will be prepared. So list of claim will be prepared. Then as I told you, what is the main job of RP? To facilitate for revival process, and for that case the resolution applicant will prepare resolution plan, and for that resolution applicant need information memorandum. So this information memorandum will be prepared by RP. Then again during that for some working capital, if any interim finance is required, then that also will be raised by RP. Then can I say inviting prospective lenders, investors. So can I say we will call, so that we will call resolution applicant, RP will call resolution applicant. See, in case of Bhushan Steel, I told you Tata Steel was the resolution applicant, but not just the Tata Steel has applied. There was even other resolution applicants were there who has applied. So for that can say they have to they need to be invited. So the resolution professional will invite all the the resolution professional will invite all the prospective lenders. Then can I say after that, let's say there are 4 or 5 resolution applicant came, so they all will prepare the resolution plan, and all the resolution plan prepared by all the resolution applicant will be presented by whom? Will be presented by a resolution professional to the COC, and obviously out of those whichever got the highest vote will be approved now. Then this is a point of professionals. If while exercising his work, there is a possibility that RB may not know everything. As I told you, he will act on behalf of corporate debtor. Now let's say lot of return filings etc. work will be there, and it might be possible that he come from a different background, not the CA background. Then he may not know that activity. So he may appoint professional to exercise those duties. Then avoidance of transaction. Later on I will be teaching you 3 activity: preferential transaction, then undervalue transaction, extortionate credit transaction. These are avoidance of transaction, and if these transactions are as happened in company, then it is the duty of RP to inform these transactions. So avoidance of transaction they will do. And then if there is a meeting of COC, even the RP will attend such meeting of COC. Then the next point is saying conditions for appointment of RP. How the RP can get appointed? What are the conditions to become RP? This is that RP can be appointed only if he satisfy the conditions of independent director. Under Companies Act you have studied under 149(6). Those are the conditions given to become independent director. This is that RP need to fulfill those conditions. RP need not be independent director. In fact, RP is not the independent director. What I am trying to say, that whatever the conditions are given to become independent director, those conditions RP need to fulfill. Plus this is RP shall not be related party. He shall not be employee, proprietor, partner of a firm who is doing statutory audit, legal audit, cost audit of the corporate data in the last 3 financial year. So can I say RP, if RP is the employee, proprietor of or firm of the corporate data who is doing statutory audit of that corporate data or legal audit or cost audit, and if RP is employee, proprietor, partner in that firm, then he cannot become RP of that corporate data. It is similar like we have studied in independent director chapter. Then this is that if any firm is there who is giving legal or consultancy service and to the corporate data, and that corporate data is giving them 5% of the total receipt. How much percent? 5% of the total receipt. Then in that case, if RP is employee, proprietor or partner of such firm who is getting 5% of its total receipt from the corporate data, such RP cannot become member of such RP cannot become RP in that corporate data. So, fourth situation, he shall then independent, he shall fulfill the conditions of independent director, he shall not be related party, he shall not be employee, proprietor or partner of the firm who is auditor, legal auditor, cost auditor of the of the corporate data. Then this is, can you replace the resolution professional? Can you replace the resolution professional? Is it allowed? So they says, please understand, RP is there. Now if RP want to replace with another RP, what I am telling you, RP want to replace with another RP, is it allowed? So there are 2 things in this. You want to change one RP and you want to bring another RP. So for that, first of all, you have to pass 66% in value resolution, and you have to take written consent of the new IP to whom you have proposed to appoint RP. Fine. So can I say 2 things? First, you have to take 66% in value approval, and second, you have to take written consent of the IP to whom you are proposing to appoint as a new RP. So these two things you will take, and then you will give this name of IP. COC will give this name of IP to NCLT. Then NCLT will refer this to IBBI, and IBBI within 10 days will say whether any disciplinary proceeding pending against that IP or not. If not pending, then NCLT will appoint that new IP as the new RP. Till the period RP does not get appointed, new RP does not get appointed, who will continue? The old RP will continue. I hope it is clear. Public announcement. As I told you, when the application is made to NCLT, then what happens? That NCLT appoint IP as IRP, and then that IRP make public announcement. And why IRP make public announcement? So they can call the creditors and they can form the committee of creditors. So when IRP will make the public announcement, so that they can call the creditors and they can form the creditors. So what all information he will give, IRP will give in public announcement. So this is, they will give the name and address of the corporate debtor. They will give the details of IRP. Why details of IRP? Because can say when the creditors will come and creditors will give the claim, so they should know to whom the claim need to be given. So they will give the details of IRP. Then they will tell under which authority corporate debtor is registered. For example, if it is a company, it will be registered under ROC. Then they will tell that till what last date they can submit the claim. Then if you are giving any false or misleading claim, what will be the penalty, until what period resolution process will get completed. Same that introduction we have studied. Now the question is, who will make this public announcement? IRP will make. And within how many days? Within 3 days from the date of appointment of IRP. Now the question is, can I say who will going to bear the expenses? So this is the expenses will be borne by the applicant, but subsequently it will be reimbursed by COC. I hope it is clear. Now who will be there in COC? So this is, if there is a financial creditor in the company, then all financial creditor will be the part of COC. Obviously provided they shall not be related party. But if no financial creditor is there in the company, then what will happen? Then this is 18 largest operational creditor will be in COC. Sir, what if there is only 10 operational creditor? Then all the 10 operational creditor will be in the COC. Then one representative of workmen and one representative of employees. Are same? No, not same. Workmen means who has been defined as workmen under Industrial Dispute Act. That is daily wage laborer, worker. So they will be there in COC. Now, I told you if there is a FC, financial creditor in the company, then in COC all FC will be the part of COC. But then I told you that if it is a related party, then they will not become the part of COC. But sometimes they become related party due to conversion of debt into shares. For example, HSBC Bank has given loan to Kingfisher, and Kingfisher told that I will not able to repay you entire amount. 5,000 crore rupees loan is there. I will give you only 2,000 crore rupees. I can repay you only 2,000 crore rupees. So I will not able to repay you 3,000 crore. So for that 3,000 crore, Kingfisher has converted this 3,000 crore rupees loan into shares, and because of that, now can I say HSBC has become what? HSBC has become major credit shareholder in the Kingfisher, and because of that subsequently became related party. But now he is related party just because of conversion of debt into shares. So government says that practically there is no relation, only on paper he is looking like a related party, and that's why if normally related party will not be sitting in COC, but if you have become related party only because of conversion of debt into shares, in that case you are eligible to vote and you will be the part of COC. I hope it is clear. Now there is a possibility that a person is FC as well as OC. For example, bank has given the loan. So there are two things, one loan amount, one processing fees. As far as loan amount is concerned, for that the bank will be called as FC. But as far as processing fees is concerned, for that portion he will be called as operational creditor. So if you are FC and OC both, as you know, the claim of FC and OC, the voting power in COC, the priority order, everything is different for FC and OC. So this is that's why you have to submit the claim separately. So if you are FC as well as you are OC, then your FC claim and OC claim you will give separately. And obviously you will get voting right only to the extent of your FC share, and as far as priority is concerned, even in that FC share will only taken separately and OC share will taken separately. This is possible that one OC has delegated his debt to FC and went abroad. So now this FC who is holding the portion of OC, for that OC portion what he will be. So this is, in that case it will be treated as OC only. For example, HSBC Bank has given loan of 5,000 crore to this thing Kingfisher. Then there is another operational creditor whose value is 100 crore. They have delegated this to HSBC. Now for this 5,000 crore they will be treated as FC, but for this 100 crore HSBC will be treated as operational creditor only, and other way around. If the FC has delegated its shares to OC, so for that portion OC will be treated as financial creditor. So it is like that. To whom the notice will be served? This is the member of COC. Notice will be served to member of COC. Ideally, who will be there in member of COC? Financial creditor. Then member of suspended director. Sir, why suspended? Because now their power will be exercised by RP. So directors will be deemed to be suspended only. But then sir, why we are giving them notice? Just for the knowledge that what is going in the company. Then any operational creditor whose debt value is 10% of total debt. So a big operational creditor. Yeah, but these two people will not going to get the voting right. It is given just for the knowledge. So sir, what if they don't attend? Doesn't make any difference. Even if they will not come, this meeting will still be valid. Quorum. What will be the quorum of the meeting? This is quorum will be 33% in value of voting share. What I am telling you, quorum will be 33% of value in the voting share. Now the next point, this is that they can attend it either in physical or through audio video. They can attend this either in physical or through audio video. So quorum will be 33%, which you can do it through physical or audio visual, that is video conferencing. What if quorum is not present? This is, it will be adjourned to next week, same day, same time, same place. Next day and not next week. Normally we say next week. Here it is next day, same time, same day, same place. And even in adjourn meeting, if the quorum is not present, then this is whatever number will be there now, that will be treated as quorum. So in adjourn meeting only 22% will come. Then that 22% will only be treated as what? Quorum. I hope it is clear. Now a very important part. Formulation of resolution plan. What they are saying? How the resolution plan will be prepared? So this is, first of all, resolution professional will prepare information memorandum. Understanding what I am telling you? Resolution professional will prepare information memorandum, and that information memorandum will be given to resolution applicant. I hope it is clear. Now in that information memorandum, what will be there? This is financial position, that is CBAL, that is cash flow statement, balance sheet, asset, liability, debt, default. Again repeating, cash flow statement, balance sheet, asset, liability, debt, default. So these informations will be there. Then this is any information required by resolution applicant and any other information. So these will be there, and then resolution applicant will prepare resolution plan on that basis. After preparing resolution plan, it will be given to resolution professional. And now what resolution professional will verify? First of all, they will see whether resolution process cost has been provided or not. Number one. Why? Because this is very important. Right? If your company is under resolution process cost is always at a priority. So that resolution process cost has been provided or not, that they will check. Then they will check that whether operational creditor cost has been provided or not. See, financial creditor cost by default you will provide. Fine. Why you will provide? Because ultimately they will not approve only if you will not provide their cost. But for OC you may not provide. So they will check whether operational creditor cost has been provided or not. Then how the business will be continued in future, that is written, it is there or not. Then implementation of law, how COC will be implemented, that will be written. There shall be no contravention of any law. So it is like that. But in this you have to remember few things. If shareholder approval is required, then this is don't take the approval. Assume as if approval is already taken. Why? Because under IBC, this is the real control is with committee of creditor. So any approval which is anyway required by shareholder, if COC approves, assumed that shareholder has already approved. In a simple language, shareholder approval will not be required wherever otherwise you take shareholder approval. So this is the thing. But if any matter is touching the competition matter, for that you need CCI's approval. So this is that if CCI approval is required, take the prior approval, and any other approval take within 1 year or time given in the act. So if in act time limit is given 2 years, then take it within 2 years. But if the time limit is given within 6 months, then take it within 1 year. So whichever is later. And then this is, there shall be no IBBI guidelines contravention. So it is like that. Then after all this verification, RP resolution plan will go to COC, and COC will approve it by 66% in value. And after that, it will be sent to NCLT, and NCLT approves this. Then resolution plan will start, and that will be binding on members, creditors, companies, stakeholders, central government, state government, local authority, everybody. But if it is rejected, then what will start? Liquidation will start. Okay, so next thing we'll discuss is ground for liquidation. On what all grounds the liquidation will happen. So this is, see, there is a time limit to submit resolution plan. You have to submit resolution plan within 180 days, though there will be an extension. You can get the extension of 90 days. But ideally, the time limit is 180 days. So if within that time limit you does not submit the resolution plan, then in that case liquidation will happen. Or let's say 180 days has not expired, the time limit has not expired, but before that only COC feels that we don't think so that company will revive, the situation is very bad. So before completion of his that 180 days, before the expiry of that 180 days only, COC, by passing 66% in value, resolve that they want to go for liquidation, that they are doing it within time limit only. Or can I say resolution plan has been prepared, and after the resolution plan is prepared, corporate debtor has contravened the resolution plan. Now don't you think it will going to affect very badly? This is, boss, after so much of time investment, after so much of effort, we have prepared the resolution plan and you have violated the resolution plan. So this is if the resolution plan has been contravened by corporate debtor. Obviously because of that somebody will be at loss. So the affected person has filed an application to NCLT. Then NCLT will pass the liquidation order. So it is the point. So we have discussed the grounds for liquidation. Now what is the time limit for resolution plan? I have already told you the normal time limit is 180 days. And if you want extension, then this is 66% in COC. 66% COC in value. I am repeating. 66% COC in value. What they will do? They will file application to NCLT. So they are saying that first of all, can I say ideally you should complete the entire process within 180 days. But if you could not complete within 180 days, then this is 66% in value of COC will make the application to NCLT, and NCLT can grant one-time extension of maximum 90 days. Again I am repeating, NCLT can grant maximum one-time extension of 90 days. That means, can I say if NCLT has given you extension of 40 days, now you cannot say second time we will file the application, we want another 50 days. No. So one time extension is only permitted. So if it is less than 90 days, let's say 30 days, 40 days, 50 days. So for remaining days you cannot go again. But yes, if they wish to give one time extension at the max, they can give for 90 days. So this is the point. And now a very important section I am going to start, disqualification of resolution applicant. Now please understand, if when I was teaching you, I told you one thing. Please understand that can I say Bhushan Steel has been acquired by Tata Steel. So Tata Steel was the resolution applicant who has given the money and took the control over Bhushan Steel. So now the question is, who can become the resolution applicant? So they have given those conditions in 29A, section 29A, and they said that we are not saying who can become the resolution applicant, we are telling you who cannot become the resolution applicant. Basically they have given us disqualification, and if it does not fall under that disqualification, then you will able to become resolution applicant. So now let us understand who cannot become a resolution applicant. First is undischarged insolvent. If yourself is insolvent, how can you take over other company? How can you revive other company? Na? If you would have been that smart, you would have done for yourself only. Then another is willful defaulter. Now what is the meaning of willful defaulter? If you have sufficient balance, but if you still don't pay, if you still default, you will be called as willful defaulter. For example, Vijay Mallya. Can I say Vijay Mallya has sufficient balance with him? His net worth is 22,000 crore, but he has not paid 11,000 crores rupees debt. So Vijay Mallya will be called as willful defaulter. Then if your name is in RBI's willful defaulter list, then also you cannot become what? Resolution applicant. Then they are saying either he or his company where his promoter has been classified as NBA and 1 year elapsed from such period. Please understand what they are trying to say. Can I say? They are trying to say that, see, you are the company. You have taken loan and you have not repaid the loan and you have defaulted so much that they have classified you NPA. Now 1 year is already completed from the date you have been classified as NPA. And now you want to become resolution applicant of some company. Government says, boss, obviously not, will not allow you. Can I say you are a very old defaulter? So let's say if Tata Steel has taken loan from HSBC, HSBC has asked for repayment, Tata Steel defaulted. To that extent that HSBC declared Tata Steel as NPA and 1 year completed from such declaration, means the default is for a very long period. Now Tata Steel want to become Bhushan Steel's resolution applicant. Then Tata Steel cannot become resolution applicant of such Bhushan Steel. Why? Because obviously, can I say Tata Steel is making such a big default. How come he will make all this improvement in Bhushan Steel? So that is what they are saying. Now you will say, sir, then how Tata Steel has taken it? So Tata Steel have taken because they were not declared as NPA from anyone. It's just an example I have given you, that if you are a company and you have been declared as NPA, and if that is after declaring NPA 1 year has elapsed, then in that case you cannot become resolution applicant of some other company. Or you are not a company, you are a promoter director of such company, still you cannot become what? Still you cannot become resolution applicant. So if a company has defaulted and became NPA and 1 year elapsed, or if any person who is a promoter director of such company, then they cannot become what? Resolution applicant. But this point is not applicable for financial entity. Even if they have been declared 1 year elapsed, they can still become resolution applicant because for them it is very normal, because they deal in so much of finances. Default is a very part and parcel of their business activity. Then this is, if under 12th schedule you have been declared as guilty and you have been in imprisonment for at least 2 years, then from the date you are coming out of the jail for another 2 years, you cannot become resolution applicant. So you have been jailed under 12th schedule, convicted as a guilty offence, then for 2 years or more, then from the date of coming out of the jail, you cannot become resolution applicant. And for any other offence, you have been jailed for 7 years. You have been proven guilty, declared guilty for 7 years. Then from the date you have came out of the jail, so you have been imprisoned for 7 years or more in other offence and you came out of the jail, then from the date you have came out of the jail for next 2 years, you cannot become resolution applicant in any company. Then this is if you are disqualified to be get appointed as a director of 164. Yesterday I have taught you, earlier I have taught you, what I have taught you, that you know what, earlier I have told you that any person who is undischarged insolvent, applied himself to be declared as insolvent, convicted by court on moral turpitude ground, otherwise for a period of 6 months or more than 5 years, not less from the date of coming out of the jail. So all that grounds I have told you. So if you are disqualified to be get appointed as a director of the company, then obviously you can also not become resolution applicant. So if you are prohibited by the SEBI to enter into security market, then also you cannot become resolution applicant. Sir, what is the example? Please understand. Prohibited by SEBI to enter into security market. Now what does it mean? Can I say Ketan Parekh, Harshad Mehta, they were involved in financial frauds in the stock market. So they have been prohibited, banned by the security market. So if you have been prohibited by the security market, you cannot become resolution applicant. Then this is if your company is engaged in 3 things: preferential transaction, undervalued transaction, extortionate credit transaction. So this is called avoidance of transaction. If your company has been engaged in avoidance of transaction and you are the promoter of that company, then you cannot become resolution applicant. But let's assume the company has done fraudulent transaction, that is preferential transaction, undervalue and extortionate credit transaction. That time you were not the promoter, subsequently you became the promoter. That means you are not involved in all this activity, then you can become. But so if the company has done anything before you became the promoter of that company, then you can become resolution applicant. But imagine that if you are a promoter of a company which has done preferential, undervalue and extortionate trade transaction, then in that situation you cannot become resolution applicant of any other company. Then this is if he has given an executable guarantee which is unpaid. Example, Kingfisher. Can I say Kingfisher has taken loan from SBI, Kingfisher has defaulted. Now Vijay Mallya was the personal guarantor. Now, so SBI went to Vijay Mallya and they demanded the money. Now Vijay Mallya said, I will not pay you. Now can I say it was an executable guarantee against Vijay Mallya which remained unpaid. Now Vijay Mallya said that to Kingfisher that I will become resolution applicant of Kingfisher. They will say, what is nonsense? You are the person who created an entire mess, and now you are talking about becoming resolution applicant. So it is not allowed. So if you have any executable guarantee which remain unpaid, then in that case you cannot become resolution applicant. And all these offences which we have just now studied, so any of these offences if you have done outside India also, then also you will be disqualified to become resolution applicant. So these are the points which we have studied. Now next point is liquidator. Who can become liquidator? See, first of all, understand one thing. In this topic, any activity is done as a professional is done by insolvency professional. So by qualification, can I say liquidator is insolvency professional. Now this is any person who is already RP of a company can become liquidator. Ideally what happens, I'll tell you. IP got appointed, he became IRP. Normally that IRP become RP, and that RP only normally become liquidator. So this is normally the liquidator of the company will only become RP of the company will only become liquidator unless he is prohibited by NCLT. Imagine if RP has done something wrong when he was in company. Now NCLT will prohibit him and will say now you cannot become liquidator. So if NCLT will prohibit him, he cannot become, but otherwise RP can become liquidator. Normally RP becomes liquidator. However, if you want to become liquidator, you have to fulfill these conditions. This is, you have to fulfill 149(6) condition. What are the 149(6) conditions? These are the conditions given for independent director. So this is, you have to fulfill the conditions which is required to become independent director. Then you should not be related party. He should not be employee, proprietor, partner of a firm which is auditor, legal firm or corporate of a corporate debtor. So somewhat similar to this thing, qualification of RP. So liquidator has to fulfill these conditions. Now what is liquidation estate? When your company's resolution process fails, you will go under liquidation. And when you will go under liquidation, please understand, when you will go under liquidation, your assets will be sold and out of which the payment will be made. So whenever the assets are sold or the assets which are eligible for selling, so those things are called as liquidation estate. So liquidation estate is nothing. It is the you can say box from which the payment will be given during liquidation. So in that box, which all assets will come? So this is under liquidation estate. What will be included? First, any asset on which you have ownership right. What I am telling you, liquidation estate will include any asset on which you have ownership right. Again I am repeating, any asset on which you have ownership right. So it's a very simple statement. Any asset of which you are the owner, obviously that will be included in your liquidation estate. Second and third point is on the same line. Any asset in which you are owner, whether you are having possession or not. For example, I have a house, I have given it on, that property is let out, and yes, that property is let out. Now tell me, you are the owner now. Now the property is not in your possession. This is doesn't matter. That will obviously be included in your liquidation estate, because at the end of the day you are the owner. Then the tangible asset, intangible asset. So basically if these 4 points are same only, asset on which you have ownership right, asset which you own, whether it is in your possession or not, tangible asset, intangible asset. Asset under dispute. Sometimes what happens, let's say there is one land and in court the case is going on. I am saying that land is mine, the other party is saying the land is his. Now the case is sub judice. Now the question is whether it will be included when in the liquidation estate. So what they are trying to say, ki boss, can I say, if even if it is dispute at once, please include in the liquidation state. Why? Because if we'll forget later on, we will not able to decide. Now can I say the matter is, anyway this entire thing is controlled by NCLT. So NCLT will also take call whether it is your asset or not. But in the beginning at least include it so that NCLT will be having knowledge of the assets which you are claiming to be yours. So asset which is under dispute will also come. Asset recover under avoidance of transaction. A avoidance of transaction include three things: preferential transaction, undervalued transaction, extortionate credit transaction. I am repeating: preferential transaction, undervalued transaction, extortionate credit transaction. So these three transactions are nothing but the avoidance of transaction. And now under a preferential transaction, when the company cancels the transaction, the person has to return the asset. So now let's say I have received an asset under preferential transaction, so I have to return the asset again to the company. So obviously after that, because under a preferential transaction, by a wrong ways you give the asset to the person, so that person will return that asset to the company once preferential transaction is cancelled. So obviously once it is returned to the company, company will include that asset in its liquidation estate. Then asset on which secure creditor has relinquished his right. Now I will tell you what is relinquishment of right. So for some time just keep it pending. Asset vested with the corporate debtor. Now say, let's say there is some cases going on my asset, and then court has given court has given a decree to me. So that means I have won the case now, and after that, that asset will vest in me. So that is called asset vested with corporate debtor. So if there is any case and after the corporate debtor win that case, that asset is given to the corporate debtor. So that will be included in the liquidation estate of the corporate debtor, and any proceeds realized from above assets. So when you sell these tangible, intangible assets, after that the money which you get, that money will also be the part of liquidation estate. Now what will not be the part of liquidation estate? This is if the asset is owned by third party, but it is just in your possession. If for example, can I say trustee, bailment, all that you know. I am giving you another example. Let's say it is other way around. The asset I have taken on rent, let out. I have taken on let out. So the other party is the owner, but it is in my possession. So government says obviously even if it is in your possession, you are not the owner. So it will not be included, it will be excluded from your liquidation estate. Then workman due. Any workman due towards provident fund, pension fund, gratuity fund will be excluded in liquidation estate. Basically this is done to protect the right of the workmen. See, workmen are very poor people. So government feels that we need to protect the right of workmen. And how you will going to protect the right of workmen? So this is that any amount which we are supposed to pay on account of provident fund, pension fund to the workmen will not be included in the liquidation estate. Means what? You can say this money is not available to others, because at the end of the day when you say things are included in the liquidation estate, means in those money others will also get the claim, others will come. How they will come, in what priority order, that will learn in section 53. But this is that these three funds money of workmen will not be included in liquidation estate. Means they are the very poor people. So this is that whatever amount is lying in provident fund, pension fund of the workmen, this only workmen will take. They will take this money, and in this money others will not get any share because it is not included in your liquidation estate. Then this is any asset which is excluded by central government in consultation with financial sector regulator. Who is the financial sector regulator? SEBI, RBI. They people are financial sector regulator. Now what they are saying? Central government, when they do business in consultation with the financial sector, when central government in consultation with financial sector regulator feels that XYZ asset shall not be included in liquidation asset, then they may say that it will be excluded. This is normally, this power is exercised normally in public interest. Then this is if any asset held as a collateral of the financial asset or asset subject to mutual set off. These two are same point. I am telling you what is this. Imagine, let's say your company is there. Now this is your company's asset, fine. Now this is your company's asset. Now you have taken loan and you have put this asset on mortgage, in mortgage. Now technically speaking, this is the company's asset, so it is the ownership of the company, it shall be included in the liquidation estate. But what they are saying, that imagine if tomorrow you make any default, then what will happen? then that other person who has taken this asset in mortgage, they will exercise their right and they will sell this asset to recover their claim. So now this asset will not be included in my liquidation estate to the extent of set off. For example, this asset value is 500 crore and my debt value is 300 crore. So they have set off 300 crore. So this asset will not be included in my estate to the extent of 300 crore. So it is a point. Then obviously asset of the partner or shareholder will not be included in the liquidation estate, separate legal entity. Partners' assets or shareholders' assets are their assets, not the body corporate's asset. Then asset of subsidiary company. Obviously, subsidiary company's assets are subsidiary company's asset. That cannot be included in the holding company's liquidation estate. So these are some points which will be excluded. Now we are moving on to the next point, consolidation of claim. Now please understand how the consolidation of claim is actually done. First we'll read it from here, then we'll do it from the chart. So there will be financial creditor. This is financial creditor should submit his claim by way of information utility, and in case of operational creditor by way of invoice. See, normally as far as financial creditors are concerned, for them registering their debt value in information utility is mandatory, but for operational creditor it is not mandatory, and more likely they don't register their claim in information utility. So when financial creditor is giving his claim to RP or liquidator, so they will give their claim by way of IU, means IU will be the evidence which will authenticate that that person is financial creditor. But as far as operational creditors are concerned, when they will give their claim to liquidator, they will not going to give IU, they will give the invoice to prove that they are the operational creditor. What if IU is not available? You said, sir, for financial creditor it is mandatory. Yeah, but what if that financial creditor belongs to the period before IBC? That time so there was no IU also. So if information of IU is not available, then this is then financial creditor may send the details of claim by invoice. So they will send the details by invoice. Then this says that liquidator shall consolidate the claim within 30 days. After the liquidator got the claim, he will consolidate the claim, and once the claim made, this is that once the claim made, it can be withdrawn within 14 days. Now you will say, sir, why they will withdrawn within 14 days? You know, if you make any misleading claim, then there is a provision for penalty. Now financial creditor or operational creditor has made any claim, and subsequently they got to know that the claim contains certain wrong information. Now they says that if it contains certain wrong information, can they withdraw it? So they says yes, they can withdraw it, but in maximum 14 days. Then this is, if liquidator want to reject the claim, they can reject within 7 days, and against which appeal can be filed within 14 days. Now I have made a very nice chart for you. From the date of liquidation, within 30 days, liquidator, the financial creditor and operational creditor will give their claim to liquidator. So financial creditor will give the information in IU, and operational creditor as given by IBBI. Fine. And if it is partly FC and partly OC, then they means a person is financial creditor as well as operational creditor. So he will give his financial creditor and operational creditor information separately, because then obviously then only you will able to verify now. That's fine. This is, can it be withdrawn? Yes, it can be withdrawn within 14 days of submission. Then the claim for FC and OC is always different. The priority list is different. So if you are both, then you have to give the information separately. Once liquidator received it, if liquidator wants some further document, they can ask it to provide this further document to the creditors, and creditors has to provide that. Now within 30 days from the receipt of claim, liquidator will verify the claim as per the provisions given in the rules, and within 30 days, once he verified the claim, in next 7 days he will communicate to the creditor whether he has accepted the claim or rejected. So if he has accepted the claim, fine. If he has rejected fully or partly claim, then against this the creditor can file appeal to NCLT within 14 days. So I hope now it is crystal clear. Now let's move to the next point. Preferential transaction. Now what is a preferential transaction? This is any transaction which create preference of one creditor over another creditor will be treated as preferential transaction if it is prejudicial in nature. Now let me explain you this. See, there are one floating charge holder, or there is one creator who is at priority list 3, and at priority list 4th, let's say a person is there who is unsecured creator. Now let's say this guy who is at priority list number 4, can I say, is friend of the director. So what director will do? Director will convert this unsecured creator into a secured creator. So what will happen? Now don't you think his priority list will go above 3, maybe 1, maybe 2? These numbers are just an example. So don't you think in that case the money which number 3 was supposed to receive, now this number 4 will receive? So this is nothing but preferential transaction. Government says that when you give benefit to one creator over another creator, this is preferential transaction if it is done in the wrongful manner. This is wrongful manner only. So this is if any preferential transaction is conducted in last 2 years. Sir, why 2 years? Because see, changing the category does not mean that the debt is wrong. A debt is right only, creator is right only. There is a genuine debt. The only thing is that due to liquidation, now somebody will receive the money, somebody will not receive the money, and that's why this preferential order is very important. So this is if it is done before 2 years, then there is no problem. But if it is done in last 2 years, then we will feel that it is done with the intent to deceive other party. So this is that if preferential transaction is done in last 2 years, if you are a related party and preferential transaction is done in last 2 years, or if you are not a related party, then if it is done in last 1 year, then only NCLT will cancel that transaction. Are you understanding? That means if you are a related party and preferential transaction done before 2 years, or if you are a other person and a preferential transaction done before 1 year, then in that case NCLT will not cancel. Now, what are the exceptions? Means in few situations, even if it is done in 2 years, in last 2 years for related party, or 1 year for others, still it will not be cancelled. Means those are coming under the exception, means those transactions will continue when it is done in ordinary course of business. For example, I have done a business with my related person 2.5 years back, but the charges I have created in after 1 year, that is in last 2 years, I have created the charges. Now technically speaking, I have done wrong only, but this is the normal practice I do. For a certain value of transaction, I create charge after a year. Same I have done with my related party also. So this is that if it is a normal practice which they do it with everybody, then it will not be treated as preferential transaction. Or if it is to create a security interest for new asset and it is registered within 30 days, then also it will not be treated as preferential transaction. Means I have done business with my related party only, but I am not creating charge on his old asset. There is a new transaction for which I am creating a charge. So obviously it's an independent transaction, and that too I have registered this within 30 days. I am not giving him benefit of his old debts. There is a new transaction for which I am creating a charge, then also it is valid. Or you have done it due to the court order. Obviously if court is telling me, how come it will be wrong? So in these 3 situations, it will not be treated as what? It will not be treated as preferential transaction, and it will continue to be valid. Now what is undervalue transaction? This is that if you purchase assets from the company at substantially low price, then it will be treated as undervalue transaction. For example, company Kingfisher has sold the asset at 10 lakhs whose market value is 50 lakhs. That means Kingfisher will get loss of 40 lakhs. So this will be called as undervalue transaction. Now if you have done undervalue transaction with related party in last 2 years and with others in last 1 year, then it is a duty of IP or liquidator to inform NCLT, and NCLT will cancel that transaction. Cancel means they will do the restoration. So the company will, the NCLT will say the company that you please return his 10 lakhs rupees, and NCLT will say to that person that you please return the assets to the company. So there is a restoration of transaction to each other. So this is what they are saying. What if this RP or liquidator does not inform this undervalued transaction to NCLT, or this avoidance of transaction to NCLT? So this is, in that case, disciplinary proceeding will start against such RP or liquidator. Sometimes this is the transaction is done in good faith. So if the person can prove that I have done with a good faith, not to deceive company, and my intention was to purely give benefit to the company. So if they can prove that the transaction has been conducted in good faith, then it will not be cancelled. Now what is extortionate credit transaction? Please understand. What is extortionate credit transaction? If when company has taken a loan at a substantially high interest rate, that is called extortionate credit transaction. So let's say Kingfisher has taken a loan of rupees 10 crore and interest rate, the market interest rate is 12% only, but the Kingfisher has taken at 50%, 50%. Now don't you think it is then substantially high interest rate? Now don't you think the Kingfisher will pay interest which is absolutely high and unusual? So this is nothing but extortionate credit transaction. So same thing will happen. RP and liquidator has to inform, and then NCLT will cancel the transaction. If they will not inform, then disciplinary proceeding will be started against them. Everything will be same only. The transaction will be cancelled and everything. The only thing is that here the transaction will be cancelled if it is done in last 2 years, whether with related party or not. So normally for other person the time limit used to be 1 year. Here whether you are a related party or other person, the time limit will be 2 years only. Next. Now listen. If there is a secured creditor in liquidation proceeding, then what will happen? So this is where secured creditor want to realize the secured asset. Means this is the asset. This is the asset. Now this is Kingfisher and he is the creditor who has created charge on this building. Now can say he is a secured creditor. So now he want to take the control of this asset, want to sell it so that he can recover his dues from Kingfisher. Now this is called how he will realize, the secured creditor will realize the secured asset. So where secured creditor want to realize the asset, it can take possession of such secured creditor. Yeah, but it might possible that the Kingfisher is creating resistance, he is not allowing a secured creditor to take the asset. So this is if any resistance created by the corporate debtor, then the application can be, they are saying that if any resistance created by the corporate debtor, the application can be filed to NCLT. Then the secured creditor will go and they will file application to NCLT. See, this is the Kingfisher. I have created a charge on this asset. Now he is not allowing me to take this asset. And in that case, NCLT will do what? Then NCLT may make such order as it required to enforce the security interest. Means what? NCLT will pass the order and then NCLT may ask police to go and help you to take the custody of the asset. Then what will happen? Then the secured creditor will realize the asset, they will take the asset, they will sell it. After selling it, first what creditor will do? He will adjust the selling expenses because asset he has taken and sold it. So there may be some expenses in selling the assets. So first he will reduce it, then he will reduce his debt, and after that also if something left, then he will return it to liquidator. Then this is, what if the amount is insufficient? Means he could recover only the part of his debt. Then for remaining part he will tell it to liquidator, and liquidator will pay him under the category of unpaid amount of secured creditor. So this is the entire section 52. Now we are moving on to the next part, priority of the waterfall. Now please understand, in what order the payment will be given. Please understand, priority of waterfall, in what order the payment will be given. So what they are saying, what is the order? First is at top level, it will be resolution, process, cost and liquidation. What I am telling you, at top level it will be resolution, process, cost and liquidation. At first order this. At second order it will be workmen dues of last 24 months and secured creditor. If the amount is not sufficient, they will get in a pro rata basis. So first we will take workmen dues of last 24 months. Let's say that is coming out to be 3 crore and 30 lakhs, or secured creditor is coming out to be 20 lakhs. Now let's say you have received only 25 lakhs rupees. So now this 25 lakhs will be shared in workmen and secured creditor in which ratio? 3:2 ratio. So can you say pro rata means if workman is supposed to take, if workman's last 24 months due is let's say 30 lakhs and if secured creditor is 20, so the ratio will be 3:2. Assume if secured creditor is 50 lakhs, workman is only 10 lakhs, secured creditor is 50 lakhs, workman is only 10 lakhs, then 5:1. So that is pro rata basis. So this is the second order. Third order is employee dues. Sir, it is already given. No, that was workman, which is given under Industrial Dispute Act, daily wage laborer. At third category, employees, like people like us. Employee dues, but not entire period, only last 12 months. At fourth category, unsecured financial creditor. Unsecured financial creditor. Entire amount of unsecured financial creditor. At fifth order, it will be government dues of last 2 years, and in pro rata you will pay to unpaid amount of secured creditor. For example, secured creditor is 10 crore, out of which 8 crore you have already paid here. So how much left? 2 crore. Yeah, so 2 crore will come here. So unpaid amount of secured creditor. Then this is any other remaining date. And now what remaining date will come? So can you say in second category you have already included workman dues of last 24 months. So workman dues of before 24 months will come in that category. Then employee dues of last 12 months we have already taken in third category. So before 12 months will come in the sixth category. Then this is unsecured financial creditor. It already came in fourth. So unsecured operational creditor will come in sixth, like that. Government dues up to 2 years is already came in fifth. So government dues before 2 years will come in sixth, like that. And then preference and then equity. So revise. First is liquidation and resolution process cost. At second, pro rata secured creditor. Along with that, workman dues of last 24 months. So like that, all priority order will come. Then the next point they are talking is fast track insolvency. Hey, what is fast track insolvency? Please understand. I told you what is the normal resolution process time. 180 days plus one time extension of 90 days is allowed, and if legal dispute is pending, then 330 days gross time limit has been given. But fast track means you are doing all procedure very quickly. So here it will be exactly half of what you have already studied. So normally how much time is given? 180 days. In fast track only 90 days is given. Normally for one time extension, how much you get? 90 days. Here one time extension of maximum 45 days you will get. That is exactly half of the normal time limit. And now normally when you go to NCLT for one time extension, how much percentage of COC shall resolve it? 66%. But in fast track 75% of COC supposed to resolve. So can I say under normal procedure 180 days time limit is there, and then if they want one time extension of by NCLT, then of 90 days, then 66% in value COC shall resolve. But in case of fast track the time limit is 90 days, and if they want one time extension of 45 days from NCLT, then in that case 75% in value of COC shall resolve for such extension. Now not every company can go for fast track. Only these three types of company can go. Small company can go, startup company other than partnership firm, and unlisted company whose asset does not exceed 1 crore. That means not a major company, small minor company can go under this. Small company, unlisted company whose other than partnership firm, like that. Only these three type of entity can go under fast track fast track insolvency. So this is all. Now we are moving on to section 59, voluntary liquidation. Now friends, what is the voluntary liquidation? Please understand. If what they are saying, now you voluntarily want to close your company, you are like, now enough, I have earned well, and now I don't want to work, I want to close my business. So this will come in section 59, voluntary liquidation. If your company financial situation is not good, insolvent, then that will come in section 10. But if it is solvent and still you want to come for liquidation, then section 59. How it will work, I'll tell you. At first, majority of directors, that means if company has 5 directors and 3 directors will be majority, shall give affidavit that the company is solvent. I told you, see, insolvent company cannot come under this category. So if majority of directors says that the company, they are filing the affidavit, declaration that the company is solvent and it is not liquidated to defraud any creditor. This is not to do fraud with anyone. So this is the first thing you have to say. And now how will you prove that your company is solvent? So this is that you have to file audited financial statement of last 2 years to show the this financial position of the company. And if your company is in existence for less than 2 years, then obviously for the period it was in existence for. Along with that, can I say you are claiming values of the asset in the financial statement. So for that you have to give valuation report also. After that, from that declaration, in next 4 weeks, you have to pass special resolution of the shareholder for liquidation. But if your company has been formed for particular tenure or for particular event, like you have formed the company, you said I am here to make metro. Once metro got completed, you will close the company. So it is for event. Or you said I have formed the company for 5 years only. So their closing of company is formality. In that situation, you don't have to pass SR, you have to pass OR, ordinary resolution. After this, that SR or OR, in next 7 days, you will take approval of creditors. At least 2/3 in value of creditor shall approve this. If any means, if company does not have creditor, then obviously will not take that. But obviously creditor, having a creditor is a very common thing. So if creditor is there, at least 2/3 in value of the creditor's approval should come. After that, you will just notify the ROC within 7 days that we are going for liquidation. You are not taking their approval, you are just notifying that, and then you will start selling the assets and paying the liabilities. After all the assets are sold and whatever liabilities you can pay out of it, all liabilities you have paid, everything done, now you will file an application to NCLT. You will say that we have sold all the assets, we have paid all the liability out of it, now nothing left. Once it is done, NCLT will pass the dissolution order. That means your company is finished off, closed. So dissolution order is passed and it will be given to the company, and now the company will file it to the ROC within 14 days. I hope it is clear. Section 59 completed. Now some voting related point I am talking. Now please understand what they are saying, that see, if financial creditors are there in the company, now if the financial creditors are there in the company, they will go and sit in COC. Now let's say in financial creditor, banks are the financial creditor and they have given consortium advances. Now what is consortium advances? Let's say 4 or 5 small banks came together, they made the pull off loan of 1000 crore and then they have given that loan to, let's say, Kingfisher. So that 4 or 5 banks, when they come together and they make a pull off loan of 1000 crore and they give it to Kingfisher, that will be called as consortium advances. In that case, how the voting will be there? So this is that, first of all, can you appoint authorized representative? So those 4 or 5 banks can appoint, when in COC, they can appoint their authorized representative, and if they are appointing their authorized representative, if single authorized representative they are appointing, then who will going to bear the cost of that representative? This is, it will be written in deed. It will be written in deed. Normally in deed it is written that company will, corporate debtor will going to bear the expense. But assume every bank attend themselves, all 4 banks go and themselves they attend, then obviously there will be no cost only because they are going themselves. Or if every bank will appoint separate AR, in that case cost will be incurred by those banks only. Or if one bank attend on behalf of all bank, then obviously in that case also there will be no cost. So you have to just remember 2 things. If single AR is there for all banks, the expenditure will be as per deed. Normally in deed it is written that company will bear the expense, and if every bank is appointing AR separately, then company will not bear, then the bank has to bear the cost. How will be the voting? Voting will be jointly and separately. Means what? If let's say in 1000 crore, 3 banks whose value is 60 crore, 600 crore, they are saying yes, 400 crore is saying no, or 600 crore is saying no, 400 crore is saying yes, then that the voting will be done in 40% and 60% ratio. So the AR will go and they will say my 40% is yes and 60% is no. So like that. This is the point. Then this is a debenture holder, deposit holder are very big in number in the company, and they are also financial creditor only. So for debenture holder, deposit holder, this is debenture trustee and deposit trustee will attend the meeting. So let's say if all debenture holders are there in the company, in their behalf who will go? Debenture trustee in the meeting, and on behalf of depositors who will go? Deposit trustee will go, and the expenditure will be bared by the person whose name is written in the deed. Normally company's name is written in the deed, so company will bear the expense. Then if you are from a specific class of financial creditors, then in that case, can you say 3 names of IP will be given to you and you have to choose one name out of it. For example, you are from the state where highest number of creditors are there. In that case, to those highest number of creditors, company will give 3 name of IP, and out of that one name, one IP, you have to choose who will behave, who will act like your authorized representative, and the cost will be the CRP cost, means the cost will be bear by the company. Then they says that apart from that, anyone else, here the voting in these situations, the voting, the majority. By the way, one more point is here. is sometimes financial creditor is represented by guardian, executor, administrator. For example, can I say, if some person has become insolvent, then can I say on his behalf, his administrator will go. So who will bear the expense? Whose name is written in loan agreement, that person will bear expense. Now in these three situations, what they are saying, that the voting will be done on the majority basis. Means what? If 51% debenture holder is saying yes, and or 49% is saying no, then the debenture trustee will take entire yes, 100% yes. Or if 51% is saying no and 49% is saying yes, then 100% no will be taken by the debenture holder. So here the majority of vote will apply to the entire class. So this point is also completed. Now friends, I have tried to cover IBC in as short time as possible. Okay, now we are starting with a new chapter, Prevention of Money Laundering Act. Very important chapter. First of all, what is money laundering? See, there are two things. First, see, when you convert a black money into a white money, see, understand, conversion of a black money into a white money. So laundry means what? Can you say cleaning process na yaar? So here black money get converted into white money. But whether every type of black money when get converted into white money will be called as money laundering? So answer is no. See, there are some legal source. When you have earned money through legal source, the only thing is that you have not paid taxes. So that is not some money laundering. But if you have earned money through illegal source, for example murder, etc., and that black money if I am converting it to white, now that is money laundering. Now tell me, government will want you to do this or not? Obviously not. So here it is encouragement of money laundering or prevention. So it is Prevention of Money Laundering Act 2002. Now how this topic will be there, flow. So first we'll discuss definition, then obligation of reporting entity, then appeal, then what if property acquired from proceeds of crime, cross-border offences, and the general provision. So one by one we'll discuss. First we'll discuss money laundering definition. Now this is that any process or activity of what? Any process or activity of possession, concealment, acquisition or use of proceeds of crime and projecting it as an untainted property is nothing but money laundering. So if you are doing any activity in which you are possessing proceeds of crime, you are holding proceeds of crime, you are concealing it, you are acquiring it, or you are using it, what? Proceeds of crime. And not only that, you are showing it as an untainted property. Untainted property means you have proceeds of crime, but you are showing it as a legal asset. That is money laundering. For example, can say there is a politician who has 1000 crore rupees illegal money. Now, can I say I am a chartered accountant and I have converted, this was a black money, fine, this was a black money. So what I have done, in the name of different person, I have deposited this money into a bank account in the name of A, B, C, D, etc. And I am showing that these people are getting salary. Now I am showing it as an untainted property, but this is nothing but proceeds of crime. This is all he have earned through bribery, etc. So can say when I am doing this, it means I am doing money laundering. Not only that, that politician is also doing money laundering. So when you are showing proceeds of crime as what? As a untainted property, legal property, that means it is a money laundering. Now what is proceeds of crime? So this is proceeds of crime is a property which is acquired out of criminal activity. So can I say the property definition is proceeds of crime means? So proceeds of crime means a property acquired out of criminal activity. But which criminal activity? So this is property acquired out of criminal activity given in schedule offences. So if there is any property which is acquired out of criminal activity given under schedule offences, so can I say then that property will be called as proceeds of crime. And now there are 3 schedule offences are there. Part A, under part A any value of transaction will be covered. Under part B, if the transaction value is 1 crore or more, that is covered. In part C, it's a cross border offences. And as far as property is concerned, property will include every type of property: intangible, tangible, intangible, corporeal, incorporeal. Corporeal means having physical existence, incorporeal means does not have physical existence. And whether you hold that property in India or outside India, every type of property is covered. So now let's revise the definition. What is money laundering? Money laundering means any process or activity of possession, concealment, acquisition or use of what? Of proceeds of crime, and projecting it as an untainted property will be called as money laundering. Now what is proceeds of crime? It's any property, fine, any property acquired out of criminal activity of the schedule offences, then it is a proceeds of crime. Now what is schedule offense? Offense given under schedule A, schedule B value 1 crore or more, and schedule C. And what is property? Property includes every type of property, whether tangible, intangible, corporeal, incorporeal, whether in India or outside India. Now listen how things works in real life that I am telling you. Now let's say this is the professional, this is criminal, fine, this is criminal. He has done some what he do? Let's say he is doing some murder activity. He is a serial killer. Serial killer is a murderer, is a criminal. Now he has done schedule offences. Now he got money against that. Now that money is a proceeds of crime. Now he went to CA. Now CA is using different person's name, and he is using this money, like he is depositing this money into a bank account, into a financial institute in the name of different person, dummy person. He has opened a company in the name of dummy companies. So these things, these people whose name is used to as a deposit holder in bank, financial institutions, or the company which has incorporated, these are nothing but called as client. They are the client, these are the client. And this bank, financial institutions intermediary or person carrying on designated business are called as reporting entity. Why they are called as a reporting entity? Because government know that any black money you want to convert through white, so in that case you have to route through these people. So government has put restrictions on these people that if you get any suspicious transaction, you have to report us, and since they report, they are called as reporting entity. The person whose name is actually used to do all this crime, means let's say I have held a bank account in the name of ABCDEFGH. So ABCDEFGH will be called as client. I have I have started a company X Limited in which I have put some dummy name. So those X Limited and that dummy name will be called as client. Not only that, the criminal who has done the murder, he will be called as beneficial owner. So this is the relation, and I am and the criminal both will be called as if we are doing money laundering. So this is some basic idea I have given you. Now if you are doing money laundering, what will be the punishment? See, if you are doing activity which is given in paragraph 2 of part A, that is narcotics and psychotropic substance. So if you are engaged in narcotics and psychotropic substance, that is drugs, etc., and from that money you are using to do money laundering, then in that case government feels that this is a very serious offenses, because most of money laundering is done through narcotics activity only. So this is that if you are engaged in this, then the minimum punishment is 3 years and maximum is 10 years. And the punishment is rigorous punishment, means you have to go and work in the jail. You will not just sit and enjoy the jail. Sir, who enjoy the jail? In just an example I am giving you. So if you are engaged into a narcotics activity, then the punishment will be minimum 3 years, maximum 10 years. And other activity, minimum 3 years and maximum 7 years. By the way, there will be also fine and fine, but the amount is not written. So that means it will be the same discretion of the judge. They will decide how much punishment should be there. So this is the punishment. I hope it is clear. Shall I proceed? Now, what is the obligation? I told you bank, financial institutions, intermediary, or any person conducting the designated business, they will be called as reporting entity. Why they are called as reporting entity? See, a simple logic. Can say any illegal activity if you want to conduct. Again listen everybody very carefully. Any illegal activity if you want to conduct, can I say it has to route through bank, financial institutions, intermediary. Intermediary means those stockbroker, broker, those intermediary given under SEBI Act. So it has to be routed through these people. Now, or any person carrying on designated business. So if these people will keep on reporting on a very frequent basis to the authority under this act, ED, Enforcement Directorate. So don't you think it will become very easy to track down money laundering activity? And that's why this is that bank, financial institutions, intermediary, and person designated on carrying on designated business. Now henceforth we will call them as reporting entity. So reporting entity has to maintain the details of value of transaction as prescribed. It is prescribed as 10 lakhs rupees, and they have to furnish it on a very timely basis to ED, Enforcement Directorate, within the time limit given in the law. They also have to maintain details of client, beneficial owner, document for their identification. Now you will say, sir, beneficial client means we understood the person who all are dealing with bank. So if I have opened an account with bank, I will be called as client. But beneficial owner, you said criminal. So how they will come to know that who is the criminal behind it? See, there are two meanings of beneficial owner. One is actually criminal. Sometimes what happens now, that you are the nominee of some other person. For example, can I say my friend does not stay in India, so he has appointed me. Now I am managing his bank account. So can I say I will be the client and my friend will be beneficial owner. So even that information need to be given, and all other documents and how you have identified the clients, the details of the client, that also need to be given to the Enforcement Directorate. And all these details need to be maintained for how many years? 5 years. And very important thing, it is an obligation for a bank, whatever activity they do, can say bank has to keep it confidential. All the details of the client they are supposed to keep confidential. So it means if ED will ask, they will not provide them. No, they will provide to ED, but apart from that they will keep the information confidential. Then this is that this reporting entity has provided the information to ED, and later on ED is of the opinion that we need some additional information. So the question is, can ED ask for the additional information? So this is that ED may ask for an additional information, and from whom ED can ask for the additional information. So this is that ED can ask the additional information from bank, financial institutions and intermediary. ED can ask for additional information from bank, financial institutions and intermediary, and in that case it is the duty of bank, financial institutions to furnish these informations. Sir, within how much time they have to furnish this information? So that is not given in the law. See, ED will tell them that within 10 days, 15 days, 20 days you have to give the information. So whatever the time limit given by the ED, intermediary has to, reporting entity has to furnish that information to ED. Later on, after these informations, can I say ED may come up with an opinion that something looks suspicious. So if they feel that, can they conduct inquiry? Answer is yes. ED may conduct an inquiry. Also, if they want, they can conduct audit, and the expenditure of audit will be borne by the central government, because yet no guilt has been proved against the company. So it is wrong to punish company at first stage. Then this is that if bank, financial institutions, intermediary fail to follow the direction. For example, they have asked us that please share the information of the client, and if the bank, financial institutions and intermediary fail to fulfill those directions, in that case penalty can be levied on them 10,000 to 1 lakh for every failure. For example, if 20 client is there and if they have asked for 20 clients information and if they have not provided those 20 clients information, then the fine will be 20 lakhs rupees. It's like that. Any information given by the bank, financial institutions, intermediary to Enforcement Directorate will not be treated as breach of information. Why I have told you this? Can I say bank or financial institutions or intermediary has to maintain the confidentiality. So technically they cannot share the information of the client, but here they are sharing the information to the ED. So technically, can I say they are doing breach of information? But this is that, boss, this is requirement of the law. This is to safeguard the economics of the country, and that's why if they are sharing their clients information to ED, that will not be treated as breach of information and they are not liable for criminal proceedings. Now, as I told you, any suspicious activity conducted by the client, can I say the first person who will come to know is reporting entity. But when they will come to know, when they will do properly verification of the client, that client is genuine or not. So they have set some ways of verification of client. What they are saying, if the reporting entity is bank, then how they can verify their client, that the client is genuine or not? So they can check their biometric Aadhaar or offline Aadhaar. What is biometric Aadhaar? The thumb impression. Offline Aadhaar means the card thing they can take. So they can authenticate through biometric Aadhaar or offline Aadhaar, or they can check passport, or they can take some other document, driving license. Okay, now please understand, out of these 4 things, reporting entity, if reporting entities bank, they can verify the client from any one out of these 4 detail, but they cannot insist client for particular detail. Means it is option of the client that what information they want to share. For example, if client want to share passport, now bank cannot say no, I want biometric Aadhaar only. So these are just 4 options. Out of this 4 option, any one option client can give to the bank and bank has to accept it. Now imagine if Aadhaar is shared to the client, then in that case bank cannot store the Aadhaar detail, because Aadhaar details are very confidential details. If the client is other reporting entity, for example, if it is financial institutions, if it is intermediary, any designated any person carrying on designated business, then they cannot verify through biometric Aadhaar. They can verify only with these 3 means, that is offline Aadhaar, passport or other document, for example driving license. Now this is that if the other entity, if central government allow other entity to verify through biometric Aadhaar, then they can do it. But can I say, as of now central government has not made such rules, but in future if central government make the rules after giving compliances for related to privacy, then they can verify through biometric Aadhaar, but till that time they cannot. And any information of Aadhaar cannot be stored, whether it is bank or other reporting entity. Now that is what they have said, that customer has choice to submit any 4 in this situation and any 3 in this situation document to the reporting entity. Now please understand one very important thing. When you are doing certain activities and subsequently you came to know you are doing certain activity and subsequently you have the opinion that this asset has acquired through money laundering or the assets is the proceeds of crime, during investigation you have this opinion, then in that case can those assets be freezed or can it be taken, can it be confiscated? So related to those provisions is given under section 5, 8 and 9, that is attachment and confiscation of the property. Now how the attachment will be done? See, please understand, if the enforcement directorate or the deputy directorate has reasons to believe, and what reasons to believe they have? They have a reasons to believe that the property is engaged in money laundering, and if we will not attach this property, then there is a possibility that this property will be transferred, which will frustrate the proceeding. Frustrate means delay the proceeding. Whenever you have reasons to believe means you must have some evidence. So they have a material in possession also, evidence also to prove this thing. So if ED or DD, enforcement director, deputy director, have reasons to believe that, and they have material in possession that property is engaged in money laundering, and if it is not attached immediately, then it may frustrate the proceeding. In that case ED or DD can do what? They can provisionally attach the property. What I am telling you, they can provisionally attach the property. For how many days they can provisionally attach the property? So this is, it can be attached for maximum 180 days. Means, can I say for 180 days they cannot sell the property? I hope it is clear. Now if during that attachment the other party go to court and take stay order, so now don't you think that investigation will be on hold for those many days? So this is, if the stay order has been given, then the attachment period will also increase. It will increase by stay plus 30 days. So normally the attachment will be for 180 days only, but if the stay order is taken, then it will increase by stay plus 30 days. So let's say stay period is 40 days, then in that case it will be 180 plus 40 plus 30. Sir, what if there is no stay? Then only 180. Sir, what if there is stay? Then 180 plus stay period plus 30 days. I hope it is clear. Now once ED and DD attach the property along with all the documents, that is copy of order and material in possession they have. Which order, sir? Order of attachment, and the material on the basis of which ED, DD has opinion, has reasons to believe that property is engaged in PMLA. All these things they will send to adjudicating authority, and within how many days they will send this to adjudicating authority? Within 30 days from the date of attachment. Now what adjudicating authority will do? Once they will get this thing, copy of order and material in possession, after that adjudicating authority will apply their brain, and then they will see whether there is a chances of money laundering or not. And if they have a prima facie opinion that property is engaged in money laundering, then they will issue show cause notice to that accused person. Now SCN means show cause notice. They will issue show cause notice to that accused person and will tell them that please reply us that the source from where you have acquired the property and what evidence you have to prove that the property is not in money laundering and all these things. And for that reply, at least 30 days time, adjudicating authority shall give to the accused person. After that, the next step will be hearing. A hearing will start, and in that there will be two parties. One is accused person and second is EDDD. So adjudicating authority will hear accused person as well as EDDD, and after that the adjudicating authority will conclude whether the property is engaged in money laundering or not. So if after that adjudicating authority comes to an opinion that property is not engaged in money laundering, then they will release the property. But if adjudicating authority is of the opinion the property is engaged in money laundering, now it will be final attachment. A final attachment will be for 365 days. Obviously, if there is a stay, then stay period will also be included. So it will be final attachment. And once final attachment is done, it will be referred to special court. Sir, why? Because till now confiscation has not done. So now it will go to special court, and special court will see whether property is engaged in money laundering or not. If they feel that property is not engaged in money laundering, then they will release the property. If they feel that property is engaged in money laundering, now it will be confiscated and it will vest to central government. So it will go to central government, and any claim you have, any legitimate claim that you have against that property, then you have to go to central government for your legitimate claim. Legitimate means legal claim. And now this is what we have already discussed. EDDD will forward to magistrate. See, when EDDD do the attachment now, so they don't do attachment directly. When EDDD attach the property, they give the copy to the magistrate. Fine, and then magistrate do all the magistrate see everything, and then EDDD go and attach the property. So basically, when EDDD want to attach the property provisionally, can say they have to inform it to magistrate unless it is very urgent. I hope it is clear. Next point. And now I told you, after confiscation, after the confiscation order passed by the special court, property will vest with the central government. This is once it is vest with the central government, who will going to manage the property? So it will be managed by the administrator. Normally they are the income tax officer. They will manage the property, and if the property need to be sold, then they will sell also as per the rules or provisions given by the central government. This is once the property is vested with CG, it will be free from any encumbrance. Means if any charge is there on that property, then that charge will lapse, then that charge will be cancelled. So once property is vesting to CG, it will be absolute, means there will be no charge standing against that property. Now then in that case some real life problem will come. What if some person has a legitimate claim against that property? Somebody will say, see, I am supposed to receive the money, that person has taken the money from me against that property. So this is if there is any legitimate claim. For example, if the property has one building and then there are 4 machines in that. Now somebody is claiming that he is the owner, real owner of that machine. Legitimate claim is there. In that case, CG may restore or may give compensation. CG will see, okay, take the machine, or CG will see the machine is immovable in nature, now it is fastened to the earth, so you do one thing, you take the compensation against that. So CG can do it, but CG will verify whether it is done in good faith or not, and without the knowledge of money laundering. For example, if CG feels that that person who is claiming that this is my machine, he is a very good friend of the guy who has done all this offense, money laundering, and he is also a CEO of that person. So now they will say that obviously you must be having the knowledge. You cannot say that I have done this, I have given him machine in a good faith, I had no knowledge of money laundering. So first CG will satisfy itself that whether person has done in a good faith and whether he has no knowledge of money laundering. So if it is so, then only he will give the compensation or he will restore the asset. Now it is possible that somebody must have created the charge. Means somebody has given loan against this property and against this the charge is created. So this is that if the charge is created in good faith, then they can claim compensation. But the loan is given, means the person who has done this money laundering and the other person is friend of him. He said, let us do one thing, you show that you have given me loan and I will create the charge. Subsequently, when I will receive the money from the central government, we will share, because we know that anyway central government will take this building. That means this charge is just to defraud the government, then it will be invalid. Sir, in that case, can this person claim money from him? Yes, yes, definitely. But can the central, if central government feels that, yeah, boss, you have created a charge just to manipulate, then in that case, central government will cancel the charge. I hope it is clear. Fine. However, it can be executed against guarantor. I hope it is clear. Shall we proceed? Appeal to appellate tribunal. Now, please understand. See what happens. If any aggrieved person is there against whom some action is taken by the ED, and that aggrieved person is not happy with the act of the ED and he feels that he has done the thing in the unjustified manner, they can file the appeal to adjudicating authority. Now, after the order of adjudicating authority, still if that person is aggrieved, they can file appeal to appellate tribunal. Sir, what if adjudicating authority has given decision in the favor of aggrieved person and now ED is aggrieved? Then ED will file appeal to the appellate tribunal. So, anyone who is aggrieved, whether it is aggrieved person or ED, whoever is aggrieved with the judgment of the adjudicating authority may file appeal to appellate tribunal. Within how many days? Within 45 days of the order. Now, the question is, what if there is a genuine delay, means that person who was aggrieved was not well? So, can it extension be granted in filing the appeal? So, this is yes, reasonable extension can be granted by the appellate tribunal. How many days is not mentioned, but any reasonable extension what appellate tribunal feels appropriate. Now, once the matter is with appellate tribunal, this is appellate tribunal shall give the decision, dispose the appeal within 6 months. See, these are money related issues. So, if they will give decision, if there is a very delayed decision, then don't you think it will affect the economy also? So, this is the decision should be given within 6 months. And if anyone who is not happy with the judgment of the appellate tribunal, they can file appeal to High Court within 60 days. Extension of 60 days can be granted. Sir, within how many days High Court should give the judgment? So, to High Court you cannot say give within that date. It's a very big court. So, High Court will take any time they feel like. And if you are not happy with the judgment of High Court, you can go to Supreme Court within 60 days and extension of 60 days can be granted. Again, there is no time limit within which the Supreme Court shall dispose the case. They can take any time they wish to. So, this is obviously Supreme Court judgment will be the last judgment. So, this is all for this. Now, we are moving on to the special court thing. First of all, here why special court is formed, that I will tell you. There are two ways. One, when you are doing offense only of money laundering, and one when you are doing offense which involves both schedule offenses also, money laundering also. For example, I told you about politician who has taken the bribe and 1000 crore rupees is there. Now, his black money got converted into white money by the CA. So, when you will book the offences of this politician, he will be booked only in money laundering? Answer is no. He will be under schedule offences also and money laundering also. But the CA will be booked only under money laundering. So, when you are booked only under money laundering, how the route will be done? It will, for only money laundering, the case will be from adjudicating authority to appellate tribunal to High Court to Supreme Court. But if the case is related to schedule offence as well as money laundering, then the route will be special court to High Court to Supreme Court. So, it is like that, not given in your module, just for the knowledge purpose I have told you. So, nothing to worry about. So, this is the reason we form special court. Now, how special court formed? So, basically, you know, at the top it is Supreme Court, then it is High Court, and then it is Session Court, which is also called as District Court. So, this Session Court, now, out of this Session Court, some judges are assigned that now onwards you will look after only money laundering cases. So, those judges or those benches of the judges will be called as special court. So, obviously, who will decide who will be special court? So, one court above the Session Court, that is High Court. So, central government in consultation with Chief Justice of High Court will notify one or more of the judges of the Session Court as special court. This is cases under money laundering. Can I say when the offence is only related to money laundering, it will be looked after ED, Enforcement Directorate. From that you will go to adjudicating authority, from appellate tribunal, from there High Court, from there Supreme Court. But if the offence is of money laundering as well as schedule offences together, then from in that case, can I say you will go to special court, from there you will go to High Court, from there to Supreme Court. So, it is like that. So which offences are triable by the special court? This is when the offence involved of money laundering plus schedule offence, then it will be tried by the special court. But for that, who will file the complaint to special court? This is J Dada. J Dada means joint director, deputy director, additional director, assistant director. So J Dada will file complaint to special court. And after that, this is that if any offence tried by any other court, they will also transfer the evidence to special court. For example, some court is already trying the offence related to that politician, and later on they got to know that that special court has started cases against this politician, and this involves all offences, that is the money laundering as well as the schedule offence. So that court will do what? They will transfer the offences to special court, so that special court can try these offences. Try means hearing. So this is it, and a procedure of criminal procedure code will be followed. It is like that. So this was the procedure I have covered. Now I am moving on to the next point. Offences are cognizable and non-bailable. Now please understand. Can I say what they are trying to say? Offences will be treated as cognizable and non-bailable. Now what is the meaning of cognizable and non-bailable? A bailable offence means police cannot keep you in custody till you proven guilty, or you will not be in jail till you prove guilty. That is bailable offence. What is non-bailable offence? A police will arrest you, they will present you in front of first class magistrate, and then the magistrate will decide whether you need to be given bail or not. So that is non-bailable offence. Now in that there are two types of offence: cognizable offence and non-cognizable. Non-cognizable are serious but not very serious, but cognizable is very serious offence. For example, can I say if there is an allegation on you, eve teasing is bailable offence, but if you do it multiple times, repeated offence, then eve teasing become non-bailable, but it is still non-cognizable. Means police can arrest you, but they have to first give you warrant. But rape, murder, these are cognizable offence. If police will get to know, they will straight away arrest you, so that you cannot run away. So it is arrest without warrant. Cognizable. So the offences of PMLA are cognizable and non-bailable, very serious offences. So when judge will grant you bail, so how they will grant you bail? So this is usually before giving bail, they will give opportunity to public prosecutor to oppose your bail. These are the government lawyer whose duty is to prove you guilty. Fine, they will try to prove you guilty. So can I say before giving bail, court will give the opportunity to public prosecutor to oppose the bail, and they will also see whether, see, right now they are just giving you bail, the case will continue. So court will see whether there is a chances that you will be innocent, or whether there is a chances that you will be guilty, and whether you will not commit any offence while on bail. So no offence while on bail, no commit offence while on bail. So court will see all these things, and if they satisfy that all conditions are satisfied, they will give you bail. But if court want to give bail to these 5 type of people, then in that case they says that without verifying these conditions also, court can give the bail. When the age is less than 16 years, minor, very small kid, or woman. They have said women, but normally it is given to a pregnant woman, so that their infant does not get affected, the baby in her womb does not get affected. So like that. Woman, infirm means mad person. Can I say to whom? Mad person, you have to give them bail. What he will do in jail? He will start beating others only. So infirm. Sick person, so a lot of politicians take bail on this ground only. Or if the value is less than 1 crore, it's a very less value. If you see, money laundering is a very big offence. So if value is less than 1 crore, it is a very negligible as far as PMLA is concerned. So in these 5 situations, bail judges can give the bail without verifying the condition, that is PP, giving opportunity to oppose PP, and whether there is a chances of likely to be innocent, like that. So normally, if the offences given under this act is cognizable and non-bailable, and this says that before giving bail, you have to give opportunity to PP to oppose the bail, and the chances of being innocent is more than chances of being guilty, that we will verify. Then only judges can give the bail. Now, next point we are doing the discussion is cross-border offences. Now, please understand one very important thing. What are the cross-border offences? There are 2 things: India, Australia. There are 2 things. This is the person who has done PMLA in Australia, fine, and he's an Indian person, but he's outside India, and he has done PMLA offense here, and he's trying to send foreign currency in India, or somebody has done PMLA offense here and trying to send currency outside India. So these are treated as cross-border offenses. It is called as cross-border offenses. Now this is very important point. See what they are saying, in India, if you commit part A, part B, part C offenses which is given in PMLA. So if you are doing those offenses in India which is specified in part B, part A, part B and part C. Now those parts are not there in your syllabus. So in paper 4, paper 6 it is there. So if you are doing offenses under part A, part B and part C, and if you transfer or if you attempt to transfer either, then it will be treated as if you have done the cross border offenses. That means if in India you have done PMLA offense of part A, part B, part C, and if you have already transferred, it will be treated as money laundering, PMLA, I mean cross border offenses. But if you have not transferred, but if you are attempting to transfer also, that is also treated as money laundering offenses only. But as far as outside India is concerned, if outside India you have done offenses which is corresponding to part A, part B, part C. See, outside India obviously there will be no PMLA law. So this is outside India you have done those offenses which are similar to part A, part B, part C offenses, and you have transferred in India, then only you will be treated as if you have done cross border offenses. Means outside India if you have just attempt to transfer but not yet transferred, so it will not be treated as cross border offense, because government will not come to only that you are that you are about to transfer or something. When government of India will come to know when you will actually transfer. So this is outside India if you are doing corresponding offenses as per part A, part B, part C, and if you have actually transferred in India, then only it will be treated as cross border offenses. So this is the thing. As far as reciprocal agreement is there, what is the reciprocal agreement? See, now India and Sri Lanka. Now, please understand, something wrong, someone is doing something wrong in India, but that person is from Sri Lanka. Or if somebody has done something wrong in Sri Lanka and he ran away to India, or someone have done something wrong in India and ran away to Sri Lanka. So in that case, don't you think these countries need to help each other so that the real culprit can be caught? So this is, in that case, India and Sri Lanka may enter into reciprocal agreement. Something similar we have studied in Companies Act also. In that case, can I say Sri Lankan government can ask help to Indian government, or Indian government can ask help to Sri Lankan government, and these are done through letter of request, and that is what we are going to learn now. What is letter of request? When India demand information from the contracting state is Sri Lanka, fine, so who have done contract. So in that case, how it works, I'll tell you how the Indian government will take help from the contracting state. So first, there will be some investigation going on in which the investigating authority or the superior to the investigating authority has opinion that outside India there is some evidence which is useful for the investigation. So they will tell it to the special court, they will request the special court that there are some information outside India, can you please demand it, and the special court will send letter of request in the manner prescribed by the central government. Now the contracting state will provide those informations to the special court, and then the special court will forward this information to investigating authority, and then investigating authority will use it as a evidence. So how it works, investigating authority will request to special court will send letter of request to contracting state, that contracting state will give information to special court, and then that will be forwarded to investigating authority, and then it will be used as an evidence. It works like this. It can be other way around. The contracting state is asking help to special court or competent authority, that means to government of India. Sri Lanka want help from India. So this is, contracting state will send the letter of request to central government. Central government will forward this to special court competent authority. Now in your book they have not given further information, but now what will be the further information? Obviously in that case, now special court will forward the data to central government, and then central government will give it to contracting state. That is a very obvious step now, but that is not given in the act. Now If when company is liable or any officer is liable for something wrong has happened, then when the officer will be liable for the offenses. So this is if anything done knowingly or if anything done due to negligence of officer, then that officer will be liable. But if the officer has exercised good faith or if he has applied due diligence, he has like ordinary prudence he have applied, then he will not be liable for the contraventions. He has to prove that. Now, very interesting provision, vexatious search. In many times, many a time, ED officers make search just to satisfy his grudges against some person. That's called vexatious search, vexatious arrest. Or if somebody make complaint against someone under ED, I mean under PMLA, out of malicious intention, means out of grudge, that means there is no genuine search, there is no genuine arrest, there is no genuine complaint. In that case, government says the person who is making vexatious search or vexatious arrest or malicious complaint is done. This is then in that case the imprisonment will be of 2 years, or it can be fine up to 50,000, or it can be both. So it will be imprisonment up to, tell me, 2 years or fine up to 50,000, or it can be both. But now can I say what section 64 says, that can I say whenever you want to give imprisonment to any enforcement directorate officer for vexatious search or to anyone for malicious complaint, you have to take approval from the central government, and central government should reply within 90 days for that application. Now here I will tell you what happens actually. Can I say vexatious search is made by ED for opposition leader, let's say Rahul Gandhi. Can I say in that case central government will not give approval to the court to take action against ED, because there is a possibility that it must have done with the motivation, it must have motivated by the central government only. But if the vexatious search is done by ED officer against Amit Shah or their family member, now central government will give approval to court to take action against ED. So this is the possibility is there. So this provision is also drafted in such a way, and that is why you will see that ED officer and all are primarily controlled by the central government only because of these structures. Next point, section 63. If any information has been asked by ED to you and you have not provided the information, or if they have asked you to sign some statement and you have not done it, they have summoned you but you have not attended, then the fine will be minimum 500, maximum 10,000. Then this is, if some direction is given under section 50 and you have disobeyed it, then there will be penalty under section 174 of Indian Penal Code, general provision. What they are saying, if, can I say, enforcement directorate get lot of information on which tax is not paid, income tax department get lot of information which is somewhere connected to money laundering. That's why they say that you should support each other. If enforcement directorate get some information which is relevant for income tax, they will share this information to income tax, and other way around. If income tax get this information, they will give it to this department, like this. Recovery of fine. A fine is levied, and if you are not paying the fine, and if the fine is not paid within 6 months, then this says that it can be recovered as per income tax 1961. Means movable property can be attached, movable property can be confiscated, movable property can be attached, bank account can be freezed, like this. Offences by company. If company has done any offence, company's director, manager, secretary will be liable if it is done with their consent, same thing which we have studied, or with their negligence, then they will be liable. But if it is done without their knowledge, or if they have applied a due diligence, in that case they will not be liable. Next point, they are saying continuation of proceeding in the event of death or insolvency. Let's say some action has been taken against some person and he has passed away, like let's say adjudicating authority has passed some order against Mr. X and Mr. X has passed away. Now can I say, can the legal representative of Mr. X can file appeal to appellate tribunal? So answer is yes, they can file appeal to the appellate tribunal on behalf of Mr. X. Why? Because can I say there is a possibility adjudicating authority must have passed some confiscation order against Mr. X. Now he has passed away. So who will going to protect his right? So obviously who is the beneficiary? Legal representative. So legal representative also have a right to file appeal against such order to appellate tribunal on behalf of the person who has passed away. So friends, that's all in money laundering. I hope you find it useful. Okay, now let us start with a new chapter, Foreign Contribution Regulation Act. In this, the first definition which we will discuss is foreign company. This is foreign company means three things. Number one, foreign company means a company or the association or the body of individual outside India. So if any company is there outside India, any association or even a body of individual is there outside India, as far as this chapter is concerned, FCRA, it will be treated as foreign company. Then this is that anything which is foreign company as per Companies Act, even that is included here as a foreign company. Then if there is any subsidiary of a foreign company, that will be treated as foreign company also. If there is any registered office or principal office of a foreign company, that will also be treated as foreign company. If there is a multinational corporation, means the company which has two or more business, which has business in two or more countries, that is MNC. This is even that will be treated as foreign company. But here one very important thing. Now can I say if any subsidiary of a foreign company is possibly maybe in India or as well as outside India, can I say they have covered both as a foreign company. Means what? Can I say if there is any subsidiary of a foreign company which is in India, even that will be treated as a foreign company. Sir, outside India definitely, but even in India, same goes with registered office also. So revise, what is foreign company? Means it's a company, association, body of individual outside India. Then this is, it includes subsidiary of a foreign company, then foreign company as per Companies Act, then registered office, principal office of a foreign company, and multinational corporation whose business there is there in India, who has a business in two or more countries in the world. Then next is, what is foreign contribution? So this is that foreign contribution means what? Number one, donation. Number two, delivery. Number three, transfer by any foreign source. In some time we will be learning what is foreign source, but as of now please understand these three things. What they are trying to say, foreign contribution means what? Number one, it means donation. Number two, it means delivery. Number three, it means transfer. By whom? By any foreign source. Of what? Of these three things. So donation, normally what you do in donation? So you do donation of money. Then delivery or transfer, you do it with services, goods, etc. So this is foreign contribution means donation, delivery or transfer. And who is doing this donation, delivery or transfer? It is done by any foreign source. What is foreign source? That we'll learn in some time. So by any foreign source of what? Of article. But if it is of personal use, by the way, now you know that there is an amendment from relative. Instead of the 1 lakh limit, now they have changed it to 10 lakhs. So of any article, currency or security. By the way, currency here it includes both Indian currency as well as foreign currency, and security both under Security Contract Regulation Act, under Foreign Exchange Management Act. That is Indian security as well as foreign security. So this is foreign contribution. Then this is, if you receive foreign contribution from any person who has received foreign contribution, then even that will be treated as foreign contribution for you. For example, let's say Mr. Kishore has received foreign contribution, and now you are receiving foreign contribution from Mr. Kishore. Means, see here, Mr. Kishore has received foreign contribution. Now Mr. Kishore is in India, and Mr. Kishore has received from a foreign source foreign contribution. Now Mr. Kishore is giving it to Mr. Anuj or Mr. Jay, and this thing. Now technically Mr. Kishore is in India only, still it will be treated as foreign contribution. So if you are receiving a contribution from someone who is in India, who has received foreign contribution, then for you also it will be treated as foreign contribution only. However, later on you will get to know this, that now it is prohibited. Like if you receive foreign contribution, you cannot transfer it. But then definition they have not changed. Then this is, if there is any interest or income on foreign contribution, even that will be treated as foreign contribution. So you have received foreign contribution of 10, let's say 20,000 deposited in bank, and you got interest of 5,000, then even that 5,000 will be treated as foreign contribution. Then this is the fees if you receive for education, or you receive a scholarship from a foreign source, or if you have exported something and you are receiving consideration against that, then that will be not treated as foreign contribution. Obviously, export is not contribution. Contribution means donation, and fees for education to motivate education. This is, it will not be treated as foreign contribution. So, what is a foreign contribution? Foreign contribution is donation, delivery, or transfer made by any foreign source of any article, currency, or security. Currency include Indian, foreign both. Security include security under SICRA as well as FEMA. That is Indian security as well as foreign security. Then this is that if you have earned interest or income on foreign contribution, even that will be treated as foreign contribution. If you have received from someone who has received foreign contribution, even that is treated as foreign contribution. Then this is fees will not, fees for education will not be treated as foreign contribution, as well as if you are getting some export consideration, that will not be treated as foreign contribution. Now, what is foreign hospitality? Means any offer not being purely casual one. So, they say that offer has to be formal. Then that offer can be in cash or kind for providing cost of travel to any foreign country, travel, lodging, boarding and medical treatment. That means what? Some foreign source is giving me what? Is giving me some offer, which is a formal offer. They have sent me an invitation letter, fine, and that can be in cash or that can be in kind, and they are providing me one out of these three things. Means travel to foreign country, means USA is telling me come, we will arrange world tour for you. So, this is travel to foreign country, or they are incurring my travel, lodging, boarding expenditure. Now, I went to USA and they are providing all 5-star hotel stay and everything. Or if I am suffering from something and they have given me the medical treatment thing, that will be treated as foreign hospitality. Now, what is foreign hospitality? Foreign hospitality means any offer not being purely casual one, whether made in cash or kind by any person for providing cost of travel to foreign country or travel, lodging, boarding or medical treatment. I hope it is clear to everybody. Then the next point, foreign source. What is the foreign source? I'll tell you. Please understand. This is a foreign source means, can I say this is the most important definition now, because anything is coming from the foreign source will be governed under this act. So, they have kept a very wide definition for foreign source. This is, first of all, there are two government related things which will come under foreign source. First is foreign government, that is USA government, UK government, international agencies, for example FBI, etc. But then this is, it will not include United Nations, International Monetary Fund and World Bank. Sir, why it is not treated as foreign source? Basically, the whole idea of this act is, if something is foreign source, then there is a risk that that person give you money and then they may give the money in India, they may send the money in India to disturb the Indian economy, to disturb the situation in India, something like that. So, to control that, these things are there. Now, can I say United Nations, IMF and World Bank will not do that. It is not their duty. They are there to protect the country. So, they are saying that if it is international agency, United Nations, IMF and World Bank will not be treated as what? Foreign source. Then for company, as far as company related, there are four things. There is foreign company will be treated as foreign source. Foreign corporation will be treated as foreign source. Multinational corporation will also be treated as foreign source. Then this is Indian company in which at least 50% shares are held by the foreign person will be treated as foreign source. Now we will say, sir, but then you told me that subsidiary of an foreign company is also the foreign source. You told us that subsidiary of a foreign company will also be treated as foreign source. So this shall not be treated as foreign source. So they are saying here, see here what they are clarifying, that please understand, they are saying that boss, now can I say, even if you are a subsidiary of a foreign company, but if the investment is made within FEMA limit, then it will not be treated as a foreign source. So how you have to interpret the whole situation? See, if you are a subsidiary of a, if your 50% or more shares held by foreign person, then ideally you will be treated as foreign source. But if the investment is within FEMA limit, if the investment is within FEMA limit of FDI, foreign direct investment, in that case you will not be treated as foreign source. So can say if there is a subsidiary in India of a foreign country, so ideally they are the foreign source. But if that subsidiaries if there is an investment in the subsidiaries within FEMA limit, then it will that Indian subsidiary of the foreign company will not be treated as what? Will not be treated as foreign source. I hope it is clear. Then others, under others, this is trust, trade union, society of a foreign country. So they are the foreign source. Now let's revise. As far as government is concerned, foreign government, international agency other than IMF, World Bank, United Nations. Then this is, as far as company is concerned, foreign company, foreign corporation, multinational corporation, or any Indian company whose at least 50% share capital is held by foreign person. But if the investment is within FEMA limit, then in that case it will not be treated as foreign source. Then this is trade union, society, trust, can say of a foreign country will be treated as foreign source. Now, few are prohibited to accept the foreign contribution. Who all are prohibited to accept the foreign contribution? This is first is politics related. If you are an election candidate or a member of legislature, MLA, MP, etc., if they cannot receive the foreign contribution. Why? Because otherwise what will happen? Foreign country will give them money and then they will tell you, do dharna, do this, do that, disturb the economy, disturb the social harmony of the country. That's why this is election candidate, member of legislature or office bearer of political party. Member of legislature means MP, MLA, all that people. Office bearer of a political party means important person of the political party. For example, in BJP it is Mishra, in Congress it is Rahul Gandhi, like that. So office bearer of a political party, or if you are a political party itself, or you are a political organization, for example RSS, for example I have given you. So these people cannot receive foreign contribution. Why? Because then this is possible that they might take money from the foreign source and then they may do something which may affect the social harmony of the country. So they are not allowed to take foreign contribution. Then related to politics means any person who is likely to support politics. For example, let's say if there is a thought that if Anupam Kher will receive the money, he will support BJP, or if this is an example I am telling you, or if Swara Bhaskar will receive the money, she will support Congress. If there is such thought, any person who is likely to support any political party, then in that case this is even they cannot receive foreign contribution. Then this is if you are an employee, government servant, for example IAS officers, etc., they are the government servant, even they cannot accept foreign contribution. Why? Because otherwise there is a possibility that they are into the implementation of government policies, then they may implement in such a way that that might disturb the social harmony of the country. Or if you are a judge, then they may end up giving some judgment which may create disturbance in the country. So that's why they cannot receive. And then the media related, newspaper editor, news channel editor, news channel, newspaper, news channel. Why? Because obviously they can maneuver the thought process of the people, and that's why they are not allowed to receive foreign contribution. Otherwise the foreign country, foreign source may give them foreign contribution to spread such news which may create disturbance in the country. So this is what you have to remember. I have arranged in a manner chote se bada, from small to big, so you can remember. Election candidate, bigger; member of legislature, bigger; office bearer of political party, bigger; political party, bigger; political organization, like that. Then government servant, judge, bigger; newspaper editor, news channel editor; newspaper, news channel, like that. So tell me, who cannot receive politics? Election candidate, member of legislature, office bearer of political party, political organization. Then this is a government servant, judge, newspaper editor, news channel editor, then news channel. They cannot receive. But these people can receive in this situation. So this is an exception. When these people can receive the foreign contribution, so this says these people can receive the foreign contribution in this situation. Number one, by salary and wages. For example, they can receive by way of salary, wages. Look here. For example, can is a member of legislature. For example, I am talking about Subramaniam Swamy. He is a member of legislature, but he went outside India. He took lectures. Dr. Shashi Tharoor, he took lecture. Dr. Subramaniam. So they are getting the money, but from the foreign university. But as a salary, wages they can receive. Or you are a politician, but you are a businessman also, and if you have exported something and you received export consideration, then also, for example, earlier Mukesh Ambani was a Rajya Sabha member, but he is a businessman also. Now let's say, now he is not, earlier he was. Now he has exported and he got the consideration. Now it's a normal thing. You cannot say he is a member of legislature. So it is like that. Then Indian embassies, now they are the government servant only, but they stay outside India to solve the issues of the people of India in that country. So those are Indian embassies. So they have to receive lot of services, lot of things, lot of contribution from those foreign country when they are in that country, but that is a need for them. So even they can receive it. It is in exceptions. Indian delegate. Now earlier Dr. APJ Abdul Kalam used to go to NASA, and out of respect he used to get what? He used to get gifts from the foreign country. Now it is given to the Indian delegates. Now can I say he was the part of the country earlier? He was a scientist, so he was the government servant. Later on he became president of the country, you know, one of the most popular president of the country. So this is that when Dr. APJ Abdul Kalam went as an Indian delegate, he is receiving, it is allowed. Then if you are getting as a scholarship stipend, also allowed. For example, many politicians, you know, they study also outside India. So they study, yes, and they get scholarship and stipend. So that is also allowed. And now, as I told you, even political organization cannot receive the foreign contribution. Now the problem is, that means any organization would not like to be declared as political organization, but the central government can declare any organization as a political organization if they believe that that organization's modus operandi is like a political organization, means they work like a political organization. For example, so what is the procedure to notify any organization as a political organization? First of all, this is if the central government is of the opinion that any organization which is not registered but has a similar ideologies like a political organization, political party, means they are working like a political party, then they may notify any such organization as political party. Now what is the procedure they will follow? So for example, they want to declare RSS as political organization. By the way, now the central government and RSS, they are the chaddi buddy, they are the friend. But I am just giving an example. Had it been Congress, they would have tried to declare RSS as political organization. So like that. So central government will give notice to the organization, and they will say, we want to declare you as a political organization. We feel that you have ideologies like a political party. Would you like to say something on it? So the organization has to reply within 30 days. Sir, can they reply after 30 days also? Yes. Then the extension will be granted by the central government and they can reply within extended time also. Then they will give their representation. After that, the central government will forward this to, may forward, it's an option, to the authority for further verifications. After that, report of the authority will be given to CG, and then the CG will decide within 120 days, whether it want to declare as a political organization or not. If 120 days will be taken from this data, means from the day they have given notice to the organization, from that day only, within 120 days they have to declare it as a political organization. If CG want to take more time, they can take further 60 days out of 180, means total 180. Out of 120, that is total 180, that is 120 days plus 60 days more they can take, but then they have to record reasons in writing why the delay is there. So it is like that. I hope it is clear. Shall I proceed? Now section 6, restrictions on receipt of foreign hospitality. Please understand, what is foreign hospitality? Any offer not being purely casual one, given in cash or kind by any foreign source for the purpose of travel, lodging, boarding, travel to foreign country or medical treatment. So this is foreign hospitality. Now see, there was prohibition for foreign contribution to some person, but in case of foreign hospitality there is no prohibition, there is a restriction. Now what are the restrictions? That is we will going to discuss now. So please understand what they are saying, that if there is any foreign source and they want to give foreign hospitality, what I am telling you, if there is any foreign source and they want to give what? The foreign source wants to give foreign hospitality. So the foreign source can give the foreign hospitality to 4 people. Again I am repeating, foreign source can give the foreign hospitality to 4 people. Which 4 people? They can give it to government employee, they can give it to judge, they can give it to member of legislature, they can give to office bearer of political party, only if these conditions are satisfied. That means normally you can give foreign hospitality to anyone, no problem, but to these 4 people it is restricted. So it is not that you can give only to these 4 people, no. Apart from these 4 people you can give to anyone else unrestricted, but to give foreign hospitality to these 4 people, there is a restriction. Now how you can remember? From small to big, government employee bigger, judge bigger than that, member of legislature because they make law, then office bearer of political party. Why? Because they control member of legislature. Imagine Mishra is controlling the MLAs. So like that. So tell me, if foreign source is giving what? If the foreign source is giving foreign hospitality to whom? To remember, government employee, judge, member of legislature, office bearer of political party. So to give them foreign hospitality, first two things. What is foreign hospitality? I have told you. Can I say cost of travel to foreign country 1 and travel lodging boarding 2. To these two things they want to give. They can give it. They have to take approval of Ministry of Home Affairs. For medical aid also, normally they have to do this only. So the procedure I am teaching you from A to E is applicable for three purposes. Number one, cost of travel to foreign country or territory, travel lodging boarding, and medical aid, medical treatment in normal situation. To give these three things, this is, you have to take prior approval of Ministry of Home Affairs, MOHA. Ministry of Home Affairs, you have to take prior approval. When you will take approval, you have to send application. So this is that application shall reach to the concerned department. These are ministries, Ministry of Home Affairs. So there will be IS officer, etc., who will be giving you the clearance. So this is that it shall reach to the ministry, that is concerned department, at least 2 weeks before the journey date. So it shall reach to the concerned department at least 2 weeks before the journey date. Then this is, the application should be in prescribed form only, obviously the form which is mentioned. Then this is, application letter should also be given along with invitation letter of host country. Sir, is it necessary that they must be having invitation letter? Yes. Why? Because can I say, I told you this is a formal offer, not being purely casual one. So there must be invitation letter of the host country. You have to attach that also. And then if it is sponsored by, if it is financed by the government department, then you need clearance from the government department also. So what is the procedure? Tell me. For travel lodging boarding, medical treatment in normal situation, and cost of travel to foreign country, they are saying travel lodging boarding. So they are saying how you can do it, how medical treatment, like how you can do it. So you need approval of Ministry of Home Affairs. It shall reach to the concerned department at least 2 weeks before the date of journey. Then it shall be given in the prescribed form. Then this says that if it is sponsored by the government, then clearance of government is also required. You have to give invitation letter also. But what if it is emergent medical aid, sudden attracted when you are outside India? Means let's say some MLA is there who is in USA, and suddenly he got heart attack, and now that USA government will give him treatment. Now we'll say no, first go and take the approval. That is not possible, na? So if it is a medical emergency which is attracted when that person was outside India, in that case they don't have to take approval. This is the value is up to 1 lakh rupees. If the medical facility value is up to 1 lakh rupees, no intimation is required. Approval is anyway not required, but this is no intimation is required. And if it is more than 1 lakh, then you don't have to take approval, but you have to just intimate that you have taken this, and that has to be intimated within 1 month. I hope it is clear. Fine, shall I proceed? Transfer of foreign contribution by one person to another person. So I told you earlier it was allowed, but now if one person is receiving foreign contribution, that foreign contribution he cannot transfer it to another person. So let's say if Mr. Kishore has received the foreign contribution, he cannot transfer it to Mr. Sanjay. I hope it is clear. Fine, it is not allowed. Utilization of foreign contribution. What they are saying, please understand. If there is a foreign source, and if that foreign source is giving what? If that foreign source is giving foreign contribution to any person. So they are saying if there is a foreign source and that foreign source is giving what? That foreign source is giving foreign contribution to whom? To any person. Now there are two possibilities. That foreign contribution is given by the foreign source to any person for given purpose. Can he utilize it for given purpose? I'll give you with an example. If for example, can I say I'm running a NGO for education. Now the foreign source has given me the money for that purpose. Now can I use it for some other purpose? Like can I use it for a senior citizens camp, etc.? Answer is no. So whenever you receive foreign contribution from foreign source, can I say you cannot use it for some other purpose? You have to use it for given purpose only. That is, if I have received for this thing, education, then I have to utilize it for education only. But what happens, till the period I am not using this money, like I have to keep this money with something. So can I use that money for speculative activity? Means I said that I need education expenditure after 5 months. For next 5 months, I said that I will put this money in shares, etc. So this is no, boss. You cannot use that money for speculative activity. Otherwise, what if you lose the money? So you cannot use it for speculative activity. And in that given purpose also, admin expenses can be only up to 20%. You want to do it more than 20%, you need CG approval. What is administrative expense? That I will tell you in some time. But this is remaining 80% should be the core expenditure. For example, you can say I am running education. So for me, what is core expenditure? Expenditure on teachers, etc., books, etc. So the major expenses should be in that nature. Admin is like whenever there is a trust, there is a governing body. So expenditure made on governing body, maintaining of books, etc. means which is not directly used for the purpose of that NGO. So those expenses can be maximum 20%. Beyond that, you need CG approval. In some time, I will tell you what is admin expense. But tell me, when you receive foreign contribution, can you use it for the purpose other than it is meant for? Answer is no. For the given purpose only you want to use, but for some time you want to invest it in speculative activity, not allowed. Now, this is for given purpose only you want to use, but how much you can use for administrative? This is maximum 20. What if you want to use more than 20? You have to take CG approval, and remaining all amount need to be used for the core purpose for which it is there. For example, you are running a hospital, then you have to make the almost 80% expenditure has to be on doctors, etc. That is the core expenditure. So what is administrative expense? Let us understand this. This is, see, trusts, etc. always have executive committees. So this is the salary, wages, water charges, telephone charges, etc. paid for executive committee is administrative. They are like in company there is a board of directors, in trust there is an executive committee. So it will be considered as administrative. Then hiring charges means when you HR expenses, you are hiring employees. So those accounting, legal expenses, then utilities, like similar wherever the accountant and all are sitting, the water charges of those areas, all that will be treated as administrative. What if you are doing research and training? For example, you are running hospital, you are giving the training to doctors or giving the training to teachers if you are running school, or welfare oriented, you are making direct payment to doctors, direct payment to teachers. Obviously, that will not be taken as an administrative expense. I hope it is clear. Shall I proceed? Next is section 9. We have studied that under section 3, certain people are prohibited to receive foreign contribution. Then there was certain restrictions to receive foreign hospitality. Then subsequently, you will learn today that few people required to take registration under section 11. So this is, they are anyway prohibited, restricted, or they are anyway required to take registration. But apart from them, anyone else, if central government feels that anyone else should be prohibited, anyone else should be restricted, or anyone else require registration, so CG may further restrict, prohibit, or require registration of any such person. That is the power given to the central government under section 9. What section 10 is saying? When any person receives foreign contribution in contravention of this act, then CG may pass prohibitory order for dealing in foreign contribution. For example, please understand, you are the politician and you are the politician, can I say, or election candidate, you cannot receive foreign contribution, but still you have received, you have taken the foreign contribution. You are not allowed to receive foreign contribution, but still you have taken foreign contribution. Now what will happen? So if central government will come to know, they will pass prohibitory order. Prohibitory order means now you cannot use this foreign contribution. You are not allowed to receive, use this foreign contribution. This, sir, but there will be no penalty or what? Yes, there will be penalty, that we will discuss later on. Because you are doing mistake also, you are receiving, you are not supposed to receive, but you are receiving foreign contribution. So there will be definitely penalty, that we will be learning later on. But this is section is not for that. This section is only telling you that if you have received foreign contribution in contravention of this act, means you are not allowed, but still you have taking it, then central government will come and will pass a prohibitory order. In that situation, you are not allowed to deal in foreign contribution. Next is section 11, registration. Who is supposed to get registration and what type of registration they can take? If the person is having definite cultural, economic, social, educational, religious program, means they are doing a proper recurring activity. I am running school, I am running hospital, I am running charity places, I am running religious places. So I can get certificate, and that certificate can be given for 5 years, and then subsequently it can be renewed also. Within that 5 years, I can receive foreign contribution for any number of time. But what if you are not doing any definite cultural program, etc.? For example, there was a flood in the Uttarakhand. That time, lot of people came and they started supporting. So now let's say for that purpose only, I said that I want to receive foreign contribution, and then I will help the people who are suffering, who have suffered from the Uttarakhand flood. So can I say I am not doing this definite social program? It is not that I will keep on doing this. It is a one-time event. So in that case, instead of certificate, you can take prior permission, but in that case, you can receive foreign contribution only once. So there are two types of registration. Then this says CG may notify registration on this basis also. Means CG can say that if you belong to a particular category of person, or if you belong to a particular area, for example, Jammu Kashmir, then whoever you are, whatever you do, mandatorily you have to take registration. Or if you are running for a particular purpose, for example, lot of people in the name of religion, can I say they are running a NGO, but they do black, they convert that black money into white. So they can say if you are doing a particular type of activity, then mandatorily whoever you are, you have to take the registration. Or if you are receiving money from a particular source, for example, let's say China or Pakistan, then you have to get registration. So this is just a power that CG may notify that even if you otherwise not belong to a particular category, still you have to take registration if we want you to take it. It's like that. I hope it is clear. And now let us understand next thing. What is the difference between suspension and cancellation? Please understand. When there is any pending inquiry for cancellation, on that ground they can suspend you. When there will be cancellation, if there is some fake information has been filed, or if you have violated the terms and conditions of your registration, if you have violated this act, that is FCRA, if there is a public interest violation, if you are doing something which is affecting in public in general, or if you are not doing reasonable activity in last 2 years, means you have registered for certain activity, but you are not doing those activities in last 2 years, means you have formed for hospital as a hospital, you are not treating any patient or something like that in last 2 years, then they can cancel your registration. Suspension can be for maximum 180 days. So it can be less than 180 days, but maximum it will be 180 days. Cancellation will be for minimum 3 years. It is other way around. It can be more than 3 years, but cannot be less than 3 years. Then says, when you are suspended, can you utilize the foreign contribution? This is yes, but only up to 25% you can utilize. And for that also you need CG approval. But if your license has been cancelled, you cannot utilize anything. Then this is, can you receive a foreign contribution? This is yes, you can receive foreign contribution. But to receive that foreign contribution, you need CG approval. So it is allowed, but it is allowed with CG approval. As far as cancellation is concerned, it is not allowed at all. So if your license is cancelled, you cannot receive foreign contribution at all. Section 15, management of foreign contribution. Now please understand one very important thing. I told you license can be cancelled. License can be cancelled. So what if your license is cancelled? Because you must be already having lot of foreign contribution, which you must have taken for doing some charitable activity. So this is that if license of any person is cancelled, then any amount available shall be transferred to such authority as may be prescribed. Normally central government has prescribed banking authority. So let's say if Mr. Kishore is running the NGO, and if Mr. Kishore's license have been cancelled, then any foreign contribution lying with Kishore can say normally it is transferred to a banking authority who do the activity for which this foreign contribution has been taken. So prescribe, and that authority shall utilize it for the purpose it is formed. For example, if it is formed for medical purpose, then it will be look after the health facility. That money will be used for the health facility. When foreign contribution is not sufficient, then asset can be sold to achieve the purpose. Means the foreign contribution which you have received is not sufficient to carry out the charitable purpose. So the asset which is lying with the trust, with that NGO, can say even the asset can be sold out and they can use it for the charitable purpose. What if meanwhile Kishore got his license back, then in that case the asset or the foreign contribution which is transferred to that authority, for example bank, they have to reinstate it, they have to return it to the Kishore. So if certificate is reinstated, then such asset will be given back to such person. I hope it is clear. Renewal of certificate. I told you for what period maximum certificate can be given. So this is certificate can be given for maximum 5 years at a time. So can you renew it? Yes, you can renew it. So there are two things, please understand. First of all, any person who has to first pay the fees of 1500 rupees and application will be done in the prescribed form, and the check will be by account pay check in the name of Ministry of Home Affairs, and it will be sent to central government. Now there are two possibilities. Central government may reject your application, and in that case they will give you reasons for rejection also. But there are few things which is given in Right to Information Act, RTI Act, and in RTI Act there are certain criteria in which they says that you should not disclose the reason. So if you are falling in those reasons, then RTI, as per RTI, then central government will not disclose you the reason for rejection, but otherwise they will disclose the reasons for rejection. But if they will accept your application, in that case they will give you license for 5 years. Fine. Now please understand, now you got the license for 5 years. Now when can you renew? So this is that whenever your license is about to get over, let's say this here the 5 years will get over, then immediately in last 6 months only you can make application. Means, can I say, to put it other way around, can I say you can make application only after the expiry of 4.5 years. So you can make application after expiry of 4.5 years, that is only in last 6 months before your license will get over. So in that 6 months only. Now please understand what they are saying, that after that 5 years get over, please understand, after that 5 years get over, and assume in last 6 months you have not made any application, then can you make after the expiry of 5 years? That I will come in some time. But whenever you make the application, it is the duty of central government to reply within 90 days. In 90 days they can accept the application as well as they can reject the application. Now I am coming back to my question, that if 5 years got elapsed and you have not made any application, can you apply after 5 years? So normally it is not allowed. After the expiry of that tenure, normally it is not allowed. But on a genuine ground, they can give you extension and you can apply in next 1 year also. But for that there is additional fees of 5,000 rupees. Along with that you have to tell the reasons for delay. So like that it is the point. I hope it is clear. Now next point, they are talking about section 17. Foreign contribution through scheduled bank. This is here we want to track how you are receiving foreign contribution. So that's why this is that whatever any registered person who want to receive foreign contribution, they have to open FCRA account, and that FCRA account mandatorily need to be opened in SBI, and that too in Delhi branch, any branch of the New Delhi. So first of all, if you are receiving a foreign contribution, fine, you have opened, you have registered yourself, you are receiving a foreign contribution. They are saying you can receive foreign contribution through one bank and one account, through one bank and one account from the foreign source, and that too that account should be in SBI, and that too in any branch of the New Delhi, so that government can easily track. Now you will say, sir, but that person is receiving foreign contribution, but that person is not from Delhi and he is operating in different parts of the country. So how he will use it? This is that utilization can be from any number of account, but receipt has to be from one branch and one account only. So that means, can I say, from that bank they will transfer it to different accounts and they can utilize from there. But receiving has to be from one bank, one account, SBI bank, Delhi branch, any Delhi branch. And in that branch you cannot deposit any other amount, shall not use to deposit other amount. So in SBI, that branch, you will receive only foreign contribution, you will not receive any other amount apart from that. And once that SBI branch has received the money, they will report this within 48 hours along with amount, source and other detail to the authority of the central government, that we have received for Mr. So and so foreign contribution. As I have already told you, it can be utilized through multiple account. Utilization, there is no restriction, you can utilize it through multiple account. Next is manner of intimation, section 18. What they are saying, if the foreign source, if from the foreign source any person is receiving foreign contribution, then now how that person need to intimate? First of all, this is form FC4 and FC1 will be signed electronically online, number 1. For article and for foreign, foreign security, they have to sign electronically and they have to file form FC4 and FC1. Along with that, they have to file income and expenditure account, receipt and payment account, and balance sheet. So they have to maintain income, expenditure, receipt, payment, and balance sheet, which will be certified by a chartered accountant, and it shall be preserved for how many years? 6 years. But sir, if there is no foreign contribution they have received in any financial year, then nil return will be filed. Then nil report will be filed. I hope it is clear. Nil will be filed. So it is very simple. Shall we proceed? Next point. This is section 19, maintain accounts. This is every person shall maintain in such form and manner as prescribed two things: account of foreign contribution received and record of foreign contribution utilized. So you have to maintain two separate account. You have to maintain kya? Two separate account in which you are receiving foreign contribution and in which you are and the details of utilizing the foreign contribution. So two separate account need to be maintained. So whether it can get audited? So see, central government can conduct this audit. But then when this audit will get conducted, can I say when? So if any person failed to furnish the requisite information to central government. Now central government is of the opinion that something wrong is happening in that trust. Then in that situation, can I say they can conduct audit? Who will do this audit? Group A post officer. So the level of the person who will audit should be Group A post officer. Whatever information is obtained after that audit need to be kept confidential. Obviously it will be shared with the government, but otherwise it will be kept confidential. And when they can do all this audit work? During daytime. Obviously you cannot go in night and audit like that. Next point, disposal of an asset. What if the person who has taken registration become defunct, or if it does not exist, passed away, or if it is artificial person, it become defunct. So in that case, if any person cease to exist or if any person become defunct, then this is that asset of such person shall be disposed, obviously, because it has to be used for the charitable purpose. So it will be disposed in the manner given by the central government, and it will be done by the authority appointed by the central government. So they are saying that if any person has defunct, then the foreign contribution which is lying with them, central government will appoint somebody and tell them that use this money, use their asset for the charitable purpose, and the manner and the person who will do this, everything will be decided by the central government. Now we are going on to the next concept, offences and penalties. What they are saying, if you have provided false intimation, or if you have done fraud, or if you have given false information, in that case there will be jail up to 6 months, fine, whatever the decided by court, that is suo motu. Then if you are doing the contravention of section 10, wait now, these two sections, these 2 points you have to understand in connection with each other. They are saying that if you accept foreign contribution in contravention of the act, for example, can I say what they are trying to say, you are a political person, you are an election candidate, can I say you cannot receive foreign contribution? Now you have received the foreign contribution, then you will fall in point number 3, accepting foreign contribution in contravention of the act. And now you have received the foreign contribution. After receiving the foreign contribution, after what I am telling you, after receiving the foreign contribution, government got to know. So there will be first penalty will be that you are the election candidate. So you were not supposed to receive the foreign contribution, you have received it. So the punishment is 5 years and fine is, imprisonment is up to 5 years and fine is as whatever decided by the court. And after receiving the foreign contribution, government got to know, they have imposed prohibitory order on you under section 10. They said that you cannot deal in this foreign contribution. Now they are saying that after that prohibitory order also you have used that foreign contribution. So now the punishment will be in point number 2 and the imprisonment will be up to 3 years, fine whatever decided by the court suo motu, and additional fine can also be levied which can go up to 100% of the foreign contribution. So it is like that. Then this is if you do any activity which is liable for confiscation of foreign contribution. For example, again say you are the eligible person, you have received foreign contribution, but you have utilized it for the speculative activity which was not allowed. So in that case, punishment can be 5 times of the amount of foreign contribution or 1000, whichever is higher. So if the amount is 100 rupees, then it will be 500 or 1000 higher, higher is 1000. So like that, if the amount is 2000, then 5 times will be 10,000 or 1000 higher. What is higher? 10. If the amount is 200, yeah, amount is 100, then it will be 500 or 1000 higher. Higher is 1000. So normally you understand, na, this will be a big amount only. So it is like that. Then this is general penalties. If there is no offences prescribed, if there is no punishment prescribed and you are doing such offences, then it will be imprisonment up to 1 year, fine, whatever the court will decide. And if you do any repeated default under section 35 and 37, then fine will not be there. But in that case, this is that you cannot receive foreign contribution for 5 years. I hope it is clear. Now, adjudication. Adjudication means giving judgment, adjudging. So, if article, currency or security, that is foreign contribution, is more than 10 lakhs, then who will do the adjudication? So, the first authority who will do the adjudication is court of session, that is session court. They will give opportunity of being heard and then they will give the judgment. And if you are not happy with this order, then by the way, then you will file the appeal to High Court. Within 60 days, extension can be granted for another 60 days. And if you are not happy with the High Court order, you can go to Supreme Court. Within 60 days, extension can be granted for another 60 days. Now, this is if the foreign contribution, that is your article, currency and security is up to 10 lakhs. In that case, who will do adjudication? In that case, the adjudication will be done by assistant session judge. Who will do the adjudication? Assistant session judge. And against that order, you can file appeal to whom? To session court. And that appeal can be filed within 1 month. And the extension of 1 month can be granted. So, it is like that. Now, when session court has given the order, you want to go against, appeal against, see, so you can see that if the value is less than 10 lakhs, up to 10 lakhs, then the adjudication is done by the lower authority, assistant session judge. And if the value is more than 10 lakhs, the adjudication is done by the higher authority, session court. So it is like that. Then after court of session, same thing. It is not given in your module, but it is obvious that from high court, session court, you can always go to the higher authority. So you can go to High Court within 60 days plus extension of 60 days, and then you can go to Supreme Court within 60 days, extension of 60 days. So what they are saying, adjudication, these 2 points. Fine. If the article, currency, security is less than 10 up to 10 lakhs, then you will go, the adjudication will be done by assistant session judge. Appeal can be filed within 1 month plus extension of 1 month can be filed to session court. Then from within 60 days plus extension of 60 days can go to High Court. Then within 60 days plus extension of 60 days can go to Supreme Court. And if the article, currency, security is more than 10 lakhs, then this thing, adjudication will be done by session court, and appeal can be filed to High Court within 60 days plus 60 days extension, and Supreme Court 60 days plus 60 days. Offences by company. If company is doing some offence, or if the company has done some offence, then who will be punishable? So this is company will be punishable, person in charge will be punishable, director and secretary will be punishable. And now they will be, when they will be liable, if offence is done knowingly, or if there is a gross negligence, then they will be liable. But if they prove that they have worked in good faith and if they have applied due diligence, then they will not be liable if it is without their knowledge. Then next is compounding of offence. What does it mean? See, when there is only fine, then reducing fine will be the compounding. And when there is fine as well as jail, then instead of jail, if you are charging fine, that is also compounding. So there are 2 ways of compounding. But when the law has written imprisonment only, or fine and imprisonment, again in that case compounding is not possible. Who can do the compounding? So this is any authority designated by the central government can do the compounding. And this is if you have repeated same offence within 3 years, means you are a regular offender, then it cannot be compounded. Sir, after 3 years, yes. But if the same offence is repeated within 3 years, it cannot be compounded. Now next is audit and investigation. See, normally what happens, this trust and all under this act, they have to get audited as per Companies Act if they are formed as company from the CA having COP. But along with that audit, special audit can also be ordered, and which will be done by Group A post officer, which we have just now studied, and it will be appointed by central government. Then this is investigation will also be done, whatever we have studied earlier, section 206 to 229 that we have studied in Companies Act. And special investigation can also be ordered by the central government. What will be the power of inspector? Civil court power. They can inspect books of accounts, they can make copies, they can summon, they can take oath. So all these things, inspect, they can verify books of accounts, they can they can take the photocopy of the book and they can take it, they can ask the person to appear in person, or they can take it on oath. It is like that. Power of central government. Can the central government exempt? Do they have power? So this is that they can exempt any person, association, organization or individual. But this is that if that organization is the political party, they cannot exempt. Why? Because otherwise what will happen? The political party which will be in power, they will exempt themselves. That is why you cannot exempt political organization as well as election candidate. Otherwise all the ministers will exempt themselves only. So these two people cannot be exempted. Then this is anything given under FCRA. This is that if any two dealings are done between foreign government and Indian government, then FCRA will not apply. Why? Because these are two governments. So they will not do business to destabilize the economy or destabilize the country. It is like that. Then this act is in addition and not derogation of FCRA. Means what? It can say means if some other law is there which is talking about FCRA, you will follow that law also and this law also. It is always, you have to read this way, that whatever, both laws will be complied. So what if they have given something which is against this? Then you have to see which is more specific law. If that law is specific, that will override. If this, then this will. But otherwise you have to make the harmonious construction. So that's all in FCRA. Okay, now we are moving on to the next chapter, that is Foreign Exchange Management Act. This is a very big chapter, but I have tried my best to make it as comprehensive and to complete it in as limited time as possible. So first thing we'll discuss in this is definition. What is the definition of currency? So they have kept it a very exhaustive definition. This is, it includes notes, coins, check, postal order, money order, traveler's check, ATM card, debit card, credit card, everything. By the way, from ATM card, debit card, credit card, they have tried to cover all the electronic forms of currency also. Then this is what is foreign currency. So this is any currency other than Indian currency is a foreign currency. Fine. So can you say, for example, dollar, pound, these are all foreign currency. Then this is what is foreign exchange. Now in this is if the bills of exchange is drawn in India, but if it is payable outside India, it's a foreign exchange. For example, it is drawn in Mumbai, but it is payable in Las Vegas, New York. So it's a foreign exchange due to the destination. Destination is outside India. Then this is if the bills of exchange are drawn outside India but payable in India, then also it's a foreign exchange. For example, it is drawn in, let's say, New Jersey or UK, but it is payable in India. So if it is drawn in US or payable in India, it is a foreign exchange. It is because of the source is outside India. Or if the bank balance is maintained by non-resident, then also it will be treated as foreign exchange. For example, if the Bill Gates is maintaining some foreign bank balance in India, so for that it will be foreign exchange. Why? Because the ownership is of the person who is non-resident. So it is like these three are foreign exchange. Then as far as person definition is covered, they have ideally covered all types of person in this, like individual, HUF, AOP, BOI, company, partnership firm, AJP, LLP, every type, except the one thing is that one new thing they have inserted, and that is branch agency office. And normally if you will see under income tax, all these are anyways treated as a company, like individual, HUF, AOP, BOI, partnership firm, LLP, company, AJP, these are anyway treated. But here the one new person they have inserted, that is branch agency office. So let's say if there is some foreign company is there who just have a branch over here and no other things, so that branch in India can be also be regarded as a person. I hope it is clear. Next is foreign security. So this is any security which is expressed in foreign currency is a foreign security. So can I say if there is any security which is issued in India, so if you will see it is issued in India, but if it is expressed in foreign currency, for example dollar, pound, etc., then even if it is issued in India, it will still be regarded as foreign security. So I hope these definitions are clear. Now the most important definition is about how to determine the residential status. So if the person is an individual, first what we have to see, we have to check last year's stay. So you want to see the residential status of financial year 22-23. For financial year 22-23, you have to check the stay of financial year 21-22, that is of last year. So if this is if in last financial year, if stays for less than 183 days, then the person will be regarded as non-resident in current financial year. But here ICI have one more opinion. So that is also I am telling you. If in the last financial year the stay is for less than 183 days, then in current year the person will be treated as non-resident. But if he is coming to India for three purposes, that is employment, business vocation, indefinite period. If he is coming for these three purposes, then even if the last stay is less than 183, but if he is coming to India for these three purposes, then he will be treated as a resident. So this is one thing. ICI keep on changing their view, but this is the view they have in last 2-3 years they have maintained, that if the stay in India in last financial year is for less than 183 days, then ideally the person will be treated as non-resident for current year. But if he is coming in India for that three purpose, employment, business vocation, indefinite period, then in that case the person will be treated as a resident. Then this is if you stay in India in last financial year for 183 days or more, then ideally you will be treated as what? Resident. But if you are going outside India for that three purpose, which three purpose? Employment, business vocation and indefinite period, then in that situation you will be treated as non-resident. If you are going for some other purpose, then you will still be treated, even if you are going, then still you will be treated as a resident for that current year. Then this is if you are coming to India again for these three purposes, employment, business vocation, indefinite period, then you are a resident. Coming for other purpose and non-resident. So how you have to remember? Stay in India in last financial year for less than 183 days, ideally non-resident in current year. But if you are coming in the current year for that three purpose, then you will be treated as a resident. Stay in India in last financial year for 183 days or more, then usually you will be treated as a resident. But if you are going outside India for three purpose, employment, business vocation, indefinite period, then you will be treated as non-resident. Going for other purpose, then you will be treated as resident. Then third situation, if you are staying in India in last financial year for 183 days or more, and current year you are coming to India for that three purpose, employment, business vocation, indefinite period, then resident. Coming for other purpose and non-resident. I hope it is clear. Then this is for artificial person. If it is a company etc, and if it is registered in India, it will be treated as what? Resident. Let's say if it is a branch agency office, then when it will be treated as resident? This is if it is registered, if that branch agency office exists in India, then it will be treated as a resident. Or if the branch agency office is outside India but it is controlled by PIRI, even in that situation it will be treated as a resident. But if it does not satisfy either of the condition, then it will be treated as non-resident. So if it is registered in India, resident. Or if it is a branch agency office and if it is in India, then also it is resident. If it is a branch agency office which is outside India, but the PRI is controlling that branch agency office, then also it will be treated as a resident. But if otherwise, if it is not falling in any of this situation which I have told you, then it will be treated as PROI, that is non-resident, person resident outside India. Then section 3 says restrictions for dealing in forex. Forex means foreign exchange. This is if you want to deal in forex with any person other than authorized person, you need RBI's prior approval. For example, I have a dollar. Ideally, I can sell the dollar to authorized person only, and if someone want to buy, then they have to buy from authorized person only. Now let's say I want to sell my foreign currency, foreign exchange directly to my friend, then in that case we need prior approval of RBI. Then this is restrictions for making payment on behalf of non-resident. For example, I have a friend who came to India. Now he has done a lot of shopping. Now he is a non-resident. I want to make payment for his expenditure. So for that I need RBI's prior approval. Why? Because otherwise, don't you think if he will give in foreign exchange, and if I will give in INR. So don't you think it will the government will miss the opportunity of getting foreign exchange if I will pay in his behalf? That's why they need prior approval of RBI. Same way, restrictions on receipt of foreign non-resident. So this is that if you are receiving on behalf of non-resident, you need RBI prior approval. Why? Because today if you are receiving in INR and tomorrow if you want to pay back to non-resident in dollar, then there will be a negative capital outflow, and that's why government says that if you are receiving on behalf of non-resident, then you need prior approval of RBI. There are exceptions also for these things, but it is not there in your syllabus, and that's why I'm not going to discuss that. Last is entering a financial transaction in India due to which asset or liability outside India get altered. Let's say me and Angelina Jolie, if we are, let's say I have drawn bills of exchange on Angelina Jolie in India, but now she is saying the payment will be made outside India. So can I say we have done financial transaction in India, and due to which my asset and her liabilities outside India is getting altered. So even that requires prior approval of RBI. Section 4. If Section 4 says that for three things, that is immovable property outside India, foreign security and foreign currency. Ideally, if you want to transfer these three things, or you want to acquire these three things, or you want to hold these three things, you need prior approval of RBI. But in some situation, you don't need any order, it is allowed. So this is that if immovable property outside India, if when it can be transferred, held or acquired without RBI approval. So there are 4 exceptions for immovable property outside India. This is that, see, normally the situation is you want to transfer, you want to acquire, you want to hold. For immovable property outside India, you need RBI's prior approval. But if you have held, if you have acquired when you were non-resident, then you can continue holding it. Even if you will become resident, you don't need RBI approval. Or if you are getting it by way of gift or inheritance, then you can acquire it, even transfer it, even hold it, and you don't need RBI's prior approval for that. Or if it is acquired out of RFC account. What is RFC account? So can I say, when you are a non-resident and when you plan to come permanently to India, then that time whatever the amount you have in foreign currency, they allow you to keep it in India in that form, and that is called RFC account. So it is a relaxation given by the government. So this is if you want to acquire out of RFC account, then also you don't want any approval for that. And last is lease up to 5 years. If you are acquiring it on lease, and if the lease tenure is not more than 5 years, then also it is permitted. So these are 4 exceptions. Then this is that foreign security. Normally if you want to transfer, acquire or hold foreign security, you need RBI's prior approval. But this is when you have acquired it when you were non-resident, or if you are acquiring it by way of gift or inheritance, or you want to acquire it out of RFC account, then there is no restriction. I hope it is clear. Then next is foreign currency. To acquire, hold or transfer foreign currency, you need RBI's prior approval. Then this is that, see, if you have acquired before 8 July 1947, so that time lot of foreign currencies used to be treated as an Indian currency only, because we were under the colonization of UK. So it is like that. So this is that if you have acquired before 8 July 1947, so you can still hold it, no problem. Or if you are an authorized person and you are holding foreign currency, so for you it is a business, you can hold it, no problem. If you are holding it in RFC, EFC account, what is EFC account? Exchange Earner Foreign Currency account. It is the account which is usually maintained by exporter. Whatever they export, they get foreign currency in that account, and whatever they import, they pay from that account. So in that account you can hold foreign currency, no problem. You want to hold it as a hobby. A lot of people keep coins of different currency notes. So that is as a hobby. That is also allowed. Or up to US dollar 2000, it is allowed in this 4 situation. When I say US dollar 2000, can say even if it is of other currency, of other country like pound, etc., it is allowed to the extent of equivalent to $2000. So if it is acquired out of service rendered outside India, or by way of gift inheritance, or by way of honorarium, or unspent foreign travel amount. Let's say I have taken lectures outside India and I got $2,500. So I have to return $500, and $2,000, up to $2,000 I can hold it. Or someone is giving me gift, or I am getting by way of inheritance those foreign currency, I can hold up to $2,000 balance I have to give. Honorarium, for example, this Shah Rukh Khan, etc., take lectures outside India. So they don't charge for that, but then out of respect they have been paid. That is called honorarium. That amount, if it is more than $2,000, you can hold up to $2,000. Rest you have to return, and I mean you have to convert it into INR. Then this is unspent foreign travel amount. I went outside India, I came back to India. Now I left with some $2,600 US. So $600 I have to repay, 2,000 I can hold it, like that. Or 2,200 if I am having 200, I have to repay, 2,000 I can hold it, like that. So these are an exception. I hope it is clear. Now next point, capital account transaction. Obviously for a capital account transaction, border need to be altered. If you are in India, it should be done something which will affect outside India, and if you are outside India, it should happen something due to which asset in India get altered. So same thing they have said here, that for resident, any transaction due to which assets and liability including contingent liability outside India get altered, obviously. So for a resident, anything if you are doing due to which asset and liability outside India including contingent liability outside India get altered, it is a capital account transaction. So what is for non-resident capital account transaction is? So this is for a non-resident, any transaction due to which assets and liability in India get altered will also be treated as a capital account transaction. But for non-resident, they have not specifically written contingent liability. My opinion, ideally they wanted to include, but inadvertently they missed writing the contingent liability. So we will read that way only. For resident, asset, liability, contingent liability outside India. For non-resident, asset, only asset and liability in India get altered will be treated as what? Capital account transaction. What is capital account transaction? Any transaction other than, what is current account transaction? Any transaction other than capital account transaction is a current account transaction. Now to put it in simple language, can I say in the balance sheet whatever things you see, these are capital, if those things are altered, that is a capital account transaction, and expenditure which what is revenue in nature is treated as current account transaction. So this is somewhere will be helpful to remember. Then they have given some examples of current account transaction. For example, loan, you know, it's a capital account transaction, but interest on loan is a current account. Then if your parents, wife, children are there outside India and you want to pay their living expenses, even that is current account. For foreign travel you are going, expenses for that is a foreign travel. This is important. Short term credit, ideally it's a kind of loan, but it is a very short in nature, like cash, credit, etc. That is outside India. So even these will be treated as current account transactions only. So now for a current account transaction, there are three schedules. Schedule 1 says whatever the transaction is there in schedule 1, those transactions are prohibited. Schedule 2 says if you are doing the transaction, then what is there in schedule 2, you have to take central government approval. Schedule 3 says whatever there in schedule 3, you have to take RBI's approval. What if some transaction is there which is not covered in schedule 1, schedule 2, schedule 3, then what will happen? So this is that if it does not fall in any of these above 3 transactions, then these transactions are freely allowed. What I told you, then these transactions are what? Tell me, freely allowed. Now let us learn this one by one. Schedule 1, this is prohibited transaction. Now in this first is remittance out of lottery winnings. What is lottery winnings? Now let's say I have taken a lottery ticket in India, and I mean some, let's say some foreigner came to India, they have taken lottery tickets and then they won it. Now they are taking outside India, so it is not allowed. Government says that boss, there is a huge lot of effort in service, but in lottery there is no effort. You are getting it without effort and you want to take it outside India, that will lead to a huge negative capital outflow. So that's why we will not allow it. Same way horse race riding, etc. So these are also a casual income only. If you have won in India and you want to take that money outside India, not allowed. Or you want to purchase a lottery ticket outside India, not allowed. Again, there is a risk that if you will win, the other country may not allow you to take that money, and the probability of winning is also very less. So government does not want to take a risk and they don't want to waste the foreign currency. So this is that if you want to purchase lottery ticket and for that you want to take foreign currency, will not allow you. Same with football pool, these are betting activities, swift skates, betting activity. Then banned or prescribed magazine, any magazine which is banned, but then you want to take foreign currency and you want to buy outside India those magazines, so that is also not allowed. The next is payment of dividend. Now payment of dividend, where dividend balancing is applicable. What is dividend balancing? Under a dividend balancing, can I say government put restriction that whatever you want to pay dividend to a foreign partner, that is your foreign investor, you can pay only from the foreign exchange earned. So by default, can I say you cannot withdraw the money from government, you have to pay only what is there lying with you, and that's why this is that if you want to pay the dividend where dividend balancing is required, then for a withdrawal of foreign currency is not allowed. Sir, what if dividend balancing is not applicable to some industry? So when it is not applicable, then it is permitted. So if in exam it is written just a payment of dividend, you have to assume dividend balancing is not applicable and the payment is permitted. But when it is written payment of dividend where dividend balancing is applicable, then in that case you have to write it is not permitted. Then see, you want to make payment to equity investment in joint venture, means some joint venture is there where you are a co-venturer and the export has been taken place to the joint venture by you. You are who? You are the co-venturer and you have done some export to the joint venture, and in that joint venture for that export you have hired some agent and you want to pay commission to that agent. Now that is not allowed. Why? Because obviously it is your joint venture, you should know first the requirement, not the agent. So this is for that export commission payment is not allowed in foreign currency. Or if there is a wholly owned subsidiary, 100% shares are held by you and you want to export to that wholly owned subsidiary, that export is permitted. But for that export you want to hire agent and you want to pay commission in foreign currency, and for that you want to draw foreign currency, that is not allowed. I hope it is clear. Then when there is a rupee state credit route export, what is rupee state credit route? If whenever you are doing export but the consideration is received in INR, so that is rupee state credit route. And now on that export you want to pay commission and for that you want to draw foreign exchange, so that is not allowed. Why? Because there is no foreign exchange inflow, so government is anyway at loss. So this is for such type of export we will not allow to pay commission in foreign currency. But then there is an exception to this law. What they are saying, you want to pay for tea and tobacco up to 10% value, then it is allowed. Means if you are doing export which is in rupee state credit route, but that export is of tea and tobacco, then even if it is in rupee state credit route, that is even if the export consideration has been received in INR, still you can pay commission, in foreign currency, but that shall not be more than 10% of invoice value. So if your invoice value is, let's say 50,000, so it cannot be more than 5,000, commission cannot be more than 5,000, like that. Payment under callback services, that we have already discussed when we are doing study in this class. So can I say, when what is callback services? So you will call to some third country, you will give the number, they will connect the call, and then once the call get connected they will transfer the call to you. So obviously there are other modes, and for this government have a lot of negative capital outflow, and that's why government does not allow payment for foreign currency for callback services. Next is payment of interest on NRSR. What is NRSR? Non-resident special rupee account. So can I say, if some person is there in India who may be resident at that time, and when he planned to go permanently outside India, so the money which is lying in his India's account will be declared as non-resident special rupee account. So subsequently when he will come back, obviously after a period of time there will be interest on that account. So this is that any interest on such NRSR account is not allowed to be taken outside India. Then there are 2 points, that is travel to Nepal, Bhutan, and the transaction to Nepal, Bhutan is also prohibited. Now you will say, sir, but it is not written in schedule 1. Yeah, because it is prohibited by a rule, but at the end of the day it is prohibited only. So travel to Nepal, Bhutan and transaction to Nepal, Bhutan is not allowed. Why not allowed? Because INR is accepted over there. So these 10 transactions are what? Tell me fast. Prohibited. I hope it is clear. Now schedule 2, this is certain transactions require prior approval of central government. Which transactions are required for a prior approval of central government? So this is cultural tour. So if there is a rock band which is going outside India, for that they need foreign currency, so they need prior approval of central government. If you are doing in advertisement in foreign print media, now that advertisement, let's say in New York Times you are doing it, then this is for tourism, international bidding and foreign investment. You don't need any approval. But apart from these 3 things, anything else you want to do for advertisement in foreign print media and the amount is more than 10,000 USD, then you need prior approval of central government. Then this is you want to pay freight of vessel, vessel you have hired, and for that you want to pay freight, that is a big ship, you want to pay freight for that. So this is that for that you need prior approval of central government. Why? Because at the end of the day these amounts are very big, so any variation can lead to a huge capital outflow. Then this is that you want to make payment for import through ocean transport by CIF basis, then you need prior approval of central government. What is CIF? Cost, insurance and freight. So in that case more foreign currency will go. So government says that for that you need CG approval. If it is FOB, FAS basis, that is free on board, free alongside, Their only cost you pay in foreign currency. Rest of the amount you don't pay, because they, at the end of the day, it is your responsibility to bring it in India. So this is if it is FOB basis or any basis other than CIF, for that less foreign currency will go, and that's why for that no approval is required. But for CIF basis, whose approval is required? Central government approval is required if you want to import on that basis. Then this is if you want to pay container detention charges and the rate is up to rate decided by Director General of Shipping, then for that you don't need any approval. But if the rate is more than the rate given, decided, prescribed by the Director General of Shipping, then for that container detention charges you have to take CG approval. Multimodal transport operator. Who is multimodal transport operator? A transport operator which operates in which owns more than one mode of transport. That's called multimodal transport operator. If they want to pay to their agent abroad, obviously their amount is very high. So just to keep check, this is CG's approval is required. Then you want to pay prize money or sponsorship, and if you are an international national state sports level body, then you can pay prize money sponsorship, no problem. But if you are a person other than international national and state sports level body and you want to pay more than $1 lakh, then you need CG approval. So if you are an international national state sports level body, you want to pay any amount, no approval is required. You are other than these three bodies, up to $1 lakh, no approval is required. More than $1 lakh, CG approval is required. If the remittance for the payment of transponders are done by TV channel or internet service provider. What is transponder? Satellite services. So you want to pay for satellite services. Who want to pay this? TV channels or internet service provider, and that payment they want to do it in foreign currency. So for example dollar. So they need CG approval. Then you want to pay membership for PNI club. This is nothing but a marine insurance company, but this marine insurance company give insurance only to their members who are into a marine business. So you want to become member for that marine insurance company and you want to pay membership fees. For that you need CG approval. So for these 9 transactions CG approval is required. But then this is if these transactions are made from RFC account, then no approval is required. So if these 9 transactions are made out of RFC account, no approval required. But if there is no RFC account at all, or if it is exhausted, then you need CG approval. Then schedule 3 is for RBI approval. Whatever transactions we are going to discuss, that requires RBI, Reserve Bank of India's approval. Now let us study this one by one. See, these 7 transactions which I am going to discuss for individual. If you are making it out of LRS account, liberalized remittance scheme account, then for these 7 transactions you don't need any approval. But let's assume you have exhausted your LRS, then in that case for these 7 transactions you need RBI approval for withdrawal of foreign currency. Now what is liberalized remittance scheme? So under liberalized remittance scheme, this is if you are a resident individual, then you can draw up to 2,50,000 per annum dollar for things which is otherwise required RBI approval without RBI approval. So in simple language, these 7 transactions otherwise require RBI approval, but if you are doing it out of LRS, that is up to 2,50,000 per annum, up to $2,50,000 per annum, then you don't need approval. Beyond that you need RBI approval. What you want to do? You want to give gift to someone outside India. You want to go for a private visit, means traveling purpose, but except Nepal, Bhutan. Why? Because their withdrawal of foreign currency is not allowed. Why? Because INR is accepted. Then you want to give donation. For example, Bill and Melinda Gates, through that foundation I want to give donation. You want to go to outside India for employment and you want to take foreign currency there. So for that purpose you need RBI approval. You want to go for emigration. What is emigration? Permanent stay outside India. You want to go for education or you want to go for a medical. So for these 3 they say that if there is a estimation outside India, no approval is required. Sir, what if there is a estimation and it is within estimation? Do I need RBI approval? No. For this point number 5, if it is up to estimation, no approval required. And that estimation will be given by that foreign country only. Let's say estimation, it is more than estimation, but it is within LRS, still no approval is required. If it is more than estimation, if it is more than LRS, now RBI approval required for point number 5. Then this is family maintenance expenses. You have been deported to India, deported as in on a deputation basis. Some foreign company is there, let's say Google is there, who sent you for some project in India. And if you are in India as a RNOR, RNOR means what? You are up to 3 years in India, resident but non-ordinarily resident, fine, up to 3 years in India, and your family is outside India only, and to support your family you want to send your net salary, that is allowed. But beyond net salary you need RBI approval. Why? Because up to net salary you must be receiving that amount in India only, and if you send that money outside India there is no negative outflow, and that's why this is that up to net salary, that is post taxes etc. If you are sending outside India, no problem, but more than that you need RBI approval, and this benefit is available to across anyone who is whether Indian citizen or foreign citizen, except Pakistan national. We usually don't give them any benefit. So this is the point. Then next is business conference. You are going outside India for business conference, or can I say, I told you someone can go for medical also outside India. So along with that person who is a patient, you are sending some attendant. So that attendant means a person who will take care of that patient. So even that attendance expenses are allowed. And see, patient went outside India for medical, but for some time he has to stay there also. Those are patient maintenance expenses, not in hospital, but before he will admit in the hospital, he has to make some expenses. So that is called as patient maintenance expenses. Even these expenses can be done, no problem. So these 7 transactions are allowed within limit, if it is paid up to LRS, but beyond LRS you need RBI's prior approval. I hope it is clear. Next is Schedule 3, person other than individual. Now please understand, for example company, body corporate etc. So these are person other than individual. If for these people there is no LRS, so that 2,50,000 USD, that is not allowed to these people. So there is an individual limit that we have to see. So this is that consultancy charges you want to pay, and consultancy you have taken for some infrastructure project. So let's say you are developing some dam, some bridge, and for that you have taken consultancy, some design work etc. And for that you want to pay consultancy. Up to 1 crore USD no approval is required. More than 1 crore USD you need RBI prior approval. If you have taken consultancy not for infrastructure, let's say you have developed your own Antilia, big house like Mukesh Ambani, you are taking consultancy for the design from someone outside India, you want to pay in foreign currency, other than infrastructure it is, no? So up to 10 lakh USD no approval is required. More than 10 lakh USD you need prior approval of RBI. I hope it is clear. Then this is you want to give corporate donation to create share for educational purpose related to donor business and not an investment fund. What does it mean? Can I say you are Reliance, let's say you want some seats in let's say Oxford University. So you want to create share, that is you want seat, and that institute is Oxford, that is educational institute. Stanford, educational, related to donor business. Let's say Reliance is in gas, that educational institute provide education related to gas only, not an investment fund, that they will not going to refund you. So usually this is done so that I can get some seats and I can send my student there who can learn and join my company. So these, if these conditions are satisfied, then corporate donation is allowed. Up to 1 USD, 1% of foreign exchange earned, and that 1% will be taken off last 3 years average. For example, I want to do it for financial year 22-23, so it will be 21-22. I want to do it for 22-23, so it will be done for last 3 years, 21-22, 20-21 and 19-20, and that 3 years average I will take. Let's say it is coming out to be $1 crore. So in 22-23, na, that is $1 crore, 1%, that is 1 lakh or 50 lakh dollar, whichever is lower, that is lower is 1 lakh. That will be allowed without RBI approval. More than that, if you want to do corporate donation, RBI approval. Let's say if last 3 years average is coming out to be $100 crore, so 1% will be 1 crore 50 lakhs, lower is 50 lakhs. So up to 50 lakhs no approval required, more than that RBI approval. Let's say last 3 years coming out to be 40 crore, so 1% will be 40 lakhs. So whichever is lower will be 50 or 40, so up to 40 no approval, beyond that RBI approval, like that. Then next is commission on sale of plot in India. If there is a plot in India and that plot you want to sell, so for that, let's say you have hired some agent which is outside India, so obviously you must be selling it to someone who is outside India, and you are sent, so you will get foreign currency also in India See, please understand, the plot is in India, but you want to pay commission outside India. Now why? Because that plot which is in India, let's say in Mumbai, so that plot is in Mumbai, but that person who has sold you this plot is in USA. Now the guy who have sold you this plot is in USA, so you will pay that person commission. How much you can pay? 5% of foreign exchange brought in India. So let's say you have sold this house for, let's say, $1 lakh. So 5% will be $5,000 or $25,000, whichever is higher. Here it is not lower, here it is whichever is higher. So I will be $25,000. Up to this amount no approval is required. Beyond that RBI approval will be required. Or you can just turn it like $10 lakh you have brought in India. So 5% will be $50,000, $25,000. What is that? $50,000. So up to that amount, no approval required. Beyond that, RBI approval. Let's say you have sent $2 lakh outside India. So 5% will be how much? $10,000. 25. What is higher? 25. So you will say up to 25, no approval is required. Beyond that, RBI approval. So it is like that. Next point they are talking is pre-incorporation expenses. Again, say you have brought investment in India. Please understand, you have brought investment in India, and for that you want to send money outside India. Fine. So this is called, you have brought investment in India, and when you raise fund to any place outside India, to raise that fund, obviously you have to do certain expenses. So those are pre-incorporation expenses. Now up to 5% of inward remittance brought in India or $1 lakh, whichever is higher, up to that amount you don't need any approval. But more than that amount you need RBI's prior approval. So it will be read like this. Let's say I have brought pre-incorporation expenses in India, let's say $3 lakh. So 5% of $3 lakh will be 15,000 or $1 lakh higher. What is higher? $1 lakh. So up to that amount no approval required. More than that you want to do pre-incorporation, RBI approval required. So this is all for current account. For current account, please understand, anything which is not there in schedule 1, schedule 2, schedule 3 will be freely allowed. Now we'll be moving on to the capital account transaction. What is capital account transaction? Please understand, for schedule 1, these are those transactions which are permissible with RBI approval. These are permissible with RBI approval, but for resident. So it is meant for resident. That means these transactions must be done outside India. As I told you, for a capital account transaction, for resident transaction which is done outside India will be capital account. For non-resident transaction which is done in India will be capital. So first understand, if you are a resident and you are doing a transaction outside India, then it will be capital. So what are the transactions? So there are first 4 things: foreign, 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 foreign. So if you remember, foreign security, foreign derivative, foreign currency loan, foreign currency account, whether in India or outside India, will be what? Will be capital account transaction. Now someone will say, sir, but you said he is a resident, so there must be things done outside India, then only it will come here. But please understand, these are into foreign. Now foreign security, you are acquiring foreign security or foreign derivative. And now don't you think even if you will buy it in India, there will be a foreign currency implication only? That's why these 4 transactions, whether in India or outside India, you need prior approval of RBI. Then, so what they are saying, you want to transfer or acquire foreign security or foreign derivative, or you want to take foreign currency loan. You want to take foreign currency loan, or you want to open foreign currency account. Even for these transactions, you need what? Prior approval of RBI. I hope it is crystal clear to everybody. So you want to take foreign currency loan, or you want to open foreign currency account, for example EFC account, whether in India or outside India, or you want to take loan in dollars. These 4 transactions require prior approval of RBI, but it is permissible. Then this is, you want to acquire outside India what? Capital asset. Now for example, jewelry you want to acquire outside India, or immovable property you want to acquire outside India, land or building. You want to acquire commodity derivative. Or so these 3 transactions, if you want to do it outside India, you need whose approval? RBI, but it is permissible. And these 2 transactions, loan, you want to give or take to whom? You are resident, so you want to give or take loan to non-resident, or if some non-resident has taken a loan, you want to give guarantee to that loan. So for these 2 transactions, you need RBI's prior approval, but it is permitted. Then this is, you want to import, export or hold currency, or you want to take insurance from an insurance company outside India, again allowed with RBI approval. And now for non-resident, this is obviously, if the person is non-resident, these transactions will be done in India only. So that non-resident want to acquire some capital, such jewelry, etc. in India, or some land and building in India, or want to invest in India, for example, FDI, etc. So these transactions, as well as you want to open foreign currency account, but that account is in India. So for these 4 transactions, you need prior approval of RBI. You want to give deposits, you want to take deposits, or if some resident has taken loan and you want to give guarantee in that favor. So even for that, you need prior approval of RBI, and you want to hold import export currency. For that, you need prior approval of RBI. So I hope it is crystal clear, everybody. Now let's move to the next part. See, please understand, there are 2 transactions which are freely allowed. Which 2 transactions are freely allowed? Number 1, amortization, means government can never put restrictions for these 2 transactions. No approval will be required. So amortization of loan, that is repayment of loan, because there is no negative capital outflow. You are repaying what you have taken, freely allowed. Or depreciation in direct investment abroad. So this is if you have purchased, acquired wholly owned subsidiary, and that wholly owned subsidiary is 100% shares are with you. Now let's say there is a fall in the value of those shares, value of that wholly owned subsidiary, and now that foreign government may close that company because of non-maintenance of certain limit of net worth, and for that you want to repay, for that you want to send some money. So that is allowed. Now that is a very, these things I explain in class in detail, but now it's just a revision lecture, so I'm not going to get into detail, I just given you the glimpses. So for these 2 transactions, it is freely allowed. Now this is that Schedule 3 transaction. For non-resident, it is prohibited. What? If the non-resident want to invest into a Nidhi company or a chit fund company. Why? Because here tracking the investment is very difficult, because these are very loosely regulated. So this is for a Nidhi company and chit fund company. You want to invest, for non-resident it is not permitted. You want to invest into agriculture and plantation activity, not allowed for non-resident. Why? Because these are normally done by the farmer who are very poor. So to control, to safeguard their interest, this is that in agriculture plantation activity it is not permitted. You want to invest into real estate. You want to invest into where? Real estate, not allowed. So you want to invest into real estate, but it is very important, because lot of black money is there in real estate sector. So to protect it, government says that non-resident cannot invest in real estate. But now government understands that, see, in real life only the outsiders invest in real estate on a large scale, and to develop the country, now what they said, that real estate does not include these things, means development of township, commercial, residential premise, road and bridge. It means, can I say, if it is not included in real estate, means can I say a non-resident can invest here? So if you are a non-resident, this is, you cannot invest into real estate, but development of township, commercial, residential premise, roads and bridges will not be treated as real estate, means you can invest here. So non-resident can do these investment in these activities. Then trading in transferable development right. Now what happens, let's say you have some property, government has acquired it forcefully. Now government will not give you money. Now government will give you development right. They will say you can develop 100-meter building. For normally, for developing 100-meter building, you have to take this thing. You have to take the development rights, and for that you have to pay to the government. But government will give you free of cost that thing. Now you will say, sir, but we are not builder. What we will do of that development right? So government gives this as a transferable nature. Means you can sell those development rights. So you can go to some builder and you can sell these rights. So these are TDR. So non-resident cannot develop in TDR. Why? Because otherwise a non-resident will acquire the development right. They will develop the 100-meter building, and let's say that non-resident is Pakistani. So he will put bomb in that 100-meter building and he will run away. So to protect these things, this is a non-resident cannot trade in TDR, transferable development right. Now, so for Schedule 3, this is for non-resident cannot invest into Nidhi company, chit fund company, real estate, or but real estate does not include development of township, roads and bridges, development of residential commercial premises. Then this says that agriculture plantation activity non-resident cannot invest, and trading in TDR, transferable development right. Now we are moving on to the next concept, section 7, export. Now what they are saying, there are 2 types of export. Non-commercial export means, for example, I am sending something to my relatives, friends outside India. For example, I am sending pickles. So these are non-commercial. I am not doing it to earn, not my business. So this is allowed. For that you have to just give the declaration within 21 days of nature of the goods and value of the goods, like what is the value of that goods, because otherwise you will send diamond, that government will not allow you that. So that thing, and whether the goods is risky or not, so that two things you have to specify. But you don't need IEC, import export code, you don't want. But if you are doing a commercial, export, then you need import export code for doing what? Commercial export. Now they are saying that if you are doing a commercial export, you need import export code. Now in that they are saying, first of all, if you are doing a trade agreement, what you are doing? Trade agreement, or if it is under EXIM policies, export import policies, then you need prior approval. But for other type of export, you don't need prior approval of RBI. And whether it is trade agreement, EXIM policy, or other type of sale, you anyways have to follow these things. Declaration within 21 days. What declaration you have to give within 21 days? That too in prescribed form, in the given form, that you have to file with authorized person. You will say value of goods, nature of goods, and price is a sole consideration. Government does not allow barter system. Means you are sending goods and you are getting non-monetary things. You are sending apple, you are getting mango. So that is not allowed. So this is price shall be the sole consideration. In order to do barter system, you have to take prior approval of RBI. And along with that, you will send invoice, you will file invoice also. So that government will come to know how much export consideration you are going to get. Then this is that prior approval of RBI will be required when you are doing in any manner other than the specified manner. As I told you, if you are doing barter system, that is not specified, you need prior approval of RBI. And this time limit you have to bring. Normally you have to bring the foreign currency within 9 months from the export date. And if it is warehousing abroad and sale, then you have to bring it within 15 months. So if you are getting it after these time limit, again you need prior approval of RBI. Or if the transaction is under value, let's say the value was supposed to be $1 lakh, but you are doing it at $50,000, $60,000. So if the transaction is under value, you need prior approval of RBI. You want to write off debtors. The debt value was $1,000, $2,000, $3,000, and he is not repaying you. You want to write off it. You need RBI approval. In all the transactions, you have to indicate your IEC code. Obviously, all commercial transactions, all the copies of invoice or whatever form you file, you have to specify your import export code. Then this is within this time limit, you have to bring the foreign currency. Now, what if you don't bring that foreign currency within this time? Then RBI first will tell you to secure payment. Means they will tell you that put more effort and bring that money to India. If that is not happening, then they will say, okay, do one thing, take goods from the person who is not giving you foreign currency and give it to some other person. So sale of goods or software to some other person and re-import the goods, or they may tell you that, okay, do one thing, bring that goods back to India. So it is like that. If you have received advance money for export, this is the maximum you have to do the shipment of goods within 1 year. What if you don't able to do the shipment within 1 year? After 1 year, you are doing shipment, fine, but you don't want to do shipment also. You want to give the money back, means you want to return that advance money. So this is if after the expiry of 1 year, you want to return your advance money. For that, you need prior approval of RBI. So advance money you have taken, please do the shipment within 1 year. Not able to do it within 1 year, after 1 year, also okay. But if you want to return that advance money after 1 year, because you may not be in situation to deliver the goods, then you need prior approval of RBI. Now, some transaction does not require any type of declaration or something under export, because export meaning is bringing outside India. So anything you will bring outside India will be called as export. But not all export is, require declaration. So which export does not require declaration, they have given here. Like you have given as a form of advertisement, free samples you are giving, or its personal effect, means you are going outside India, you are carrying laptop, clothes you are wearing. So these are, or jewelry you are wearing. So these are your personal effects. You don't need declaration for this. Transshipment cargo, like there is some goods came to India, now that will be taken to some other country. For example, one cargo came from Australia to India, and now it will be shipped here, and after 2-3 days it will again go to Pakistan. It was meant to be to Pakistan only. So this is called transshipment cargo. No declaration is required. Ship stores. See, when military other people go in ship, there is a lot of stores to repair the ship, etc. So those are ship stores that does not require any declaration. if you are giving gift in kind, see in schedule 3 we have studied monetary gift, this is gift in kind. I am giving teddy bear to my girlfriend, and if the value is up to 5 lakhs, that gift in kind's value, that teddy bear's value is up to 5 lakhs rupees. Here it is not dollar, rupees. So for that you don't have to give any declaration. If the value is more than rupees 5 lakhs, then declaration is required. Aircraft for overhauling means up to 6 months. So can I say you have sent aircraft outside India because of some repair, etc., and now it will come back. So if you have sent it for maximum 6 months, so that's called aircraft for overhauling. Up to 6 months it is allowed, no problem, no declaration required. Or you have purchased some goods for re-export, means some bike testing came to India. You have imported some goods for re-export, means some bike came to India for testing, now you are re-exporting it. So that is allowed. These are a general thing. In real life it does not tantamount to be export, but the definition is designed in such a way in FEMA that it is called as export. But practically speaking, these are just services. So these are not treated as export in real life. Goods sent for testing for re-import. You have purchased something, for example iPhone, there is some problem, and let's say you have purchased directly from USA. Now, so can I say you have sent it and then you will again re-import it. So you have exported and then you will re-import. After repair they will send it back to India. So does not require RBI approval, not require declaration, any form of declaration. See, special economic zone is treated as a place outside India. So let's say if you are into a special economic zone and you will send anything for repair also out of SEZ, can I say it will amount to export only, but this is allowed, no approval will be required. Replacement of goods means you have given some goods outside India, they are calling it as export, but can I say that you have sent because there is some defect and they will send back you the other goods as a replacement. For example, Tesla car, there is a problem, I sent it outside India, now they will give me the another Tesla car, so it is a replacement, no declaration required. Same goods brought in India for testing and re-export and export as permitted by RBI. So these are the things. Next is repatriation. What is repatriation? Repatriation means what? Government says that whenever you have earned foreign currency, government want you to bring those foreign currency as early as possible. So that's called repatriation basis. What we call it? Repatriation basis. So in that they are saying for repatriation means what is the whole idea behind repatriation? That whenever you earn foreign currency, please as soon as possible bring that foreign currency in India. Now that there can be 3 forms in that. Number 1, cash, means you have generated foreign currency and you have converted it and you want to bring that in India, this is cash. Deposit means you have earned foreign currency, you sold it in India and you are getting INR, that is cash. Deposit, you are depositing that foreign currency in RFC, EFC account, etc. Or by way of set off. Set off is not important, means you are supposed to take money from some person and you give it to some person. Now you are telling those 2 persons to settle among themselves. This is also one form of repatriation. So there are 3 forms of repatriation. Authorized person, as I told you, you cannot directly deal in foreign currency. You have to deal it with through authorized person only. Now the question is, who will be regarded as authorized person? So this is any person who want to work as authorized person shall obtain license from RBI. Now for obtaining license from RBI, they have to give application to RBI in writing. Now there are 3 types of authorized person. First is authorized dealer. This person deals in foreign security. For example, Motilal Oswal, Sher Khan, these are authorized dealer. They buy foreign security, they sell foreign securities. Money changer. There are 2 types of money changer, FFMC, RMC. Full-fledged money changer, restricted money changer. A restricted money changer can only buy foreign currency. Full-fledged money changer can buy as well as sell foreign currency. And offshore banking unit. What is the job of offshore banking unit? They give finance to special economic zone. So they are the banks, they are the branches of the bank which is separately, or they are the branches, you can say, of the bank which is separately established in special economic zone only. So these people are authorized person. This is when you want to take a license from the authorized person, what RBI will check before giving you the approval. So RBI shall give approval only following conditions are satisfied. RBI will first check whether it is in public interest or not, giving you the license. Then is it in interest of foreign exchange reserve, means after taking RBI's approval whether foreign exchange will increase or will fall. Then whether that person to whom you are planning to give license will comply all rules, regulations and directions of RBI or not. And after that they will give you condition. But when RBI will give you condition, they will put some terms and conditions. They will tell you where you can operate, that is the area of operation. Then they will tell you how much you can deal, how much foreign currency you can buy, how much you can sell, like that, which records you have to maintain, and which type of laws, rules, regulations, guidelines you have to follow. What if RBI want to revoke these license? They can do it. If you are not acting in public interest, means you are doing some fraud or negligence, something like that, or if you are not following the act, rules, regulations, guidelines and of the RBI. Then obviously what is the most important job of authorized person? They have to ensure that the foreign exchange whichever the person has earned, they are bringing it within the time limit given in the act. Next point we are going to discuss is penalties. Under that, first is section 11. This is if authorized person fails, it's not fails to comply what? Act, rules, regulations, provisions, guidelines of RBI. So they have to do a lot of activity. So for them, doing errors are very much normal, and that's why they say that for them the penalty will not be very huge. It is up to 10,000, that is 10,000 will be one time and 2,000 per day. So it will be 10,000 plus 2,000 plus 2,000 every day on a daily basis. 2,000 will be keep on adding. So it is 10,000 plus 2,000 on a daily basis. Fine. Next point what they are saying, section 30. If any person other than authorized person is doing this mistake, what I am telling you, what I am telling you, if you are not the authorized person, so if you are anyone else other than whom, other than authorized person, and if you are contravening the act or rules or regulations or provisions or guidelines of the RBI, then for you what will be the punishment? So this is for you if amount is quantifiable. So for example, there is a company or an individual who have used more than LRS without RBI approval. So for them, what will be the punishment? So for them the frequency of transaction is less. So if they are doing mistake, it's a big thing, because you are doing anyway less transactions, still you are doing wrong. So still you are doing mistakes. So for them the punishment will be more. So if the amount is quantifiable, then 3 times of amount involved. For example, if certain limit is given, let's say $250,000 LRS, but you have used $255,000. So 5,000 is the quantifiable amount. So into 3, 15,000 will be the penalty. If amount is not quantifiable, for example, you are the company who have not filed the return, so amount is not quantifiable. So it is rupees 2 lakh plus 5,000 per day. So 2 lakh will be one time plus 5,000 on a daily basis till the period you don't rectify the default. Then this is what if the penalty is levied and you have not paid within 90 days. So in that case there will be civil imprisonment. So there will be not rigorous imprisonment, there will be what? There will be civil imprisonment. Now in this there are 2 possibilities. Possibility number 1, can I say if the amount is more than 1 crore, then the punishment can be up to 3 years. And in other situation, that is if the amount is up to 1 crore, then in that case the punishment can be up to 6 months. So it is like this. So if it is more than 1 crore, up to 3 years, and up to 1 crore, up to 6 months only the punishment will be. Then the next they are talking is adjudication. Now what they are saying for adjudication, adjudication means giving judgment. So this is that in this there are 2 possibilities. Possibility number 1, if enforcement directorate is there, ED is there, ED is into a dual role. They will do investigation also, judgment also, and adjudicating authority will do judgment only. How they do it? First judgment will be given by ADDD, assistant director, deputy director, against whom you can file the appeal to DG, director general. They are also called as this thing. So director general you can file appeal, and within how many days you can file appeal to director general? So you can file appeal to director general within 45 days. Director general will give judgment suo motu. From director general you can appeal within 45 days, and if assume there is a delay, then in that case any extra time, after writing reasons in writing, after recording reasons in writing, you can file appeal to appellate authority, appellate tribunal, and they need to dispose within 180 days. All other authority can take time as they feel to, for example DG or High Court, or but appellate tribunal need to dispose it within 180 days only. And if you are not happy with the decision of appellate authority, you can file appeal within 60 days to High Court, and if you could not file it within 60 days, then extension of another 60 days can be given to High Court. And High Court will give judgment suo motu, like whatever time they need to. Appeal against the order of High Court can be filed to Supreme Court within 60 days. An extension of another 60 days can be filed if on a genuine reason. Supreme Court will give judgment suo motu, means whatever time they need to, they will take and they will give the judgment. Then this is adjudicating authority shall follow the right of natural justice, means they shall give opportunity of being heard. Next we are doing the discussion is compounding. Now what is the meaning of compounding? Compounding, please understand, compounding means if there is only a fine, then reducing the fine is a compounding thing, or if there is a punishment where there is a fine or imprisonment. So levying fine against imprisonment is also called as compounding. So reducing imprisonment for fine, or reducing fine when no imprisonment. But please understand, when it can never be compounded, when it cannot be compounded, when offence is repeated within 3 years. So you are a regular offender. So let's say if the compounding has done in immediately last 3 years, then in that case you cannot do compounding. So for same offences, compounding is possible only after the period of 3 years. Or if the amount is not quantifiable, then obviously how the fine will be determined. Or if it is already under appeal, then don't you think if you will try to compound, you will be trying to subjudice the power of the higher authority. So they say that in these 3 situations, compounding is not allowed. Now, who can apply for compounding? Obviously, anyone who has committed contravention can apply for compounding, and it has to be completed within 180 days. All these things will come later on also. Time limit for compounding fees from 15 days of the receiving order, and you have to pay compounding fees within 15 days. But what if you fail to make that payment, then it will be deemed as if there is no compounding initiated only, means entire adjudication process will start again. So it is like that. A compounding related only, there is a point which will just now finish. See, this is only point related to compounding. If anyone voluntarily admit contravention and seek redressal, but obviously no compounding can be done when there is a fraud involved. It is only for negligence. And who will do the compounding? Department of Enforcement. How it is done? Applicant will make an application to DOE, and then within 180 days enforcement director will pass an order. After that the order is passed, within 15 days you have to make the payment. Once you made the payment, can I say you will be released from the coercive action. Coercive action means what? Can I say once compounding is done, you have made the compounding fees, means now you will not be done, nothing will be done against you in a coercive manner, means you will be free from the charge. Now if no payment is made within 15 days, then no benefit of compounding will be given, means it will be deemed as if you have never opted for compounding, and whatever action need to be taken against you will be taken. It is like that. Now, capital account transactions point we have already discussed. Capital instrument RBI determined. Then this is RBI has a power to give direction to authorized person. And why RBI will give directions to authorized person? So they will give to secure the compliances of Act, rules, regulations, notifications. So whatever the provisions of Act is given, rules have been given, regulations have been given, notifications have been given, to ensure that these things need to be complied with, RBI will give direction. They may also give appropriate direction wherever it is needed for. Then this is section 12, power of RBI to inspect authorized person. Can the RBI have a power to inspect the authorized person? This is yes, they can. But for this, what they will do? They will appoint some officer of RBI, and that RBI will verify the statement and authenticity. Means obviously whenever there will be inspection or investigation, lot of statement will be made. So he will verify the authenticity, he will obtain the information, he will make sure that laws have been complied to, and every person against whom any investigation is going on, that person's duty is to cooperate the authorized person, to produce books of accounts, to furnish information like this. I hope it is clear. Now next point, enforcement of the order of adjudicating authority. Please understand what they are saying. Section 14, enforcement of the order of adjudicating authority. Now first, this is within 90 days. If there is only a possibility to abscond, only then only once order has been passed, now you have to pay penalty within 90 days. So whether you can be detained within that 90 days period. So this is that, see, within this 90 days period, you will detain only if there is a possibility that the person will abscond, will run away. Otherwise, you will not detain. So within 90 days, technically there will be no detention. But after 90 days, if you have not paid the penalty, then there will be detention. But how it will be? The procedure I am telling you. First, notice will be sent to the person to pay the arrear, and this notice will be sent by the adjudicating authority. And after that notice also, if that person is not coming and not paying the arrear, no appearance made, then against him arrest warrant will be issued. Are you understanding? Then against him what will be issued? Arrest warrant will be issued. Now the person against whom arrest warrant is issued, that arrested person need to be presented before adjudicating authority within 24 hours. What if that person, if it is that person is HUF, then in that case Karta will be arrested. And if assume he has been taken into custody, but within that, before he has been presented before adjudicating authority, in between only if he makes some payment, whatever the payment is required to be made by him, if that payment is made, then in that case he can be released. But assume he has been presented before adjudicating authority. So before detention order also, adjudicating authority will give him opportunity of being heard. Now after that, they are saying that if, let's say, in between, if the inquiry is going on and after some days that person is saying please release me, and for that he is ready to give security deposit, then also it can be released. And assume that once the order has been passed, on conclusion it is proved that that person is not guilty, and if he is already under custody he will be released. Assume on conclusion he has declared as guilty. If he is already under custody, fair enough. But assume he is not under custody, then there will be order will be passed against him, and in that order they will say that please arrest that person. So it is like that. But if he is under arrest and, can I say, in between he is like, I want to make the payment, please release me, then for 15 days he can be released, so that he can pay the penalty amount, he can be released for 15 days. So it is the entire procedure. Shall we proceed? Fine. Now there are some small provisions are there. Please understand. Appointment of adjudicating authority. CG will appoint adjudicating authority for adjudication under section 13. Adjudicating authority is of the opinion that person may abscond, then may require to provide bond or guarantee. What they are saying, adjudicating authority is of the opinion that person may abscond. So if his opinion that person may run away, so what they will say, okay, do one thing, you provide bond to us, you provide guarantee to us. So they can say this point. Now what they are saying, this is Department of Enforcement. Now this act required lot of people, means lot of officers are required to carry out the activity of this act. So this is that central government will establish Department of Enforcement, in which there will be director as well as other officers. If central government want, they can authorize Department of Enforcement, additional directorate, special directorate, deputy directorate, that they can appoint other officers also. But they can appoint officers below the level of assistant director. So any officer below the assistant director can be appointed by these people if it is authorized by the central government. Then any search and seizure you want to do, then the level of the officer who will do search and seizure shall not be less than assistant director. So it will be assistant director or above level people only will do the search and seizure. Below level is not allowed. Then central government, this is that is Ministry of Finance, will authorize, if sufficient officers are not there to carry out the FEMA activity, then they may authorize custom officer, excise officer, police officer, central government, state government officer, and they will get the income tax officer's power. So it is like this. As far as ODI is concerned, please read it from the my lectures for May 23 amendment lecture. In that I have explained the whole ODI. As it is an amendment, I want you to study everything and not quickly. These are just a reference, quick reference now. So it is like that. Now we'll be doing it ECB, external commercial borrowing. External means outside India, the lender is outside India. Commercial means Can I say it is for a business purpose? Borrowing means the borrower is in India. Now there are two possibilities. A, you can do borrowing. The mode can be by way of equity or debt. So equity is FDI. That is not we are going to cover here. Debt funding is ECB, which we will going to discuss. So this is that, see, if there is a foreign lender, they want to, if you are an Indian borrower and you want to take ECB from the foreign lender, then it will come under the concept of ECB. So this is that the lender has to be the recognized lender. So first, then and then what is ECB, we'll learn that. Then who all are the recognized lender, we'll learn that. And then we'll learn who all are the eligible borrower. So there will be a three different patches, we'll learn it. Now there are two types of ECB possible. FCY denominated ECB, here the repayment is in foreign currency, and then rupee denominated ECB, here the repayment will be in INR. And as far as this is concerned, rupee denominated ECB, there will be no fluctuation risk in this. There will be no fluctuation risk in this. As far as FCY denominated ECB is there, you have to repay in foreign currency. So obviously there will be fluctuation risk in this, and that can be protected through hedging. Hedging is a natural hedge and artificial hedge. What is natural hedge? Again, the natural hedge is not a hedge. Here, can I say, you know that you will going to get the export consideration in foreign currency, and from there you will be paying the ECB. That is natural hedge. Artificial hedge means the futures options, which we have studied in SFM subject. Now let us understand who are the eligible foreign lender. Means, can I say, Indian borrower can borrow only from these four people. So eligible foreign lender is multilateral development bank, for example World Bank, IMF, International Monetary Fund, etc. Then regional financial institute, for example European Investment Bank operates in Europe, Asian development in Asian countries, like that. Then foreign equity holder and foreign branch of Indian bank. For example, there is a foreign branch of SBI, State Bank of India. So even they will be regarded as eligible foreign lender. Now who can borrow? So who is the eligible borrower? This is first the entity which are eligible to take FDI, foreign direct investment, are also eligible to take ECB. Then PUSE, Port Trust, Piyush, Port Trust units in Special Economic Zone, SIDBI and Exim Bank. These four people are the eligible borrower, they can borrow. Then now let us understand what they are saying. Please come here. What will be the minimum maturity period of the borrowing? So it depends from whom you are borrowing. So if you are borrowing from the foreign equity holder and you are borrowing for working capital and general corporate purpose, means administrative expenses, then the minimum average maturity period, for repayment should be at least 5 years. If the lender is someone else other than foreign equity holder, like multilateral development bank, etc. is there, then in that case the MAM should be at least 10 years. If you are borrowing to repay your rupee loan, if that purpose, and if you want to repay the rupee loan of capital expenditure, then for that, if the lender is foreign equity holder, the MAM should be at least 5 years. If lender is someone else, for example Asian Development Bank, etc. is there, then the MAM should be at least 7 years. Then this is, you want to repay the rupee loan other than capital, for example revenue expenditure, then and the lender is foreign equity holder, then the MAM should be at least 5 years. If lender is someone else, fine, then the MAM should be at least 10 years. And apart from that, if you are taking it for any other purpose, and if the lender is foreign equity holder, the MAM should be at least 3 years, and from others also it shall be 3 years only. If it is a manufacturing activity and if it is up to 50 million US dollar, then the MAM should be at least 1 year. More than 50 million US dollar, then the MAM should be at least 3 years. So it is like that. All in cost and everything in amendment lecture only we have discussed in only, so I am not going to repeat it again. Then the negative list means, can I say, you cannot take ECB, external commercial borrowing, for these purposes. You want to invest in real estate, you want to invest in stock market, or you want to make the equity investment. So for these three purposes, ECB cannot be taken. You want to do it for working capital purpose, general corporate purpose, repayment of rupee loan, or on lending of NBFC. If for that, if you are, this is usually not allowed, but if you are maintaining the MAM, just now we have studied the MAM, minimum average, then it is allowed. To put it in simple language, it is allowed only, but provided you should take care of the MAM period. It shall not be less than the MAM period given by the regulations. So now let us understand. So what they are saying, if the foreign lender is there, he is taking ECB. If you are the Indian borrower and you are taking ECB from the foreign lender, then you have to follow entire provisions whatever we have just now studied. Now, can I say if the Indian borrower is there and if Indian borrower wants ECB from the foreign lender, they can take it, but then it is divided in two parts. Number one, there is a automatic route, fine. Number two, there is a approval route. Please understand, there is a automatic route, number one. Number two, there is a approval route. Under automatic route, they are saying that obviously you don't have to take any approval. So borrower has to just file form ECB to AD category 1 bank and they can just take the ECB money. But if it is approval route, the borrower has to file form ECB to AD category 1 bank. AD category 1 bank will forward it to RBI. There is a recommendation of empowered committee of RBI which see whether what is the impact on macroeconomics of that ECB, what is the benefits of those ECB, what are the guidelines are there for those ECB, and after that they will give the approval for ECB. So this is for approval route. Now automatic route, I told you no approval is required. So how much amount you can take under automatic route? Please understand. So this is if the ECB is up to USD 750 million, then it is allowed under ECB, no problem. But there is an extra condition for it for foreign equity holder. Means this condition is there for all type of eligible lender, all 4 type of eligible lender. But for foreign equity holder, along with point number 1, there is an extra condition, point number 2. They have to follow both the condition. If your lender is foreign equity holder, you have to maintain the debt equity ratio of 7:1. Means what? Your borrowing can be maximum up to 7 into equity. So that is debt equity ratio you have to maintain. 7 into equity means equity will be paid up share capital plus free reserve plus equity premium. But then this is you don't have to maintain this debt equity ratio if the borrowing is up to only USD 5 million. So now if your lender is anyone else other than foreign equity holder, you have to maintain up to 750 million per year allowed in automatic route. But if your lender is foreign equity holder, then you have to maintain 750 million limit also, as well as you have to maintain the debt equity ratio of 7:1. Means the borrowing can be maximum 7 times of your equity. Equity includes paid up share capital plus free reserve plus equity premium. But if it is less than or up to 5 million, you are borrowing from the foreign equity holder, then you don't have to maintain the ratio of 7:1. Fine. Now, then there are some other conditions also. This is you have to maintain the risk management policy need to be maintained by the BOD. You have to do the mandatory hedging of 70% of ECB if the average maturity period is less than 5 years. Obviously, if natural hedge is there, you don't have to do it, artificial hedging. But if natural hedge is not there, then you have to do artificial hedging, and that amount shall be at least 70% of the ECB amount. Then this is you have to make an application to AD category bank. AD category bank will verify it and they will report through form ECB2. And as I told you, you have to do hedging. Hedging period shall start from the date of ECB liability booked until the period you don't repay ECB. Your ECB shall be protected by way of hedge. And now this is all I am talking about FCY, foreign denominated ECB. INR denominated ECB, there is no fluctuation risk only, and for that you don't have to, the borrower don't have to hedge. Obviously the investor has to hedge, but the investor is the foreign lender, so we are not concerned about that. The tenure will be of at least 1 year with a rollover period. Means what? Normally, as I told you, you have to do the hedging. So hedging normally you will not get for a very long period at once. So this is, you can get the forward contract of 1 year and then you can keep on renewing it. So like that. Then this is natural hedge. We already know that, see, you are supposed to get the export consideration. If that amount is more than or equal to your ECB, then in that case it is already hedged. You don't have to take the artificial hedging. What if the money you have taken as ECB, you don't want to use it immediately, you need it for future, so you can park it, you can keep it in some deposits. If it is for foreign expenditure, then you will obviously park it outside India. Then you can park in any deposits outside India, but that shall be rated for at least AA- by S&P or AA3 by Moody. Or you can deposit that money in treasurer bill, or you can deposit in foreign branch of Indian bank. For example, there is some foreign branch of SBI, then you can deposit there also. As far as you want to park the ECB in India because you need it for Indian expenditure, so in that case you can put that money with AD category bank, or you can make the FD of maximum 12 months. Now they are saying reporting requirement. What is the reporting requirement? This LRN is loan registration number. So can I say you have to, whatever, whenever you need ACB, you need LRN. So for that, borrower will make an application to AD category bank. AD category bank will make the application to DSIM, and then they will give LRN, and after that bank will give LRN to borrower. So it will flow like this. Now next they are saying, what if there is any change in terms and conditions? So even that need to be reported in maximum 7 days, and anyway whether there is changes or not, you have to anyway do the monthly reporting in form ECB2, and that has to be filed within 7 days of after the end of every month. So beta, all these important things of FEMA I have done. See, this is a revision lecture only, so I am just giving you important glimpses. For a detailed understanding we have anyway done in the classroom. Okay, now we are starting with a new chapter, Arbitration and Conciliation Act. First of all, please understand that if let's say there is a dispute between two parties, so there can be a criminal dispute, civil dispute or commercial dispute. So criminal dispute is always resolved in court only. As far as civil and commercial disputes are there, can say you can resolve this dispute in court also and by some other way also. But what is the problem in court? See, there is a delay in decision because of multiple cases are pending. So because of that, obviously number of cases are pending. So the frequency of hearing is very less, and because of this there is a delay in decision. There will be zero confidentiality because all the dispute in court is available in public forum. Then there is a flexibility, there is a problem of flexibility I would say, because there is certain procedure given in Indian Penal Code CRPC, you have to follow that. Then it is subject to too many appeals. Because of that, obviously again there is a delay of time, and it is very costly because of the entire structure and delay, and obviously somewhere goodwill also get damaged because the matter is sub judice to court, so public notion is developed that way. So there are other ways of solving the dispute. Along with other ways, there is arbitration, which is alternative way to solve the dispute, conciliation and mediation, which we will be focusing in this chapter. Now, so these are not important general understanding. So from here we will start. What is arbitration? It is not a definition, it's just an understanding about arbitration. This is arbitration is the process by which dispute between two or more persons as mutual rights and liabilities referred to a determined judiciary. So here willingly two or more person is referring their dispute to some determined people, and the judgment of that person is binding also. So can I say if two or more person has certain dispute and they will mutually agree to refer those dispute to XYZ person, and that XYZ person will going to give judgment against that, and that person, the judgment will be binding to those people who have referred it. So it is like this. Now the person who is the judge in the arbitration, we will call it as judge only, is called arbitral tribunal, also called as arbitrator. Now the parties in the agreement, the parties under the arbitration need to have some sort of understanding that they want to go for a arbitration. So that is the point. Now please understand there are two types of arbitration, domestic arbitration and international arbitration. If all the parties of the arbitration are Indian, then it is a domestic arbitration. But at least if one party is outside India, then it will be called as international arbitration. What if no party is of India? Then it is not concerned to us, then it is not an arbitration only. So this is the point. Next we are going to discuss process of arbitration. And now in arbitration there are two party 1 and party 2. See what they will do, they will mutually decide who will be their arbitral tribunal, that is judge, arbitrator, and that arbitrator will do hearing of both the parties, and then he will give the judgment which is called as arbitral award, which will be binding on both the parties. Now a judicial authority definition, it is not defined in the act, but there was a case in which it is held that is SPP versus Patel Engineering. It is held that judicial authority will include court first, second they will also include special tribunal. For example, consumer forum is the special tribunal, or even a quasi judicial authority, for example NCLT. So can I say judicial authority is a much wider definition compared to court, because it will include court, along with that it will also include special tribunal and that. Now as far as court is concerned in this topic, if court is involved, then what will be which court need to be referred to? So this is that if you want to appoint the arbitrator, then in that case, for a international commercial arbitration, you have to refer it to Supreme Court. For, again I am repeating, for international commercial arbitration, you have to refer it to Supreme Court. As far as domestic arbitration is concerned, you have to refer it to High Court. As far as supervisory functions are concerned, what are the supervisory functions? Execution, challenging, etc. These are supervisory functions. So as far as supervisory functions are concerned, in this what they are saying, if it is an international commercial arbitration, then you have to refer it to High Court. And for domestic arbitration, you have to refer it to District Court or even a High Court where you have an original jurisdiction. So please understand. So if it is a supervisory function for international, you will go to High Court, or for domestic you will go to District Court or High Court of the original jurisdiction. You want to appoint arbitrator, then you will go to Supreme Court. Now you will say, sir, but why court is there? Arbitrator will be appointed by the parties mutually. See, they will be appointed by mutually, but if they mutually decide that it need to be done through court, then they will go to Supreme Court in case of international. For domestic, High Court, like that. And this features of arbitration. If first of all, here the party must agree that they want to go for arbitration instead of court. So it is like that. Then this is, there has to be some dispute, then only you will go to arbitrator. Then this is that the parties, what they will do, if they will together, they will appoint arbitral tribunal who will determine the judgment on their dispute. Then who will appoint the arbitrator or arbitral tribunal? So parties themselves will appoint it, and they will agree that any dispute of the arbitrator will be solved. So parties will they will agree that the judgment given by the arbitrator it will be binding, and it will be binding on the parties. So it is like that. Now please understand, when you go to arbitration, when parties go to arbitration, so whether it is necessary that there has to be the arbitration agreement. So this is yes, there must be some agreement, but that can be a two ways of agreement. If there can be a separate agreement, means let's say there is a partnership deed is there and you have prepared a separate agreement also for arbitration for the dispute among parties, or you can have an arbitration clause in the general agreement. For example, there is a partnership deed and you have an arbitration clause in the partnership deed only. So there can be that. And in arbitration agreement which you are doing, you can refer that multiple dispute is solved, or you can say all dispute, or you can say some dispute will be solved through arbitrator and some will deal in court only. So that is your choice which all dispute you want to refer through arbitration. Then arbitrator will not give for judgment for those dispute which is not brought to the arbitrator. So he will give judgment only for those dispute which is brought to the arbitrator. Now this is arbitration must be in writing. And for example, you have done the separate agreement, there is a separate partnership deed and then there is a separate arbitration agreement. So if there is a separate agreement, it has to be in writing, but there is no further condition. But if arbitration clause in general contract, for example, you are making arbitration clause in the partnership deed. So if there is a arbitration clause in the general contract, then this is, it has to be signed, or either it should be signed or one party is alleging and other party does not deny that there is no arbitration agreement. So basically you have to remember that. So signature is mandatory for arbitration clause, but it is not mandatory for separate agreement. Now, what need to be checked when there is an arbitration agreement? So this says that there must be agreement between the parties that they want to go for arbitration. So this should be the first point, and there shall be a clear consent, clear understanding that they want to resolve their dispute through arbitration. Second point, it has to be in writing. Arbitration agreement cannot be oral. And now the problem is, as I told you, it must be in writing. That means oral is not allowed, but the format is not given. Fine. The format is not there. So they can have any format, but that format has to be in some written form. Now, then this is that just mere using the word arbitrator or arbitration will not make any agreement as an arbitration agreement. So this is very important thing. So there has to be intention that you want to go in arbitration. Mere adding the word arbitrator or mere adding the word arbitration will not make any agreement as a arbitration agreement. Then this is only for a legal relationship you can go in arbitration. For example, I am doing some drugs, narcotics business, which is illegal. Now you cannot obviously form an arbitration agreement for that and you will go for dispute, because it is not enforceable only, it is illegal activity. So it is like that. Then this is, once you agree that you will go in arbitration, then the judgment given by the arbitrator is binding on you. You cannot say no, he is just a private person. It will be binding on you. Then this is it is binding and you have to follow that. Now it is your choice that whether you want to put all dispute to the arbitrator or some selected dispute only. So let's say there are dispute ABCD. So you want to put for ABC to arbitrator, then it is your choice. Then in that case D can be resolved or redressed through court. It is like that. Then this is party must sign, but obviously if there is a separate agreement, that signature is not necessary. Next point is arbitration agreement through reference. What happens in real life? And now let's say you are a new party, you don't have much knowledge and the other person is a very senior guy, he has a great knowledge. Now you have a fear that he may draft some provision which may be detrimental to you. So what you can do, you can adopt some existing agreement of some independent parties, and you will, if it is of similar nature. So it is called arbitration agreement through reference. Means, can I say, if I want to do business with Reliance to sale of air conditioner and I don't want to make a independent agreement, so what I will do, there must be sale of air conditioner agreement already exists in the market of Mr. X with, let's say, some other company, let's say Tata. So I will adopt the entire document of entire details of those transactions only. The only thing is that I will change the value, name of the party, and the basic individual details will be changed, and rest all legal point will be the similar way. That's called agreement through reference. Even that is allowed. Then when the arbitration agreement will be terminated, when it will be cancelled. So this is, it can be terminated through mutual consent. For example, let's say arbitration agreement was for 3 years, but after a year parties became very friendly to each other and now they feel that there is no need of arbitration agreement, then they can cancel the arbitration agreement. Or it is by performance. Performance means you have executed the work. For example, there was an arbitration agreement for warranty and it was for 2 years. Now 2 years completed, you have served all your warranty period. Now it is, arbitration agreement will be terminated, but it is by performance. Or it can be even terminated by novation. Novation means you are cancelling this and you are bringing the new arbitration agreement. Even that is allowed. But if you are doing violation, then it will obviously not terminated. Then death of party. For death of party, there are two different things. See, ideally the legal heir will not be responsible, but if the party, if the legal heir is getting property etc., against that arbitration agreement losses can be enforced. It is like that. Then sometimes it is non-executable due to law. For example, can I say I have done the arbitration agreement to supply liquor, but now liquor is has been banned in that area. So in that case I will not able to do that activity. So it is called, it is terminated due to law. Then next point we are going to discuss is arbitral tribunal. Arbitral tribunal means judge, how he will be appointed. If first is joint appointment, means there are two party, party A and party B. If together they have appointed the arbitrator. For example, if party A has given some name Kishore and party B has accepted that name, that means it is it will be called as appointment appointed jointly. So this is one way you can appoint arbitrator. Or appointment by arbitrator. For example, party A has appointed Mr. Kishore and Amit and party B has appointed Mr. Kishan and Virat, and they four arbitrators together appointed one more arbitrator. So even that can be one way of appointing. Or you can say that this appointment will be by designatory. For example, we said that ICI president will be appoint the arbitrator. So whenever the dispute will arise, whoever will be ICI president at that time will request them to appoint our arbitrator. So these are different ways by which you can appoint arbitrator, which is also called as arbitral tribunal or arbitrator. Now requirement of an arbitral tribunal. Requirement of an arbitral tribunal. This is, arbitrator can be of any nationality, obviously. So he need to have a knowledge. It doesn't matter he belongs to which country. But here the problem is, can I say, if the dispute is between two countries, please understand, if the dispute is between whom? If the dispute is between two countries, then what will happen? So this says that in that case, arbitrator should be from an independent country. Independent country means what? If it is from India and China, then arbitrator should not be from either of the country in case of international arbitration. So this is a suggestion they are giving. then the person who is entering into who is become an arbitrator should able to enter into a contract as per Indian Contract Act. As per Indian Contract Act, unsound mind or lunatic person, they people cannot become arbitrator. So here also, can I say anyone who want to become arbitrator should not be lunatic or something like that. Then he shall be unbiased person. He shall be what? Tell me fast. He shall be unbiased person. Obviously by behavior, by his approach, because the whole idea is to give fair judgment. So you have to be unbiased. Then this is when arbitrator will cease. Number one, he can go voluntarily. For example, arbitrator now does not have a sufficient time to give judgment or to do hearing. So he want to leave, he can go voluntarily. There is no binding that he has to complete arbitration. Or if the party feels, this point we have already discussed. Then if the party feels that arbitrator is not doing the work fairly, even parties mutually can remove the arbitrator, even that is allowed. Then what they are saying that, see, maximum period is 12 months. Within 12 months, if arbitrator is not able to give the judgment, even in that situation, arbitrator after the expiry of 12 months has to vacate the office. Then let's say arbitrator is not well, so due to illness etc, you want to go out of the office, so even he can cease the office due to that reason also. Now what is arbitral award? The judgment which given by the judge is called judgment. Same way the judgment given by the arbitrator is called as arbitral award. Final award, what is final award? So let's say there are 4 disputes, dispute A, B, C, D, and if judgment is given on all the dispute A, B, C, D, then it will be called as final award. What is interim award? Now can I say judge, the arbitrator has given judgment on 3 dispute only, dispute A, B, C, but dispute D judgment is pending. So this is called interim award. This is called, tell me fast, interim award. What is additional award? Please tell me. So what happens, you know, judge has given you judgment on 3 dispute only. Dispute D is pending, but judge was of the opinion that all judgments have been given. So can I say he has stamped it like a final award, but subsequently the party has informed the judge that, see, 1 dispute is still pending. Now he will give judgment on that extra dispute. That's called additional award. What is settlement award? There were 4 disputes, everybody. Now judge was taking like lot of time. So what happened, you know, 4 judges together decided that they will come up with some outcome, and they went to judge, and the parties given agreed themselves what judgment should be. So the 4 disputes have been agreed by the party only, and the arbitrator is just stamping it. This is called settlement award. Now what if arbitrator gives some decision, can it be challenged? So yes, it can be challenged on some limited ground which will revise later on, but this is if you want to challenge the judgment of arbitrator, and if it is international commercial arbitration, then you will go to high court, and if it is domestic arbitration, then you will go to district court or high court having original jurisdiction. So this is like that. How to appoint new arbitrator? You have removed the old arbitrator, you want to appoint new arbitrator. Ideally you will try to appoint in the manner given as per provisions, as per parties have decided. But if that is not worked out and now you want to move to the court for appointment of new arbitrator, then if it is international arbitration, you can go to Supreme Court, and if it is domestic arbitration, you can go to High Court. Now what they are saying, there are some principles related to arbitral award. They are saying arbitral award is given by the, what is arbitral award? It is the decision, judgment given by the arbitrator. If the party is not satisfied, then on some limited ground they can file an appeal against the arbitrator, which we have already discussed. Within how much time they can file appeal? Within 3 months they can file appeal. And if they could not file appeal within 3 months due to some genuine reasons, then they can they will further get the period of 30 days as an extension to file the appeal. Then normally, can I say, if Mr. X has lost case, on behalf of Mr. X somebody else can appeal, but in case of arbitration, challenge can be filed only by the parties themselves. Means a outsider cannot file the appeal of the arbitration, only the parties involved can file the appeal. And normally what happens, when you go to appeal, there is a stay of the order, but here there is no automatic stay. So if some judgment has been given by the arbitrator, it will be executed. Now even if you want to go in appeal, you can go in appeal, there is no problem, but the thing is that there will be no automatic stay. There will be no what? Automatic stay. Then this is components required to be present in award. What should be there in arbitral award? Please understand, this is arbitral award should be given by the majority of the arbitrator. So let's say if there are three parties, party A, party B, party C, or party 1, 2, 3. So majority shall give whatever the majority will give, the judgment will be binding. So it will be like that. And then this is judgment should be in written form. Why it should be written form? Obviously because then only they will come to know that how the execution will be done. It shall be dated and signed. Why? Because there is a time limit within which the judgment shall be executed. So that is why the initial date shall be there in the judgment copies. So from that day, can I say, we will count the time limit within which the judgment shall be executed. Then this is whatever the reason is there behind the judgment, those judgments shall be complete in nature. The award cannot be vague. For example, if the court has said that Mr. X has to pay to Mr. Y, so every component shall be there in this, that how much money has to be given, within what time, within what period, in how many tranches, everything shall be there in the copy. It shall not be the vague order. Then this is that whatever the judgment the arbitrator gives now, it shall be capable of performing. Means, can I say, now you will say, okay, go and do XYZ activity, and now that is not feasible only. You know, in the dialogue we say na, tere liye chand tare tod ke launga. Now a person cannot break that na re. So it is not capable of performing. So you have to see that also. It shall not be unrealistic. It shall not be illegal in nature. For example, now liquor is banned in certain state, and you have done this agreement before, you know, entering into before ban, you have entered into some arbitration agreement. After liquor is banned, you cannot just, arbitrator cannot just say no, there was an agreement, you have to supply. No, because it is illegal now, and the copy shall be delivered, whatever the judgment will come, that copies of the judgment shall be delivered to all the parties. Now, can you challenge the arbitration? Yes, on certain limited grounds, arbitral award can be challenged. So first of all, this is if it is biased, the judgment is biased, then it can be challenged. Overstepping of jurisdiction means arbitrator has given judgment for the dispute which is not brought to him. For example, dispute was brought for dispute ABC, but he has given judgment for D. So that is overstepping. Then same thing, decision on those dispute he has given which is not served to him. Then the party under arbitration is not capable, then also the arbitrator cannot give the judgment. For example, party A was minor or unsound mind, and arbitrator has given the judgment. Now ideally the party who was under arbitration was not capable of contracting only, so it shall be void ab initio only. So here the arbitrator is giving judgment, but if some party is under some incapacity, in that case the judgment cannot be executed. Or if the arbitration agreement is invalid, there are certain situations when you cannot do the arbitration. For example, if the matter is related to matrimonial issues, or if related to some lease related issues are there, these are not arbitrable. These issues need not be should not be under arbitration. Or criminal offences are not supposed to be, for example, murder etc., cannot be done under arbitration. So can you see, the party is under some arbitration, so this is that in that case it will become invalid only. It will not be allowed at all. Then this is that proper notice need to be served to the parties. Unilateral communication is not allowed. For example, there are two parties now. So party A and party B is there. So unilateral communication is not allowed. If I am doing the discussion, then I need to discuss with both the parties simultaneously. And if I am not communicating with one party and later on that party come to know, so even he can challenge on those grounds also. So it is like they need to follow proper policy, and any arbitration judgment you give shall not be against public policy of India. So it shall not damage any public policy of India, your judgment. So what if you challenge the arbitral award? Now what will happen? So this is consequences of challenges. What will be consequences of challenges? Number one, they can set aside the order copy. Number one. So can I say whatever the arbitrator has given the judgment, the arbitral authority will just cancel the judgment, or they will continue the judgment of arbitrator, means they will confirm or remit back to the arbitrator. Means what? Whatever arbitrator has given the judgment, we will tell to the arbitrator only that you please rethink over it, or they may make some changes in it, modify. Now, what is conciliation? It is a friendly settlement. Arbitrator is slightly strict, but when there is a friendly settlement, it is called what? Conciliation. So where decision given by the condition only after both parties have accepted the decision, that's called conciliation. There are certain characteristics of conciliation. What are the characteristics? It is a voluntary act, means you cannot force any party to enter into conciliation. They mutually come to conciliation. Not only that, the judgment also friendly only, means till the period parties don't accept the judgment, those judgments will not be binding on the parties. Then this is that here whenever you go in conciliation, the whole idea is not that one party is right, one party is wrong. Here, as I told you, it is a friendly settlement. Both parties should be in a win-win situation. One party should not be loser and other shall not be like a winner or something like that. Then, so the duty of conciliator is like a guardian. They will try to come up with a solution which is suitable to both the parties. But again, the judgment, once parties have agreed to it, then it is final and binding. Now parties cannot say no, it was friendly only. No, once both parties agree to certain judgment, now it will be binding. And obviously you have to maintain confidentiality, means whatever the judgment has given or whatever the discussion has been done in conciliation need to be kept confidential. Next is conciliation in India. This is how many conciliators can be there in India. So it can be anything between 1 to 3. Like that. Then this is conciliator will be appointed by the parties either directly, or if some other person designator is requesting them to appoint conciliator, conciliator can be appointed then also. Then what they are saying, that parties in conciliation shall follow the normal procedure, means whatever the mutually decided procedure is there, they have to follow that. And then this is a dispute brought in conciliation shall not be parallelly brought in arbitration or court. Means what can I say, there is a dispute in conciliation and now parallelly you are running those disputes under court also or under arbitration also. So that is wrong. This is if you want to redress any dispute through conciliation, it has to be done there only. Now you cannot parallelly run it, like you cannot parallelly resolve the dispute in court, or you cannot resolve it in through arbitration. It cannot be done simultaneously. So that's all in this chapter. We have covered almost all important provisions of this chapter, and now we will be moving on to the next chapter. Okay, now we are starting with a new chapter, Security Exchange Board of India, that is SEBI Act. What is the logic behind bringing this chapter or bringing this authority, SEBI? So before 1992, all the intermediaries, for example, broker, sub-broker, share transfer agent, depository, merchant banker, foreign institutional investor, stock exchange, AIF, all they used to be controlled by CG. So to offload their burden to regulate intermediary, they have formed SEBI. It is applicable to whole of India. Now, what is the objective behind bringing this law? So this is, first objective is to develop security market. Now how the security market will be developed? Only when the investor will invest it, and when the investor will invest into security market, when their rights will be protected. So second objective is to protect the interest of investor. And how you can protect the interest of investor? By controlling the intermediary, because they deal with investor, so they shall not fraud the investor. So to register and regulate intermediary and anything ancillary or incidental that are connected with that. These are the objective of this thing, SEBI. Then who will be there in SEBI? See, SEBI is an artificial body. So who will be there in SEBI? So first of all, there will be a chairman, then representative of Ministry of Finance and Ministry of Corporate Affairs. So one chairman, then Ministry of Finance 1 and Ministry of Corporate Affairs 1. So total there will be 2 person, 1 plus 1 plus 1, till now 3. Then representative of RBI, that is 1. And 5 members, out of which 3 shall be whole time. So 2 can be part time, but at least 3 shall be whole time member, full time job. Now, so in total there will be 9 members. Na? 1 member plus 2, 3 member, 4 member and plus 5, 9 members. Now, what they are saying, please understand, all the members will be appointed by whom? All the members will be appointed by the central government only, except representative of RBI. Representative of RBI will not be appointed by central government, will be appointed by RBI only. So it is like that. Now, can they be removed? So yes, if the members of SEBI been declared as insolvent, then that member can be removed. Or if he has been declared as unsound mind, obviously, then he will be removed. Or if he is convicted as moral turpitude, see, trial is not there. So if he has been declared by the court as a conviction in the moral turpitude, then also he will be removed. Or if he has abused his position, means he is doing some activity by which he is taking defame to his post. For example, he is taking bribery, etc. So in that case also he can be removed from the office. But whenever you will remove that person, member of SEBI, before removing that member of SEBI, you have to give opportunity of being heard to the member of the SEBI. Now, apart from these 4 grounds, if the member of SEBI is removed on some other grounds, then in that case, if you are removing them from some other than these 4 grounds, then they can be removed only, can I say, after giving 3 months notice. So without that you cannot remove them, or you don't want to give that person 3 months notice, then you have to give at least 3 months salary and allowance. So for these 4 grounds you can be straight away removed. For other grounds you can be removed, but then the SEBI has to give them notice of at least 3 months or at least 3 months salary and allowance. Can the person resign themselves? Yes. In that case, the resignation will be effective from which date? So 3 months notice need to be given in written form to central government, and it will be effective from the date it is received by the central government. Within 3 months from the date it is received by the central government. So let's say member has sent notice to CG and CG has received on 1/7/24. So it will be effective within 3 months, that is by 1/10/24 it will be effective. I hope it is clear. Now tenure. What will be the tenure of members of SEBI? So tenure, they are saying, for a chairman and whole time member, maximum period is 5 years. Can he be reappointed? Answer is yes. He can be reappointed for any number of time. There is no restriction, but till the maximum age he attains 65 years. As far as part-time member is concerned, at one point of time he can be appointed for 5 years, reappointed for any number of time, but obviously he is a part-time member. He is not going to go office every day. So there is no maximum age limit. He can continue till whatever age. But chairman whole-time member, maximum 65 only. Part-time tenure you will not find in module. For knowledge purpose I have shared it, but this you will find in module. Now, what are the general functions of SEBI? So first of all, can I say his functions will be more like a preamble only. See, intermediary is there. So to control the intermediary, you have to register them. So registering and regulating, both activity of intermediary will be done by whom? Will be done by SEBI. Then we have to control the market. You have to stop the insider trading. What is insider trading? If you are dealing in stocks, securities, on any information which is not yet in the public forum, which is not yet in public knowledge, and you are dealing in that, and by which after doing those transactions, either you are saving the losses or you are creating undue profit, that will be called as insider trading. Market manipulation, like Harshad Mehta and all, they have done some fraud, etc. So these are things which SEBI will try to stop. So it is prohibition of insider trading. Then regulating substantial acquisition of shares. One company is acquiring substantial, very huge number of shares of some other company, or they are doing takeover of some other company. So it is allowed, but they will regulate it. They will control it in a proper systematic manner. They will allow them to do this. Or if they need to call for some information, they can call for information also. They can ask for inspection also, and all these things. Then section 11 says general power of SEBI. What are the general power SEBI need to exercise or SEBI can do? So this is suspend recognized stock exchange. They can suspend recognized stock exchange. Now what does it mean? See, there is one stock exchange is there. Now their activity they will suspend. In what way? Like if some fraud allegation is there, so for investigation they can say to stock exchange that for so and so months, for so and so period, you cannot do any business activity. Then for example, Harshad Mehta was there, Ketan Parekh was there, so they can restrain any person to access stock market if there is some allegation of insider trading or such kind of activities levied on that person. Then some officers of stock market is involved in some market manipulation, so they can suspend that office bearer of that stock exchange. If some person is engaged in some insider trading, and if it is believed to be those insider trading profits in certain bank account, and that bank account can be freezed for 90 days, or if some person there is a belief that some person has certain security which is out of insider trading, so can I say there can be some directions given to intermediary stockbroker not to transfer those securities which is obtained after doing insider trading. Or if some money is in cash or something like that, which is believed to be generated from insider trading, then they can impound, they can confiscate those sales proceeds. For that, civil court power has been given to the SEBI. Section 11A, regulation for issue of prospectus, offer document, or any document through which money solicited from the public. So if company is coming up with a public issue, and for that they are raising offer document. So what content will be there in offer document, how the offer document should be, all these guidelines SEBI can issue. So without prejudice to Companies Act, means whatever given in Companies Act you have to follow that also, and SEBI can issue regulations related to issue of prospectus, offer document, or they can give some general specific order which is applicable to a class of company or to all companies, or they can give directions for this. This is already, there is already SEBI ICDR regulations which is already been issued. And then there is a direction SEBI can issue related to listing or transfer of securities. SEBI LODR is there. So SEBI LODR is nothing but the direction given for listing or transfer of securities. So even that can be offered. So SEBI LODR is the regulation which is issued by SEBI which controls the listing or transfer of securities. Then if SEBI want to give any particular directions, they can give. But they can give directions for what? So SEBI may issue directions to protect the interest of investor, obviously. See, any direction SEBI will issue, the whole objective of that direction will be what? So the whole objective of direction will be to obtain the whole objective of the directions is to obtain the preamble, to achieve the preamble of this act. So they will give directions to protect the interest of investor, and for that, and what is the reason to protect the interest of investor? So that they can develop the security market, and for that how they can do this? By doing the proper management of intermediary. So can I say SEBI will give directions for what purpose? So SEBI will give directions to protect the interest of investor, and for that why they want to protect the interest of investor? So that they can develop the security market, and they can do it by proper management of intermediaries. Next is investigation. What are the grounds of investigation? See, there are two grounds of investigation. Number one, if there is a violation of this act, that is SEBI Act or Security Contract Regulation Act. Number two, if any transaction is done by someone which is harmful to the interest of investor, even on those grounds investigation can be ordered. If an investigation will be ordered, what will be the power of investigating authority? They have the power to inspect the books of accounts. So obviously the duties of employee officers whose investigation has been ordered will be what? To produce the books of accounts. Then the investigating authority can sought explanation if they don't understand anything in books of accounts. So it is the duty of employee officer to provide the explanation. They can summon also. Summon means asking someone to appear personally. So it will be duty to appear personally. To take, they can take things on note and they can take on oath, which can be used subsequently as evidence. So it is their duty to sign the note. So it is like that. What are the power exercisable with the prior approval of magistrate? So there are three powers which are exercisable with the prior approval of magistrate. Which power? So three powers are enter, search, seize. Can I say? Normally, whatever power we have studied for investigating authority, they can do straight away, and for that they don't have to take anyone's approval or something like that. But three powers, that is enter, search, seize, these three powers this investigating authority can do only after taking so these powers, as I told you, to exercise this power they don't have to take anyone's approval, but to exercise the three power enter, search, seize, they need prior approval of magistrate. Enter with such assistance as may be required, means you want to take police along with you for protection, so you need to take magistrate prior approval, or you want to search certain place, for example house of MD, or you want to seize the books of accounts, then you have to take magistrate approval. When you can seize the books of accounts? When you are of the opinion that books can be DMAFS, destroyed, mutilated, altered, falsified or secreted, then you can seize the books of accounts. Now the question is, can I say if the company is a listed company, or if the company is coming up with the listing, then you can seize the books of accounts only and only when the offence is related to insider trading, or if the offence is related to market manipulation. And whenever your investigation get completed, conclusion, then maximum till that period you can retain the books, means till conclusion of investigation you can return the books, latest by that you shall return the book. So it is like that. So for listed or company, listed company or company which is coming up with the listing, they are not directly intermediary, hence their books of accounts can be seized only on two grounds: insider trading and market manipulation. Seize and desist order. Seize means stop and don't repeat, and Desist means it is given in advance. So when you are doing certain activity or some wrongful activity is already been conducted, then cease order will be passed. And desist order, when some activity is about to happen, then they can pass desist order. So cease and desist order also SEBI can pass. But if you are a listed company or company coming up with a listing, in that case cease and desist order can be passed only when the offence is related to insider trading or market manipulation. Now when you will see punishment, always there is a minimum or maximum punishment is written in the law. So when you see minimum and maximum punishment, how the judges will decide how much exact punishment should be. Like minimum is 1 lakh, maximum is 10 crore. For example, I am talking. So what amount will be levied between 1 lakh to 10 crore? How the judges will be deciding that? So this is, they will consider 3 factors. Number 1, the inappropriate gain to the defaulter. What is the benefit or wrongful benefit a defaulter is getting? What is the loss investor is suffering because of that? And repetitive nature of offence, means are you a regular offender, are you coming up with this offence again and again? So if these all 3 factors are against you, then they will charge you maximum possible fine. But if assume there is no much gain you are getting, there is no much loss to the investor, this is a first time offence, then minimum possible fine can be levied. So judges will consider these 3 factors while deciding the punishment. Now what are the punishments which we have to study now? First is, if you don't maintain the proper books of account or you don't file the return. So if you fail to maintain proper books of account, you fail to file the return, you fail to furnish information, what will be punishment? So first of all, for 15A, 15B, 15C, 15D and 15E, same punishment is there. What is the punishment? Rupees 1 lakh per day or 1 crore, whichever is lower. So if 50 days default is there, it will be 50 lakhs. If 200 days default is there, so 2 crore, 1 crore lower, lower will be 1 crore. If 2 days default is there, then it will be 2 lakh. So it will be like that, 1 lakh per day or 1 crore, whichever is lower. And it is for 15A, 15B, 15C, 15D, 15E. So same punishment for these 5 sections. So now let us understand what are the offences given in these 5 sections. So under 15A, they are saying you have not maintained proper books of accounts, you have not filed the return, you have not given the proper information. Under 15B, they are saying that there are certain agreements, you are supposed to enter with the client, and without that agreement you have entered into the transaction. Then also, for example, there is a contract of principal in agent, not principal between client and the broker. But if you have done some transaction as a principal without written agreement, then in that case also you will be punished under 15B. Then there is a failure to redress the grievance. There is some grievances of the investor, and that investor went to SEBI. SEBI has given you some time to solve that grievances, and you would not able to solve that within that time, then you will be punished under 15C. 15D, if some default is done by mutual fund or collective investment scheme, then they will be penalized as per 1 lakh per day or 1 crore, whichever is lower. What default? Like they have not registered, failure to register means mutual fund has to register under Indian Trust Act, they have not registered it. Then whenever somebody purchase the unit, they have to give the certificate, they have not given that certificate. Then there is a equity oriented fund, debt oriented fund, and you have not invested according to that, those funds, those schemes which you were supposed to do, then, or any other defaults of the mutual fund, like that. Then failure by asset management company. What is the main duty of the asset management company? See, basically whatever money collected by mutual fund is invested by AMC. So if AMC do any default, then they will be punished under 15E. 15AF is for stock brokers failure. We'll be going to that point. Now listen, stockbroker, whenever they transfer any securities or acquire any securities, they have to give contract note, and if they fail to give contract note, there will be a punishment of minimum 1 lakh, maximum 1 crore. Then whenever they purchase any security, it has to be delivered from the broker's pool account to client's demat account within 48 hours, and if they fail to deliver that security, or if they have sold the security, they have to make payment within 48 hours, and if they have failed to make the payment within 48 hours, in that case the punishment will be 1 lakh per day, and which can go up to rupees 1 crore, whichever is lower. There is a percentage of brokerage, and you have charged more than that, then in that case this is 1 lakh or 5 times of excess brokerage, whichever is higher. So if the excess brokerage is 100 rupees, 5 times will be 500, or 1 lakh higher will be 1 lakh. It is like that. Now, what is the penalty for insider trading? So this is minimum 10 lakhs, maximum 25 crore, or 3 times of profit made, whichever is higher. So if the profit made is 10 crore, 3 times will be 30 crore, or 25 crore, higher is 30 crore. So maximum it can go up to that. Minimum how much? 10 lakhs. If there is a if you have acquired these shares, there is a takeover regulation, SAST regulation is there, and you have not complied with those regulations. So you are taking the substantial shares of the other entity, other company, and then you are not complying with the provisions of SAST regulation. Then you will be punished under 15H, minimum 10 lakhs, maximum which can go up to 25 crore or 3 times of profit made, whichever is higher. Or you are doing unfair trade practices, some wrongful activity you are doing. So minimum 5 lakhs, maximum 25 crore, 3 times of profit made, whichever is higher. Next is procedure for adjudication. How the adjudication will be done? So this is SEBI shall appoint officer. First of all, who will do the adjudication? So SEBI will appoint the officer whose rank shall not be less than division chief as an adjudicating authority, and that officer shall give reasonable opportunity before giving any judgment. Then that authority has a civil court power, and after the punishment, if SEBI feels that the penalty is less and they want to increase it, so SEBI can even increase those penalties. How the penalty will be recovered? So if you don't pay penalty within the prescribed time, then this is that first of all, if you have an immovable property, it will be attached. Movable property will also be attached. Bank account will be freezed. They will appoint a receiver who will going to sell the assets, and that recovery officer will pass the order in writing. After all these activities, if you are creating resistance to recover the assets or something like that, then in that case even police help can be taken to recover the asset. Composition of offence, that is compounding. We have studied this multiple times. Wherever in the law it is written imprisonment only or fine and imprisonment, so these two offences cannot be compounded. Which offences can be compounded? Fine only, fine or imprisonment, fine or imprisonment, or both. Only these offences can be compounded. Appeal to SAT. Any order given by SEBI or adjudicating authority or IRDA can be filed. Against this order, you can file appeal to SAT, Security Appellate Tribunal, within 45 days. And if on genuine reason you could not file appeal within 45 days, then you will get the extension whatever decided by SAT. SAT has to dispose the decision within 6 months, as it is economic offences. The judgment should be very quick, and the judgment whatever given by the SAT against which you can file the appeal to Supreme Court within 60 days, further extension of 60 days can be given. Then this is who will be there in SAT. In SAT there will be 3 types of officer: presiding officer, like president; judicial member who will come from a legal background; technical member who will come from administrative background. Normally in all disputes, one judicial member and one technical member will be the part of bench. And where will be the principal bench of this SAT? So it is an economic crime. So where is the economic capital of this country? Mumbai. So it will be, principal bench will be in Mumbai. What will be the qualification of presiding officer, judicial member, technical member? So presiding officer shall be Supreme Court judge. The tenure can be, even if he is a Supreme Court judge for a day, either a present judge or a past judge, it is allowed. Or he can be, if he is a High Court judge, then he shall be the High Court Chief Justice, or if he is a High Court Chief Justice, then it can be even a single day experience is sufficient. Or if he is just a normal judge of a High Court, then he shall have an experience of at least 7 years. To become judicial member, he shall be High Court judge of at least, which is having an experience of at least 5 years. And you want to become technical member, then he shall be secretary or additional secretary in ministries. So they are normally a UPSC qualified people, senior IAS officers. Or you shall have ability, standing, integrity in some financial sector, security market, insurance, commodity market, and you shall have experience of at least 15 years. Then this is a qualification to become presiding officer, judicial member, technical member. But how they will be going to get appointed? So first of all, they are saying central government, on consultation with Chief Justice of India or the nominee of Chief Justice of India, will appoint presiding officer, judicial member, technical member. But out of that, 2 most important, presiding officer and judicial member will be appointed by CG on consultation with Chief Justice of India. So they will do face-to-face discussion, and then they will appoint these 2 officers. And technical member will be appointed by CG only, but on recommendation of Search Cum Selection Committee. When Search Cum Selection Committee will give some list of name, and from which CG will appoint technical member. Now who all will be sitting in the Search Cum Selection Committee? So this is the presiding officer will be chairperson of the Search Cum Selection Committee, and IAS officers, that is UPSC qualified person, IAS officers, they become secretary, and secretary of Ministry of Economic Affairs Ministry of Finance and Ministry of Legal Affairs or Legislative Affairs will be the member of search cum selection committee. So this is how they will appoint. Then this is what if there is some defect in the decision given by the SAT or some bench of the SAT. So this is once decision given, it will not going to invalidate the decision which is already given by SAT. So even if there is some defect, it will not going to invalidate the judgment. Then this is conditions for appointment. What are the conditions for appointment? So this is that any person who is at a senior position of IRDA, Pension Authority or SEBI in last 2 years shall not become the member of SAT. Why? Because usually what happens, a person who are the senior position at IRDA, Pension Authority, SEBI become member of SAT. And if you will file orders of SEBI to SAT, and if the same person happen to be the member of SAT also, then it might create a problem. So this is that if you are in a senior position of IRDA or at a senior position of Pension Authority or SAT or SEBI, sorry, in last 2 years, then you shall not become the member of SAT. What will be the tenure? So this is maximum 5 years. One can be appointed and they can again be reappointed for another 5 years. But after that you cannot be appointed. So for SEBI you can be reappointed for any number of time. But for SAT you can be reappointed for only maximum. Means your tenure can be only for maximum 5 years tenure. So you can get appointed for maximum 10 years. And maximum you can continue till the attainment of 70 years. So once you have completed 69 and you have attained the 70, even if your 5 years is not completed, you have to vacate the office. Then this is salary shall not be vary to the disadvantage of their appointment. Now it is possible that you are a director or at some other position of the court, like you are a High Court judge. Now you got appointed as a judicial member. So the salary which you are getting as a High Court judge, now as a judicial member your salary shall not be less than the earlier salary. So it is like that. What if there is a temporary vacancy? Fine, but permanent vacancy need to be filled. For judicial member, technical member, it is mandatory to fill. Obviously for presiding member also it is mandatory to fill. But till the period you don't appoint the presiding member, the senior most member of the bench will act like a presiding officer. Resignation. This is from which date the resignation will be effective. So this is, it will be effective from 3 months from the date of receipt of notice by central government, successor appointed or tenure completed. So can I say, if you have given notice to the central government, 3 months is not elapsed from the date of notice received by the CG, but the successor has been appointed by CG, then you will be relieved. Or your tenure itself got completed of 5 years, then also you will be relieved. But neither successor appointed nor tenure completed, but from the date CG has received the notice 3 months elapsed, then in that situation your office will be deemed to over. I hope it is clear. Grounds for removal by CG. On which grounds central government can remove the officers? So if offset, if he has been declared as insolvent, or if he is a physically or mentally incapacitated, or the SAT member is convicted of moral turpitude, or they have brought some abuse to their position, bribery and all they are taking, or they have developed so much of financial interest in some entity that now it is for him, it is very difficult to act independently. Even in that case he can be removed. But before that they will give them opportunity of being heard. What are the power of SAT? The normal civil court power, they can summon someone, means they can ask someone to come appear in person, or they can ask to bring books of account, they can ask for evidences, they can cross-examine the witnesses, and if they have given some decision they can review their own decision also. If some party is not appearing even after issuing notice, then they can declare those party as ex parte. And any matter which is under appeal, can I say, such matter shall not be brought to the civil court. Then this is, can central government supersede SEBI? Can they take SEBI in their own control? So this is, if there is a grave emergency, like some very, like Harshad Mehta type financial fraud has happened, वैसे time पे. So in that situation also, can I say CG can supersede SEBI? Or if the SEBI is not complying with the direction of the CG, or if the SEBI is not complying what is given in the law, or it is beneficial if CG will supersede SEBI, it is beneficial to the public. So in these 4 situations, CG can supersede SEBI. Next, collective investment scheme we know. Power to grant immunity. And now central government want to waive someone's penalty. So can they do it? Can they give the immunity? So this is, first of all, for this SEBI has to give recommendations to central government that any person who has violated any provision. Normally this happens when some person gives some very vital information to CG. So what happens, or to SEBI. So SEBI give recommendation to CG, and for that your prosecution should not be started. See, now SEBI has given recommendation to CG, but now it is the wish of CG whether they want to give immunity or not. So now the recommendation is not binding on CG that okay, SEBI has given the recommendation, now CG has to give the immunity. It is the wish of CG whether they want to give immunity or not. So these offences we have already discussed earlier. This is the new punishment. If you are an alternative investment scheme or retail investment trust, so they are saying for these people the punishment is 10,000 per day, which can go up to 1 crore or 3 times of profit made, whichever is higher. If you are an investment advisor or research analyst, the people release research paper on the basis of which you can invest in market, and investment advisor will give you directly advice, and according to those advice you can make the investment. So if they are doing anything wrong, minimum 1 lakh, which can go up to, that is 1 lakh per day or 1 crore, whichever is lower, that can be the maximum punishment can be levied. For stockbroker we have already discussed. If you are doing anything hacking activity of SEBI, after that you destroy any information of SEBI's database or you alter any details of the SEBI's database, in that case the punishment will be minimum 1 lakh, which can go maximum to 10 crore, 3 times of profit made, whichever is higher. So beta, that's all in SEBI Act. Now we will be moving on to the next chapter. So now we are going to discuss Security Exchange Board of India listing obligation and disclosure requirement, that is SEBI LODR. Now SEBI listing obligation means what? You have to do lot of compliances, and disclosure requirement means you have to do disclosure. But whenever you hear the thing disclosure, immediately what should strike in your mind? That it will be disclosure to whom? So in most of cases here the disclosure is done to stock exchange. This chapter is applicable for the listed company or any company which is coming up for the listing. So for a listed company, can I say, they says that you have to do the corporate governance. Corporate governance talks about FAT, that is fairness, accountability and transparency. And whenever you discuss about transparency, I can say the most important thing for transparency is disclosure. And now there are two types of disclosure. Number one, there is a periodic disclosure, and number two, there is a event based disclosure. What is event based disclosure? When you do disclosure on happening of certain event, that is event based disclosure. What is periodic disclosure? So first of all, there is a one time disclosure, you have to do only once. Then quarterly disclosure means you have to do after every quarter. Half yearly disclosure is after every half year, and yearly means once in a year. Now please understand, what is the purpose of bringing SEBI LODR? So first of all, can I say, as I told you, it is applicable to listed company, but for listed company even Companies Act is applicable. So they wanted that Companies Act and LODR's provision shall go hand in hand. So this is one purpose. Number two, a lot of informations are there with company not available with not there in public domain, and because of that there is to be an insider trading situation. So in order to eliminate the insider trading, they want as soon as price sensitive information is available to the company, they shall disclose it to stock exchange so that it will be in public domain. So because of that also they brought SEBI LODR. Now anything which is for a listed company, you have to follow Companies Act also and SEBI law also. And if there is a difference, in that case, as I told you, what is more strict, that you have to follow. But if that is against each other, then in that case LODR will prevail. Now what listed company has to disclose to the stock exchange? So there is a listing agreement between a company and the stock exchange, and that listing agreement will be based on SEBI LODR. So whatever is given in SEBI LODR, that has to be there in the listing agreement between listed company and stock exchange, and those information a listed company has to disclose it to stock exchange. So it has to be followed to all types of listed companies. Then they says to which type of securities when you issue, you have to comply with the SEBI LODR provision. So this says that, see, whether you issue non-convertible debenture or non-convertible redeemable preferences or IDR or security debt instrument or security receipts or mutual fund units, whatever you have issued, you have to comply with the provisions of SEBI LODR. Then this is, there are several obligations. There are some common obligations which has to be complied irrespective of any type of securities you issue, and there are some special obligations which is applicable only for selected securities. Now, what are the common obligation to every type of listed company has to comply with? This is every type of listed company, for every security they issue, they have to appoint at least one compliance officer who is by qualification company secretary, and they have to appoint one share transfer agent, or they have to manage it in-house. So that is the thing. Not only that, they have to cooperate with intermediaries, they have to coordinate with them regularly, they have to preserve the document, they have to file the document, whatever given in the law, they have to redress the grievances of the investors, and if there is any amalgamation or anything, they have to follow what is told by SEBI. So it is like that. And now there are certain compliances they have to follow. What are the quarterly compliances? So this is every listed company has to file a quarterly compliance report in which they will say whether all laws have been complied or not, and that has to be filed within 21 days. Earlier it used to be 15 days, now it is 21 days. So they have to file this report and they have to say that, boss, we have complied these many laws, or these laws have not been complied. After every quarter end, that is April, May, June, quarter got end. So from June, next 21 days, that means by 21st July they have to file, then July, August, September, so 21st October they have to file, October, November, December, so 21st Jan, Feb, March, so 21st April, like that they have to file after every quarter. Grievance redressal reports, that is how many grievances are there in the beginning of quarter, how many grievances reported during the quarter, and how many redressed and how many left in the end of the quarter, has to be given in grievance redressal report after every quarter within 21 days. Then corporate governance report has to be filed within 15 days after every quarter, that is by 15th July, 15th October, 15th January, 15th April, like that. Shareholding pattern, how many divisible right shares, DVR, differential voting right shares are there, how many ordinary shares are there, how much preference shares, these shareholding pattern need to be given after every quarter within 21 days. If there is any standard in deviation or variation, so if there is any deviation or variation, that has to be reported quarterly, but here they have not specified within how many days, so I have written X over there. Then quarterly financial statement you have to file, and year to date financial statement also. What is quarterly financial statement? So let's say your first quarter is April to June, so quarterly and year to date will be same. Second quarter is July to October, so quarterly will be July to October, and April to October will be year to date. So both you have to file, except last quarter. For all three quarters you have to file within 45 days of the quarter end. So it is April, May, June, so you have to file it by 15th August is the holiday, so maybe 14th August or like that. Then July, August, September, so you have to file this by 15th November, like that you have to file. October, November, December, so by 15th Feb you have to file. So within 45 days you have to file your quarterly financial statement and year to date financial statement. So these are quarterly compliances. What is yearly compliances, everybody? You have to pay listing fees, annual listing fees within 30 days, obviously after year end. So by 30th April you have to pay. Then standalone financial statement, that is there are two types of financial statement. One is consolidated financial statement, one is standalone financial statement. Consolidated means you take subsidiaries profit also, and standalone means without subsidiary profit. So standalone financial statement you have to file after year end within 60 days, that is by 30th May you have to file. Then this is annual report need to be dispatched. How? So there are three things you have to understand. Before AGM you have to send annual report to shareholders, and before AGM you have to send annual report to shareholders. You have to send it to stock exchange also, and if there is any changes, then after AGM also you have to file. So before AGM, at least 21 days before you will give it to shareholder. So if AGM is on X day, so before X days, 21 days before X day, you have to give it to shareholder, and before you give it to shareholder you have to give it to stock exchange also. So these are two requirements, and if there is any changes in the annual report, within 48 hours you have to file it to the, again you have to file it to stock exchange. So like that there will be 3 times this annual report will be given. Then composition of board of directors. See, this is, if your chairman is the executive director, at least 50% shall be non-executive director in your company. But if your chairman is non-executive director, that means chairman is the independent person. In that case, at least 1/3 shall be the independent director. So please understand one thing. See, what is non-executive director? They are like a visiting director in the company. They go sometime like on a need basis. So if Reliance Industries Limited is there, and let's say Mr. A is the non-executive director. And if Mr. A is the chairman, then this is out of total director, let's say 9 directors are there. So out of total director, at least 1/3 shall be independent, at least 3 directors. But let's say Mr. B is the executive director and he is the chairman, then at least 50%. So 9 ka 50% is 4.5. So it cannot be 4.5. So it is 5 director need to be independent director. Now this is, your chairman is not regularly non-executive director, means during the years, due to in some period executive director was the chairman and in some period non-executive director was the chairman. So we need more independent director. So we need at least 50% independent director. Then this too is not that important. Then this is, if you want to appoint a non-executive director and his age is 75 years or more. Sir, he is very old, but he is non-executive, means he will come sometime in the office just to see everything is okay or not. You can appoint, but you have to pass special resolution, and before passing that you have to give explanatory note in the notice to which you are calling the meeting. So in that you have to write explanatory note also in the notice. So it is like that. Now please understand, there are different types of committees. First is audit committee. Under audit committee, minimum 3 members will be there, and out of those 3 members, at least 2/3 shall be independent director. Are you understanding? Companies Act required majority, but here it is 2/3. So let's say if 5 directors are there, 5 directors. So out of these 5 directors, minimum 3 satisfied na? So out of this 5, at least 2/3 of 5 directors, how much it is coming out to be? It is coming out to be 3.3. So it cannot be 3.3, so it will be 4. So 4 director will be the independent director. And this is, out of this, all 5 directors shall be financially literate, means they shall be from the commerce background, and 1 shall be financial expert, means all shall be from commerce background, but 1 shall be a person who has given all his life for financial matter only, means he is expert in the financial matter. So it is like that. And then this is this, there are 4 directors. So chairperson has to be independent director. So 4 are independent director, 1 is non-independent director. So chairman has to be from this 4 only. It cannot be from this one. I hope it is clear. Then next is, how much quorum will be there? It's like a Companies Act only. There will be 4 meetings should be there for the audit committee in a year, and the gap between 2 meetings shall not be more than 120 days. So it is same what we have studied in Companies Act. And this is the number of meetings. And now what will be the quorum? So this is whatever the total 1/3 of total independent So let's say 5 directors are there in the audit committee. So this is 1/3 of that. So what will be 1/3? So 1/3 of 5 is how much? Again 3.33. So it will be 4 director or 2 director, whichever is higher. And this will be the quorum. So quorum is 1/3 of total number of directors in the audit committee or 2 directors, whichever is higher. But in any situation in the quorum, at least 2 independent directors should be sitting. So it is like that. These are very much similar what we have studied in Companies Act. Now nomination and remuneration committee. What is the duty of nomination remuneration committee? So they decide how much remuneration should be given to the directors. So this is, in the nomination and remuneration committee, at least 3 members should be there, and all members shall be non-executive director. And now there is an amendment. So this is, if 5 directors are there, minimum 3 criteria satisfied. So out of this 5, all 5 directors shall be non-executive director, and out of this 5 only, at least 2/3 should be what? At least 2/3 shall be independent director. So all 5 will be non-executive director, and out of this 5 director, at least 2/3 shall be independent director. And the chairperson has to be come from that 2/3 only, means from the independent director criteria only. What will be quorum? This 2/3 is amendment. Earlier it was 50%. What is the criteria of the quorum? So this is 1/3 of total directors in the NRC committee or 2 directors, whichever is higher, out of which at least 1 shall be independent director. Now how many meetings shall be there? For audit committee there is the requirement of 4 meetings. But this is what? This is NRC. So for NRC 1 is sufficient, because they have to just decide salary, etc. So it will be once in a year. Stakeholder relationship committee. What is the duty of stakeholder relationship committee? First of all, they look after shareholders, debentures and other security holders' rights protected or not. And there will be at least 3 members will be there. This is, chairperson has to come from a non-executive director category. Here the member can be executive and non-executive, both. But the chairperson should come from the non-executive category. And out of these 3 members, at least 1 shall be independent director. Fine. And again they will meet at least once in a year. For risk management, in amendment lecture only I have covered everything. So that's all in LODR.